GA8 in the non-commercial division of your order passed by your lordship, by which I'm mentioning on notice, by which your lordship was pleased to direct the Kolkata Municipal Corporation and the firefighting department to survey the building and advise necessary corrections. Now, we are unaware whether there has been, it's mentioning list. We are unaware, whether there has been any report forthcoming as your lordship had directed. And secondly, that is the reason why this is my mentioning notice. I'm mentioning on notice. So lordship's order, but due to change of determination, this matter, had to be, your lordship released the matter. However, it was parted, but the other side never agreed for your lordship to take up the matter. But now we have come up with a modification application, so that, we are aware of what is happening in pursuance of your lordship's order. If your lordship, any day, we have filed the application.
No,
any day, if it can be listed.
Which GA?
It is GA8 of 2025.
New one.
New.
For modification of my order.
For modification of your lordship's order, because we are not aware about the contents of the report. Report has not been served on us.
Correct.
We are also not aware.
What the modification required?
The prayer which I have made in the application is that direction be passed on the authority to serve a copy of the report on me. Since it was in pursuance of
submit the report before the court.
That is all what I want to know, This is the shortest breadth of my application. Any day which is commensurate to your lordship. I'm deeply obliged,
I'm the plaintiff in this.
Yes.
My lord, I appear for the defendant.
Who has preferred an SLP before the transfer petition before the Supreme Court?
The plaintiffs, my lord.
You. Yes. So now
That is dismissed.
now this court has to dispose of your suit.
Yes, Lord.
My lord.
So what is the stage of the suit?
Lordship, on the last occasion, before your lordship had made the matter go out of the list, it had been fixed for framing of issues by the order dated 17 January 2025. However, my lord, I think the admission and denials is also not complete, subject to correction by my learned friend, but I think admission and denial is also not complete.
Yes,
Yes,
Mr.
my lord. Yes, my lord. The discovery inspection process has been completed, but the admission and denial has not yet been filed.
Discovery completed.
Inspection completed.
Discovery and inspection is over. Only affidavit of admission and denial is to be filed.
Yes,
My lord.
Also, lordship, subject to what comes out in the admission and denials, since most of the documents are in common between the parties, I believe, or we believe, that if the documents are admitted, we can directly proceed with or arguments, or with only fewer documents for evidence. That is our submission. So let the admission and denials be completed, lordship. Thereafter, we can take over.
The matter is listed as to be mentioned on the report. On receipt of the report of the Registrar Original Site dated 18th August 2025, wherein the Registrar has enclosed the order passed by the Honorable Supreme Court in transfer petitions within bracket civil number 3357 of 2024, in which the Honorable Supreme Court has directed this court to expedite the hearing of the matter and to dispose of the case as early as possible. Learned counsel for the parties submit that discovery and inspection of documents have been completed, but affidavit of admission and denial is required to be filed. In view of the submission made by the counsel for the parties, admission and denial of the document, affidavit of admission and denial of the document, affidavit of admission and denial of the document be filed within 2 weeks.
3 weeks, lordship. The client is in Bombay.
Within 3 weeks. Police. In the meantime, the parties are also directed to exchange their suggested issues.
My lord.
List the matter on 16th of September 2025 for framing of issues.
Deeply obliged, my lord.
My lord, I appear for the defendant number 2.
Hmm.
My lord, kindly gives a short pass over.
Why?
Counsel is on his way. He's in parking lot. He'll be just here in 2 minutes.
My lord, I think it was for office objections for the written statement filed by me. My lord, I undertake to cure all
How
the
much time will it
defects.
take to cure the defects?
My lord, 2 weeks. My lord, the
Nothing.
client is
Only the
actually-
report is there. Their written statement is having some.
My lord, I beg to appear for the plaintiff, my lord. I
Yes.
was being led by Mr. Meghnad Datta, but till the time he comes, my
Okay.
lord, I believe in his application under Order 8 Rule 1, some averments have been made, my lord, which we believe are not factually correct as per the department's report. So, my lord, this written statement perhaps is beyond time in our respectful submission.
No, that is not there. Only there are some defects in the written statement, so that has to be rectified.
My lord,
Not with regard to the limitation point.
if my lord may grant
Whether the
me 2
written
weeks,
statement is accepted.
not yet. The application is on board. GA1.
It is not yet, it is on board, and my lord, 120 days have gone.
It is not accepted.
it is
So how it has
provisionally
gone for the scrutiny?
My lord had provisionally accepted it on the 18th of August because it was the last day.
So if it is provisionally accepted, so how it has gone for the why it has gone to the scrutiny? एक scrutiny report तो है. Granted to submit. So how it has been sent to this scrutiny?
As per my lord's direction, I had submitted it in the department till 5 p.m. on 18th of August.
Correct,
The last time. And today, my lord, the matter was on the list.
19th.
May I indicate, my lord, of a small fact, my lord?
Yes.
My lord, I believe we had received a notice on the 18th of August that they are going to mention at 4:30 p.m. for lodging the written statement on board.
Correct.
Now, my lord, perhaps they have lodged it on 18th.
Hmm.
If they have or if they have not, my
Hmm.
lord, 18th itself is beyond 120 days.
Okay, that I will decide. That has not
Yes,
been,
that is to be decided. my lord.
that is not decided.
I'm led by
Yes,
Mr.
sir.
Dotto, madam. Mr. Dotto is there. Mr.
Lordship,
Dotto.
I appear on behalf of the defendant number 2. So
Hmm.
my application for acceptance of written statement was filed way before.
Hmm.
Lordship, the matter was there in the list. It was taken up by your Lordship once, but because the other side said they have not been served with a copy, your Lordship was pleased to direct us to serve a copy. We served the
Correct.
copy immediately on the same day. Lordship,
Hmm.
thereafter, your Lordship, I had again mentioned the matter because your Lordship's practice that it be mentioned and generally before the time expires, it be taken up. So Lordship,
Correct.
it was running in the list.
Hmm.
Thereafter, your Lordship, since the last day was 19th of August, your Lordship, on 18th, we took a leave to file the written statement with the department subject to your Lordship's acceptance.
Hmm.
Lordship, today, your Lordship, I believe your Lordship has a report of scrutiny.
But how it has gone to the okay when let the J1 be appeared along with this report.
Very well, Lordship.
Good.
Well, I have a objection as regards to the acceptability of
Correct. What I stated, you came late and you have filed the defendant number 2 has filed an application for acceptance.
yes.
And they have filed the written statement subject to acceptance with the leave of this court on 18th.
My lord.
As per your submission, that 18 is also beyond the period of 120
120
days.
days.
So now the hearing is to be done with regard to their application, whether
Absolutely.
it is after 120 days or on 120th days or before 120th day. The matter is listed as to be mentioned on the report received from the section officer of the Office of the London Master and Official Referee dated 19th August 2025, wherein altogether 4 defects have been indicated in the said report. Counsel for the plaintiff raised objection and submits that the written statement is not yet been accepted and the application filed by the defendant number 2 for acceptance of the written statement is pending for hearing. The plaintiff further submit that though the defendant has submitted the written statement with the leave of this court on 18th of August 2025, but on 18th of August 2025 is beyond the period of 120 days.
Yes.
Full stop. Considering the submission made by the counsel for the parties and the report submitted by the section officer of the Office of the London Master, this court is of the view The report will be considered at the time of hearing of the application filed by the defendant number 2 in by J1
Yes, my lord, GA1.
1 of 2025. Full stop. Let J1 1 of 2025 be placed under the heading new motion on 20th August 2025.
Grateful, Lordship.
Sorry,
20th
today is the
August.
21st. Today, 27, 25th August.
Only one thing, my lord, will kindly also record one thing, my submission, that the 120 days timeline expired on the 13th of August.
I have recorded beyond 120 days.
Yes.
Grateful, Lordship.
Grateful, Lordship.
13th August. I'm talking about- Great.
Yes.
My lord, I had mentioned this matter.
Yes,
my
what
lord,
is the
yesterday for
correction?
correction at paragraph 4 and my lord at paragraph 9.
Counsel for the submit that the several communication may by way of email have been exchanged between the parties, and lastly the plaintiff even given an offer of 25%. Yes.
My lord, plaintiff has even given an offer, my lord. This is not
Yes,
correct.
you have submitted.
My lord, no, my lord, the defendant had given an offer, my lord. I had relied upon page 656, my lord, showing that it is the defendant's offer and therefore the defendant has himself admitted the liability.
That is a 656.
My lord, it is volume 5, my lord. And I have pleaded also in paragraph 20 of my plaint.
656.
Yes, my lord, 656. This is an WhatsApp communication from the defendant, lordship. And that is my case, my lord, that they have admitted, my lord. It is written at the bottom, sir, can settle minimum 25%. This approved by our
You
management.
have submitted that we as well.
No, my
You have given the offer.
my lord,
on
my
25%
my lord, I
discount.
did not give that offer, my lord. I want my entire claim. They have themselves admitted that up to 75% we can pay. That is my case on judgment on admission, lordship. That they have admitted, my lord. In fact, in the subsequent paragraphs, lordship has recorded the defendant has admitted the claim. If lordship sees paragraph 5, it is written in paragraph 4 and paragraph 9, this finding that I have given the offer.
Yes.
Lord, para 20 of my plaint also records it is the defendant's offer, my lord. Lordship takes up para 20, I have specifically stated. 20 and my lord, I have
Nothing.
yes, my lord, para 20 and thereafter, my lord,
The
even,
para 20 is stated that 25 given the defendant.
Lord, I have
the offer
given
of 25%. Where is that?
Lord, kindly sees, lordship, I have accepted the WhatsApp communication is also annexed in my plaint.
Correct.
Yes,
That
my
is
lord.
correct.
And at paragraph 20, I have specifically pleaded that it is their admission. My lord, at para 15, lordship, by an electronic message or WhatsApp, the defendant admitted to release the outstanding sums. It was never my offer. I want my entire dues, my lord. And that's why the subsequent paragraphs, lordship has recorded that is admitted by the defendant. Paragraph 15 and paragraph 20. That is my case, lordship. That is why I was seeking the leave. Paragraph 15, if my lord, I will read it out by electronic message.
So what is the correction here now?
Now, the correction is that at para 4, my lord, it's recorded the plaintiff has even given an offer. It will be the defendant has given an offer and of an amount by giving a 25% discount. In spite of that, the defendant has not come forward to pay the dues, my lord. And plaintiff will accept this amount, my lord. I have not accepted. This is I have filed the suit because, my lord, I want the entire dues to be cleared. This defendant has given an offer. And my lord, even at paragraph 9, the same thing is recorded. My lord, the plaintiff was ready to accept the amount. My lord, that is not my case.
The matter is listed as to be mentioned for correction in the order dated 11th August 2025. Counsel for the plaintiff submitted in paragraph 4, line number 3, page 2, paragraph 4, line number 3. This court has recorded that the plaintiff has, inverted comma, the plaintiff has even given an offer to the defendant that the plaintiff will accept the amount by giving a minimum 55% discount on the total pending amount. Inverted comma close. Counsel for the defendant plaintiff submit that it is the case of the plaintiff that the defendant by an electronic mail dated 6th May 2025 admitted to release the outstanding due to the plaintiff after deduction of 25% from the said amount. Full stop. The counsel for the plaintiff further submits that in paragraph 9 also, in page 3, paragraph 9 of the order, page 3, paragraph 9, line number
5.
Line number 1, 2, 3, 5. Again, it is also recorded. Again, it is recorded that inverted comma the plaintiff was ready to accept the amount by giving 25% discount on the amount due and payable, and comma close. But that is to be corrected that the defendant has given an offer of 25% discount, but even the defendant has not paid the amount. Defendant has not paid the amount. Considering the submission made by the counsel for the plaintiff in order number 11, order dated 11th August 2025, page number 2, paragraph 4, line number 3. Paragraph 4 shall be read as, line number 3, paragraph 4 shall be read as Learned counsel for the plaintiff submits that several communications by way of email have been exchanged between the parties. And lastly, the defendant has offered 25% discount of the total amount, but even the defendant has not paid the said amount. Even the defendant has not paid the said amount. Full stop. Paragraph 9 shall be read as considering the judgment relied upon by the parties and by the plaintiff, this court finds that in the present case the plaintiff has filed the suit claiming an amount of 67,26,466 along with interest at the rate of 18% per annum. Full stop. Though the plaintiff had made several correspondence with the defendant, and even the defendant has given offer of 25% of discount of the total amount, but in spite of the same, the defendant has not come forward to pay the amount. Full stop. Taking into consideration of the above, this court does not find that there is any urgency in the matter. Matter full stop. The plaintiff फिर इसके बाद ये पूरा कर देना, यहाँ से लेकर यहाँ पे कंटिन्यू, ठीक है ना. This order may be incorporated with the order dated 11th August 2020.
Grateful, my lord.
Matter, I appear for the defendants, my lord.
Yes.
Appearing at my behest, perhaps. Appearing at my behest. So there were 3 written statements filed, my lord. I appear for the defendant numbers 1 and 1.
Written statement accepted?
Yes, my lord. It has been accepted, but a defect has been pointed out.
Following defects have been found on scrutiny of the department in the written statement of the defendant number 1, 2, 4, 5, 7, and 8.
I appear for 1, 2, 4, 5, 6, 7, 8, 9. 6.
How many written statement is filed?
3 has been filed, my lord. The written statements of the defendant number 6 and 9 are in order. There is no difficulty. Whereas, as far as the written statement of the other defendants is concerned, my lord, the list of documents, my lord, has been signed by the advocate. So the department is asking us to have it signed by the defendants themselves. So now, my lord, we are at the stage where we have come to your lordship for leave to do so. The issue here was, my lord, the written statement was initially affirmed in 2021 during the pandemic. When we filed for an extension, it was rejected. Ultimately, it had to go up to the Supreme.
What you want? I didn't want the story total.
We want leave to, my lord, file.
That's all. So you are appearing for 1, 2, 5, 6, 5, 7, and 8.
Apart from 3, everybody else.
The matter is listed as to be mentioned on receipt of the report of the section officer attached to the office of the London Master, wherein it reveals that on scrutiny of the written statement of the defendants number 1, 2, 4, 5, 7, and 8, it is found that there is no signature of the defendants concerned at the foot of the list of document filed with the written statement. Counsel for the defendants press for 2 weeks time.
Yes, my lord.
Press for 2 weeks time to rectify the said defects. In view of the submission made by the counsel for the defendant, 2 weeks time is granted to rectify the defects as pointed out in the report dated 18th August 2025.
My lord, I appear on behalf of the plaintiff in this matter. My
Yes.
application GA Com 12 is also appearing in the list today. That
Yes.
is my application under Order 13A.
Okay.
My
So
lord,
let-
if
the-
directions may be given, my lord, if my learned friend, my lord, appearing for the defendant wants to
The
file a
return date
proposition.
according to the master summons was on the 20th August. So it may come up on that day because
20 August.
28th August.
Let it come on
There are
20.
certain set of counsel appearing in that matter, my lord.
Okay.
Grateful, my lord.
Yes. Next.
My lord, I am led by Mr. Jishnu Chaudhary. My lord, I am
Which matter?
7. My lord, I am led by Mr. Jishnu Chaudhary. He is out of station. He will be back after 28, lordship. I was praying if your lordship pleases to keep this matter after 28.
I appear for the.
I applied for 1, 3, 4, and 8.
I'm for the defendant number 11 HDFC Bank. We are suffering an interim order. So, my lord, the plaintiff was making submission.
My lord,
Let the
kindly keep this matter.
plaintiff has to complete their argument. Let they complete.
Fixed at 11:30. So
Let the plaintiff
Time today.
let the plaintiff complete for half an hour.
Yes.
But before Mrs. Saha starts, I have 2 applications on board, GA5 and GA6. Those are for acceptance of the written statement. The time to file written statement expired on 14th August. With leave of your lordship, we had filed it on 12th of August. We'll serve the written statement in due course. This is the application for acceptance. Your lordship considers them now or after their submissions are over. That is after
Okay,
your
let us
lordship.
see. Let's see complete first.
My lord, grateful.
My lord, on the last occasion, we had completed looking at that final order of SEBI, my lord, which has not been appealed from, where, my lord, SEBI has found liability on the part of the respondent numbers 1, the connected companies, and the present directors, my lord. This order stands till today. There's no appeal. Secondly, my lord, we had also looked at the affidavits of respondent numbers 5 and 6, who were the ex-directors, my lord, and we have seen their defense, my lord, and their reply thereto. My lord, we were about to get into the affidavits of the financial bodies, my lord, but before that, my lord, the respondent number 1's affidavit, my lord, would be necessary. If my lord kindly, only a few paragraphs from there, if my lord kindly takes up affidavit in opposition of the respondent number 1, 3, 4, and 8. Then
Yes, give the affidavit.
affidavit affirmed by one Ajay Kumar Singh, my lord.
1, 3, 4, and 8.
1, 3, 4, and 8. They, my lord, according to us, are the main, the company, and the one number 8 is the related party, and 3 and 4 are 2 of the present directors, my lord. The other present directors have not filed any affidavit. My lord will kindly come to para number 9 onwards. I'll skip the first few paragraphs. They're not that relevant.
Yes.
Paragraph number 9, my lord, I was repeatedly saying, my lord, they had been continuing this practice since 2005. I get this from here. This is where it comes in for the first time. Para 9, respondent number 1 and the respondent number 11, which is HDFC Bank, entered into business transactions from the year 2005, in terms of which the respondent number 11 granted financial assistance in the form of overdraft facility secured by his shares, which the respondent number 1 would purchase on behalf of his customers. Admitted fact, 2001, this practice is going on.
2005.
2005, my lord, this practice is going on. So, my lord, when they say it's only in 2019, my lord has seen the other SEBI circulars dating from 1993, wherein there was always a direction to keep client shares, client security separate, its own client security separate, not to confuse the proprietary ones with the client shares. Now, my lord, the copies of agreements are annexed. My lord, I'm not going into all this because those are voluminous agreements only I want to point out from there. My lord, immovable properties of the respondent numbers 1 and 8 were also given as collaterals, my lord. Also, personal guarantees of respondent numbers 3 and 5. 3, my lord, the present director, 1 of the present director, 5, ex-director. So, and the sanction letter, my lord, has been accepted by the respondent numbers 3 and 5 both. Present director, ex-director. So the ex-director, my lord, in my humble submission, was all aware of the nature of the transaction, my lord, that was being entered into. Now, my lord, kindly turns over to page para number 10. From the aforesaid documents, it would be evident that security for the overdraft facilities given to the respondent number 1 by the respondent number 11 was pledged in respect of shares purchased by the respondent number 11 on behalf of his customers. It should be respondent number 1 purchased on behalf of the clients. Factum of creation of pledge from the balance accounts and skipping that. Never was the respondent number 1 a defaulter. In or around 20th June 2019, SEBI respondent number 12 herein published a circular. Very conveniently, my lord, all the other circulars omitted, including the 2016 circular, which is very specific that you cannot do this. Story starts from 2019 circular, by which the entire modality of stockbroking business was altered. Previously, all stockbrokers would pledge shares purchased by them for their customers for the purpose of raising finance, which would also be used by the customers. However, this was prohibited by the said circular dated 20th June 2019, and stockbrokers, including the respondent number 1, were directed to unpledge the shares and return the same to all the customers. This, my lord, remembers was the submission of Mr. Chaudhary when he was giving an overview of the matter, that this was always the practice. Respondent number 11 was aware of the manner in which the business was carried out as mentioned above. So HDFC Bank was aware. The annual accounts of the respondent number 1, which was in public domain, makes this position clear. In fact, from the balance sheets of the respondent number 1, it would be evident that cash credit from the bank was secured by quoted shares and securities of clients. So always the practice. Para 14, my lord. The respondent adopted a hostile attitude towards the respondent number 1 from the date of publication of the said circular dated 20th June 2019. The respondent number 11 was aware that it would have to unpledge the shares in terms of the directives of SEBI and has attempted to avoid doing so. This was done by the respondent number 11 wrongfully and in breach of his obligations under the agreement. Immediately after the publication of the circular dated 20th June 2019, the respondent number 11 called upon the respondent number 1 to sell shares approximately worth rupees 5.98 crores. Particulars in the schedule, respondent number 1 protested. However, in order to continue with his banking limits, the respondent number 1 had no option but to sell certain shares as demanded by the respondent number 11. My lord, kindly notes, right after the circular is issued, my shares are sold, apparently on being coerced by the respondent number 11. All the sale proceeds from such sale was appropriated by the respondent number 11. The said sale was under undue influence, coercion, and pressure. The sale was forced by the respondent number 11, and the respondent number 1 was aware that extreme prejudice would be suffered by it if the shares would not be sold by the respondent number 1 what kind of prejudice not given. In order to ensure continuity of business and in order to buy peace, the respondent number 1 has succumbed to a wrongful demand. By selling my shares, the respondent number 1 has decided to acquire back the shares which has been sold in the open market, but was prevented from doing so in view of further wrongful conduct of the respondent number 11. So both respondent number 11 and respondent number 1 are aware at the point of time that they are dealing with shares of me and other investors of the respondent number 1.
So in the paragraph 14,
my lord,
the first line, the respondent adopted the...
it should be a respondent number 11, my lord. Respondent number 11. My lord, what has happened is this is a copy paste of the plaint filed by BRH against HDFC in the other suit, which is pending, which is why the entire story revolves around the respondent number 11 and the plaintiff and BRH, nothing else.
They had applied for addition of
Yes,
party.
we have applied for addition of party. So that is a copy paste there from. So that's why something has happened here. Yeah.
Draftsman tries to take advantage.
Yes.
Paragraph 16, my lord. The respondent number 11 did R11, did not permit the petitioner to continue to use the financial facilities. Here, my lord, the petitioner should be respondent number 1. So all this has happened. This is despite the fact that there had been no breach or default by the respondent number 1. It is the respondent number 11 who, by refusing to allow use of the financial facilities, has been in repudiatory and of fundamental breach of the contract. My lord, kindly comes to paragraph 17. It is for reason of the respondent number 1's breach. The respondent number 1 was, again, should be respondent number 11's breach. The respondent number 1 was constrained to suspend its business operations on and from 30th September 2019. My lord, I had placed 30th September 2019 is the date when NSE suspended its operation.
Who is
not
appearing for the 1?
1, my lord, Mr. Jishnu Chaudhary, my lord. They were seeking time. This would be evident from respondent number 1's letter dated such and such issued to the respondent number 11. Such fact would also be evident from the letter issued by the respondent number 1 to the NSE. It is clearly recorded in the said letter of 30th September 2019 that it is for reason of the respondent number 11 that the respondent number 1 could not continue with its business operations. The respondent number 1 had thus requested for suspension and freezing of his trading account maintained with the NSE on his own accord. So their cases, we had sought for it. NSE says we have suspended it because we have found a number of discrepancies in the accounts. Para 18, my lord, respondent number 11 had issued an email dated 1st October 2019 at 1:34 a.m. requiring the respondent number 1 to repay, prepay or reduce his outstandings. And I'm skipping over that email annexes. There was no cause or reason for the respondent number 11 to issue the said email. The respondent number 1 was not a defaulter and had not defaulted in effecting any repayment. In the said circumstances, it could not have been required to repay or prepay or reduce its outstandings. It is fundamental breach of contract on the part of the respondent number 11 to act in the aforesaid manner. At this juncture, the agreement between the parties was alive. Para 19, it is pertinent to mention that as on 30th September 2019, the respondent number 1 had shares worth rupees 163 crores in his demat account, which belonged to his customers or investors. Most of the shares in the demat account were pledged by the respondent number 1 to the respondent should be number 11. Now, my lord, 30th September 2019, this pledge value is according to admittedly 163.46.
Yes.
SEBI circular said by 30th September 2019, you have to unpledge everything and return them to the customers. So 11 was as on date holding a huge number of shares. In fact, the value, my lord, would be 158 crores odd that was with them. In para 20, my lord, respondent number 1 thereafter received another letter dated 4th October 2019 by which the facilities granted to the respondent number 1 were wrongfully recalled. My lord, I'm skipping over the jurisdiction part. My lord, kindly sees in the middle of the paragraph, even as at 4th October 2019, there were no default on the part of the respondent number 1 towards the respondent number 11. In the said circumstances, recall of the financial facilities granted to the respondent number 1 and or termination of the agreement by the respondent number 11 thereof was unlawful, illegal, wrongful and has caused substantial loss and damage to the respondent number 1 suffered against jurisdiction issue. My lord, I'm skipping over the rest of this paragraph. Now, my lord, kindly comes over to para 21. The respondent number 11 had been threatening to transfer the shares which had been pledged. This has been recorded by the respondent number 1 in his letter dated 16th October 2019. all this letter is not disclosed. The respondent number 1 was, however, in the knowledge that in the event the respondent number 11 would attempt to take any step to sell the pledged shares, the respondent number 1 would receive notice as mandated by the Contract Act and by the contract between the parties. Respondent number 1 subsequently received a letter dated 30th October 2019 issued by the respondent number 11, wherein it is recorded that the pledge has been invoked and the shares have been sold. So, my lord, this even after, my lord, I'll show from the records, respondent number 1 has written to the respondent number 11 saying that the shares belong to my clients. I am offering you further collaterals. Please release all the shares because they have to be returned to the clients. Respondent number 11 was clearly in the knowledge that the shares are of clients because the sanction letter, my lord, of 2005 itself, that modality is reflected therein. So, my lord, despite knowledge, my lord, they go ahead, they invoke the shares. My lord kindly turns over the page. Respondent number 11 has wrongfully sold all shares which had been pledged with it. This is factually incorrect because respondent number 11 has disclosed that some shares amounting to about 1.8 crore is still lying with it. Rest all 158 crores, rest all it has sold. Surprisingly, without notice under section 176 of the Contract Act 1972 or as mandated by the contract, these shares were sold by the respondent number 11. This has brought the entire business of the respondent number 1, who was not a defaulter, to a standstill. The respondent number 1 has filed a suit, being CS number 54 of 2020, against the respondent number 11. So then he says that I have approached the Investor Protection Fund and...
what has happened to this suit?
My lord, in that suit, my lord, initially there was...
That suit, earlier suit is pending. We have filed our written statement. It was, and the suit, then after that, no steps have been taken by the plaintiff.
My application for addition of party, my lord, is also pending.
Which is also no steps taken by them.
Where it is pending?
It is in the before
this court.
It was also filed before this court in the commercial division.
Commercial number is not provided.
Yes, it is there.
Commercial.
It was CS-Com 54 of 2020.
Oh, my lord, this was filed as a normal suit. No, normal
That's why.
suit.
That's interesting.
That's why,
Because
yes.
It's a normal suit. CS 50.
It's before Justice Majumdar, my lord.
It's an ordinary suit. CS-20.
They filed it as an ordinary suit.
Yes.
In
I was under the
2020.
impression it's a commercial suit.
It should have been in 2020. I do not know how this could have been filed as a regular suit.
I have to check, man. Let me check whether it is a commercial or not.
Okay.
This is CS 54 of 2020. So it's before Justice Majumdar only. Yes. Now, my lord will kindly. Then they have said, what are the proceedings? My lord, proceedings by SEBI. I have placed those orders, so I'm not going into this. So, my lord, what transpires from the affidavit of the respondent number?
All allegation upon the respondent number 11.
All allegations on the respondent number 11. One. Second is an admitted fact that this practice is continuing since 2005.
Correct.
And
Sorry to interrupt, man. This is filed. CS-54 is filed under the commercial division. This is the written. Yes. This is the written statement showing. And the last order also shows that it was passed under the commercial division.
Also before Justice Majumdar. The order. Oh. Then, my lord, if it's filed before the commercial division, they should be before this court. But I don't see any COM number, my lord. That's all. So, my lord, 2005, this thing is going on. And, my lord, importantly, respondent number 5, my lord, the ex-director, was the person who signed the agreement, signed the sanction letter, and taken all steps on behalf of the respondent number 1. My lord will remember his defense was, I was never involved. I never did anything. I was only a promoter director, but I did not know anything that was done by this company. Now, my lord. So for now, my lord, I had handed over 3 separate list of dates, my lord. That would be handy for looking into the activities of this financial bodies, my lord, the banks. I would request, my lord, to kindly take up the one of the respondent number 11, my lord, first, because that's the more comprehensive one. The other list of dates, I'll just show the relevant dates, my lord, on which respondent number 11 are affidavit. The affidavit take to My lord will also look at the affidavit of respondent number 11, with it, my lord, to look at the documents. I've indicated all the documents with their page numbers and para numbers in this list of days, my lord. So that would be convenient. Affirmed by Devojit Mukherjee on 27 January 2025.
It is in about
It's a
six,
big one.
6 volumes. 6 volumes, I think. 6 volumes.
Yes.
My lord kindly takes up the list of days first. My lord, this is one list of dates that I would require to take my lord through. The rest I will not, will only indicate the relevant dates. My lord kindly comes to serial number 1, my lord. This is the 1993 circular of SEBI. Before any of this starts, this SEBI circular, it mandates the brokers to keep separate accounts for client securities and to keep separate books of accounts to distinguishment. My lord, it's at page 354 of the petition. My lord, all the page numbers are there.
Yes.
10th of December 2004, my lord, respondent number 1 was incorporated by respondent numbers 3, 5, and 6, my lord. So these are the promoter directors. It was a registered broker. The memorandum and articles of association, my lord, are at page 436. Page 446, my lord, I have indicated, that indicates the signature of all of this three. Now, my lord, 7th of October 2005, my lord, this is a relevant date when this practice starts. My lord kindly notes, respondent number 1 availed of financial assistance from the respondent number 11 against pledge of its client shares, and respondent number 3 fraudulently declared in the overdraft request letter that the securities pledged were held by the respondent number 1 as the absolute owner thereof and not in any fiduciary capacity. The sanction letter is accepted by the respondent numbers 3 and 5, I was just indicating. Such facilities were renewed from time to time with the sanction limit as on 4th of October 2019 standing at rupees 300.3 crores. Subsequently, respondent number 8 also availed of credit facilities from the respondent number 11 of the sanctioned limit of rupees 17.9 crores against the pledge of client shares of respondent number 1. Well, I have no privity with respondent number 8. My shares have also been siphoned off to 8 and other related parties who have in turn availed financial facilities. The facilities were also secured by immovable properties of respondent numbers 1 and 8, as well as personal guarantees of respondent numbers 3 and 5. Respondent number 11 accepted such pledge of client shares as valid security and sanctioned and renewed facilities from time to time in favor of the respondent numbers 1 and 8. My lord, I have indicated the page numbers of the AO from the respondent number 1 from which all these documents are there, as well as from the respondent number 11's affidavit in opposition, my lord. They say this in page 26, paragraph 3x. I have indicated the page numbers and the paragraph numbers here. My lord kindly comes to serial number 4. 17th of April 2008, my lord, this is the second SEBI circular on this issue. It mandates the brokers to have adequate systems and procedures in place to ensure that client collateral is not used for any purpose other than meeting the respective client's margin requirements or payments, and brokers should maintain records to ensure proper audit trail of the use of client collateral. My lord has seen, my lord, I will further show, my lord, I have always maintained a credit balance. There is no question of any debit balance at my end. So my even under the 2008 circular, my lord, my shares could not have been used, but they have been. Now, my lord, this circular, my lord, is at page 212 of my petition.
Yes.
Now, my lord, kindly comes to serial number 5. This is the date, my lord, 1st of May 2010, when respondent number 6, my lord, resigned from the board of 1 and 8. The form DIR 12s, my lord, are at page 169 of the petition. But respondent number 5, my lord, is still there. His
Only
number,
eight. Who has resigned?
my lord, respondent number 6. My lord, there are 2 Agarwala brothers, my lord, Sudhanshu and Avinash. Sudhanshu has resigned before this entire this SEBI circular of 2016, my lord, comes in and out. But then he was still a director when the practice started. In 2005, the practice started. He was still a director. My lord, next page, 26th of September 2016, my lord. This is another SEBI circular. This is more of a putting everything into place, my lord. This is, in fact, what I would strongly rely on. It mandates the client demand account be named as client account. Client securities cannot be used for proprietary purposes of the broker, including settlement of proprietary obligations. It provides that transfer of securities from client account to proprietary account is permitted only for implementation of government or regulatory directions or orders in case of erroneous transfers, for meeting legitimate dues of brokers, etc. It further provides that brokers can pledge securities only to the extent of client's indebtedness and only with the explicit authorization of the client. It's not either or, my lord. In any event, they cannot do it. And that funds raised against such pledged securities shall be credited only to the account name as client account. It would not happen for their own benefit. And a statement to such effect would be sent to the client by the broker. Securities of only those clients who have a debit balance in their ledger can be pledged by the brokers, which is why, my lord, I was harping on not a single day did I have a debit balance, and only to the extent of such indebtedness. It further required brokers to upload client security balances to the exchanges. It further provided for demat accounts holding client securities to be named as client accounts, and that client securities shall not be used by brokers for proprietary purposes, including settlement of proprietary obligations. This is very specific, very to the point. According to this, my lord, this could not have been done at all. In 2016 itself, if they have done anything at all, they should have unpledged the shares. My lord, this circular, my lord, I have indicated at page 452 of my petition.
Yes.
Then, my lord, kindly comes over to the next serial number 7, my lord. This is where, my lord, my unfortunate clients come in for the first time in October 2017. They enter into client-broker arrangement with the respondent number 1 and transfer their entire holding in shares and stocks into demat accounts maintained by the respondent number 1. The specific powers of attorney executed by the petitioners only permitted respondent number 1 to debit or transfer security only for margining purpose or for delivering the same to the clearing house or to correct any erroneous transfer of security. So this power of attorney is in terms of the 2016 circular.
Yes.
However, their actions are not. They say that you have given a power of attorney, so we could have done it in their affidavits. But this power of attorney, their formatted power of attorney is strictly in terms of the circular, and it could not have been used for this purpose, my lord. The power of attorney did not.
Yes.
My lord, the power of attorney did not permit the respondent number 1 to pledge petitioner securities for the use or purpose of the respondent number 1. My lord, this power of attorney is at page 122 of the petition, my lord. I have indicated only for margining purposes or for correction of any error or for delivery to the clearing houses. That's it. My lord kindly turns over and comes to serial number 8. 17th of September 2018. My lord, respondent number 5, the other Agarwala brother, he resigns from the board of the respondent number 1. However, my lord kindly notes he continues to remain the majority shareholder himself. He holds 5.54% through family members, my lord. Respondent number 6 holds 1.38%, the other Agarwala brother. and companies controlled by him. Like Snotex Investment, my lord, holds 27.1% of the shares. Snotex Securities holds 6.92%. Shakti Auto Finance, my lord, 2.79%. And his other family members, other Agarwalas, they own through Sumi Trading Private Limited 4.61% and through Bhagwati Syndicate Private Limited 1.93%. Cumulatively, my lord, this comes to around 50.27%, my lord. That is still held by the Agarwalas. My lord, the relevant documents, my lord, are at page 168 and 202 of the petition, my lord.
Yes.
Now, my lord, remember, response number 5 had stated that we had permitted.
Change the name.
We had permitted respond number 3 to use my name, to use the name of the BM Agarwala group. And once I exited, I asked him to change. My lord, that change takes place on 13th March 2019 from BMA to BRH Wealth Creators, my lord. The new certificate of incorporation is at page 61 of the AO of respond number 5. Now, my lord, kindly says on 31st March 2019, my lord has noted the amount of the pledges, 158 crores, 164 crores. This is the disclosed net worth of the respondent number 1 in terms of their balance sheet, my lord. Any amount of due diligence, the basic due diligence would have shown that they could not have pledged the shares and the shares could not have belonged to them. 12.83 crore is their disclosed net worth. This, my lord, is at page 228 of the petition. This is a finding of the SEBI in the SEBI's order, my lord. I've indicated the page number. 2019 circular. This, according to them, is when heavens fell and everything broke loose. SEBI circular mandates the securities received in payout against which payment has been made by the clients to be transferred to the demat account of the respective clients within 1 working day of the payout. It provides that client collaterals and securities shall not be used for purposes other than meeting clients' margin requirements or paying. It further mandates that client securities already pledged to be unpledged and returned to the clients upon fulfillment of pay-in obligations or disposed of after giving notice of 5 days to the clients by 31st of August 2019. My lord has seen, even on September 2019, the respondent number 11 is holding 164 crore worth of shares. So, my lord, the only difference between the 2016 circular and the 2019 circular is that 2019 circular specifically mandates you to return the shares. But it was illegal to do this even from the time of the 2016 circular and even prior thereto in terms of the other circulars. Now, my lord kindly turns over and comes to serial number 12. According to the respondent number 1, BRH, my lord, immediately after the circular is published, my lord, the respondent number 11 demanded certain shares to be sold, and under undue influence, coercion and pressure, respondent number 1 was compelled to sell certain shares worth rupees 59.72 crores, and the sale proceeds was appropriated by the respondent number 11. This I have shown from the affidavit. Serial number 13. 14th of August 2019, my lord, according to the respondent number 5, he called upon the respondent numbers 1 and 8 to cease associating themselves with the BMA group using registered trademarks of BMA. That's in his affidavit. Now, my lord, 30th of August 2019. This is when my last monthly holding statement is issued by the respondent number 1, holdings of 9.92 CR cumulatively as on that date. So, my lord, admittedly, huge amount of positive balance, no question of any debit balance. This is at page 147 to 158 of the petition, my lord. All the monthly holding statements are disclosed there. After that, my lord has said that in September 2019, though I conducted further trading, my lord, no monthly holding statement was shared, citing technical glitches. In serial number 16, my lord, 24th of September 2019, respondent number 1 provided an undertaking to the respondent number 13, my lord, the NSE, affirming that all client securities are lying with it without any shortage. My lord, when they have already given up everything and everything is gone. In their affidavit now, they said that all of this were dealt with in favor of the financial bodies, my lord. However, they go on give this undertaking. This is at page 232 of the petition, my lord. This is also a finding by the SEBI. Serial number 17, my lord, 26th of September 2019. Coming to know of the inconsistencies in the balance of the client securities reported by the respondent number 1 as on 30th of August 2019. Respondent number, my lord, this should be 13, my lord, if kindly a correction can be made. My lord, in serial number 17, my lord, there's a respondent number 3 requisition. This should be 13, my lord. NSE, National Stock Exchange, requisition respondent number 1. And being dissatisfied with the response offered, informed the market infrastructure institutions and respondent number 12 of the same. So, my lord, on 26th of September 2019, it is out in the market that respondent number 1 is indulging in such practices. There are huge discrepancies in their records. Then, my lord, kindly see, my lord has noted this date. This is 26th of September.
Yes.
Very next day, 27th of September 2019, respondent number 1 says before the SEBI that despite the circular, respondent number 1 has still created pledges over his client securities. After the circular clearly says that you have to unpledge and return, they're still continuing to create pledges, and respondent number 1 is still accepting those pledges. 11 is still accepting those pledges. And this is according to respondent numbers 11 submissions before the SEBI, my lord. It is in the part of the order at page 278 of my petition, my lord.
Yes.
I've indicated the page number and the sentence. On 30th of September 2019, my lord, a number of things happen on this day. Respondent number 1 writes to the respondent number 11 and says that the shares that I have pledged with you, they all belong to my clients. I'm seeking release of the securities, and he proposes to arrange additional collateral securities in his favor. My lord, this document I will have to show, my lord, from the affidavit on opposition of respondent number 11. My lord has volume 1, my lord, at page 85. Till now, HDFC has not sold the securities. They have kept the securities. They are informed formally in writing that those are not my securities. Please release them. My lord, kindly comes to page number 85 of the affidavit in opposition of R11, my lord.
Yes.
My lord, it's Annex D. My lord, kindly note this from BMA Wealth Creators to HDFC Bank Limited, 30th of September 2019.
Page
85, my lord.
85 of respondent number 11.
This one number 11. Volume 1, page 85.
Yes.
And I kindly has found a letter dated 30th of September 2019 from BMA to HDFC Bank. My lord, kindly notes the subject regarding releasing of client shares. Dear sir, this refers to the credit facility provided by you to us. You are aware that by circular number such and such dated 20th June 2019 issued by SEBI, all stockbrokers, including us, have been directed to segregate securities of their clients. You are also aware that the shares over which you have created pledge against our said credit facility are freely tradable shares and securities of our clients, for which full amounts have been paid by the respective clients. Admission, nothing, no debit balance. You were always aware of such fact, and while carrying due diligence, this was brought to your notice. However, you still impressed upon us to create the pledge. Though such pledge ought not to have been created in the first place, however, even if created, such pledge is void under SEBI guidelines. You have also derived benefit from sale of such shares in the past few months to reduce your credit exposure towards us, which also you should not have done. So they have given the pledge. They say that the pledge was wrongfully created. The pledgeor itself says. You cannot dispute that our intention was never to avoid repayment of credit facility, and we are committed towards the same. It is in this regard we had also engaged the services of a world-renowned wealth management company, namely Alpen Capital ME Limited, to arrange for alternative source of funding, which would have ensured clearing of our credit facility with you in due course. However, since there is extreme economic slowdown all over the world, including in India, there is a delay in progress by Alpen also. As was informed to you, Alpen is constantly working on unlocking values of real estates, which we have offered to them to arrange the funding. However, none of our efforts can be at the cost of investor securities or to circumvent their rights. In order to demonstrate our further bona fide intent, we propose to arrange additional collateral securities of equivalent value for you so as to protect the interest of the bank. However, the same can only be done once you release the pledge over the shares of our clients. We would also like to place on record that today you have failed to release shares for our pay into exchange purpose, as a result of which our operations have been suspended around 1 p.m., which has caused immense loss and prejudice to us, for which we reserve our right to claim damages and compensation. My lord, in their affidavit, they say it's because of HDFC's illegal act that everything was suspended.
Yes.
And NEC says that because of detection of all this irregularities, it was suspended. Hence, you are requested to forthwith release the pledge on the shares held in our account. Your failure to adhere to our request will cause us to fail in performing our duties as stockbrokers in terms of the said circular issued by SEBI, which will lead to suspension of our operations, for which you shall be held solely liable. Signed, my lord.
Yes.
So on 30th September 2019, formal letter to them saying all of this are owned by my clients. The pledge was invalidly created. It's admitted that the pledge was invalidly created and it's void and asked to return upon offering other collaterals, my lord.
Yes.
My lord now comes back to the list of dates. My lord, I have shown, my lord, the corresponding documents with regard to the first entry at page 85. Now, my lord, kindly comes to the second one. Respond number 1, my lord, BRH also informed respond number 13, that is NSE, that respond number 11 has been requested to release all pledge on shares of clients in favor of other collaterals, as the same ought to be transferred to the client's respective accounts. I'm not bothering, my lord, with this letter because it's in sum and substance the same as this letter that I said. This is at page 141 of the AO of respond number 1.
Yes.
My lord, which is very clear. Again, I have written to HDFC to release everything because they all belong to my clients. Now, my lord, kindly turns over the page, my lord. There are 2 more entries of this date. On the same date, my lord, respond number 13 reported that in violation of SEBI circular dated 20th of June 2019, respond number 11 held pledges valuing at 156.05 crores pertaining to shares of the respond number 1, clients of the respond number 1. They're supposed to return everything by this time.
Yes.
This, my lord, is at page 229 and 230 of the petition, and the clauses are mentioned. And respond number 13 suspended respond number 1 with effect from 1st of October 2019 for non-compliance. My lord, that suspension letter is also there.
Yes.
My lord, should I stop here today? My lord,
Yes.
My lord, I'll complete this list of dates, and from 9 and 10, my lord, I have a few relevant dates to show who are the directors at the point of time when the arrangements were entered into and when the invocation was done, my lord, and how the invocation was done despite having notices of the fact that BRH had already been suspended. It was already under scrutiny of the regulatory bodies and an interim order has been passed against it, my lord.
Okay. Counsel for the plaintiff has argued the matter at length, but due to paucity of time, hearing could not be completed. According to this is adjourned. Let the matter appear on.
Next week,
25th है? हैं? कल 12:30 खाली है? Tomorrow at 12:30?
My lord?
Tomorrow at 12:30?
Tomorrow at 12:30.
At 12:30 on 21. August.
More 12th,
30th, 20th. Yes, next.
Great.
But insofar as GS 5 and 6 is
Let-
concerned,
let-
Lordship will
I
consider.
will take.
My lord, grateful.
Yes.
Respondent.
My lords, I appear for the petitioners.
Now change.
My apologies, my lord.
They have to start, my lord, today. My lord. Let them start.
Yes.
My lord.
My lord, I am being led by the learned advocate general. My lord. I'm requesting for a short accommodation. I know it's a last minute request, my lord. You're supposed to be here.
Mr.
Or my lord may kindly pass it over. But the learned AG has requested me to convey to my lord if it can be accommodated to some other date, my lord, a short deferment, my lords.
You know when the date was fixed, 23rd June, the date was fixed
Yes,
today.
Lordship,
After a month, after 2 months, then
a short accommodation for today, my lords, may kindly be given, my lords.
Next matters, my lord, if my lord, and it was known to them, my lord, they were supposed to start today, my lord.
Most certainly.
Several times, my lord, they had also taken extension, my lord, with regard to my lord, time, and my lord, we have also scheduled last time, my lord, I mean, led by Mr. Shudipto Sarkar, my lord, he's also, my lord,
My lord,
on his way, my lord.
the request for deferment last time was on account of a circular in the court, my lord. That was a joint request. The order speaks.
what has happened to him? Nothing.
This has to be, my lord, heard.
My lord, we've made a request. We've still not heard. The other side can confirm that. We've still not heard from the Honorable Chief Justice.
No,
We
no,
requested.
let's not get into this
Therefore, I'm
over
not,
and over again.
sir, I'm
my lord.
not getting into
Either,
it.
my lord,
My
the
lord
matter
asked a
today.
question. Your
So
lordship
they're
asked
supposed
a
to
question.
start the matter.
My
Mr.
lord, we
Manoj,
will-
the Advocate General and Mr. Jishnu Shah, my lord, both are appearing in this matter.
So when see
Your lordship
today's
may
fee
give a
especially fixed, you know that
I understand, my
24
lord.
July this
My
case
lord, I
was fixed today.
apologize, my lord. The short accommodation may be given for today. Short accommodation may be given.
My lord, kindly pass it over, my lord. Let them start, my lord, today. My lord,
Okay, let pass over. When your AG will come, then we'll start. Pass over.
The Advocate General was supposed to start, but since he's in difficulty, then I'll start for a little while because I'm appearing for the WBIDC. We have separate submissions to make. Then I might as well start because
sure.
You are appearing for?
I am appearing for the petitioner number 2.
Okay. Okay,
West
then you
Bengal
can.
Yes. Well, I'll start with the aspect of the matter which, my lord, the Advocate General had not addressed, your lordship. Well, so far as your lordship's order, my lord, in the 36 application is concerned, that was an interim order. We'll proceed on that basis.
Yes.
My lord, may I start with, my lord, the agreement? Because, my lord, one of our principal contentions will be, my lord, that, my lord, today, of course, the arbitrators have the jurisdiction and the duty to, my lord, interpret the agreement. But when in the course of interpreting the contract, my lord, the arbitrators cannot take, my lord, such a stand, or, my lord, interpret the contract in such a manner which is going to, my lord, ultimately be a perverse interpretation. Let us put it that way. Now, my lord, to understand, my lord, what is the contract and, my lord, how the contract proceeded.
Yes.
Well, I'd like to, my lord, refer to the shareholders agreement. Well, that your lordship will find at, my lord, share purchase agreement 353. This is volume 3, page 353. Well, the background as narrated or recited in this agreement is very, very important.
353.
353.
Yes.
Well, please have a look at the agreement. My lord, may I place it a little slowly? My lord, this agreement is entered into between, my lord, West Bengal Industrial Development Corporation, which I represent.
Yes.
Then, my lord, the second party is the government of West Bengal. The third party is, my lord, Chatterjee Petrochem Mauritius Company, which is, my lord, one of the Chatterjee Group entities. The fourth, my lord, party is Essex Development Investments Mauritius Limited. The fifth party is, my lord, the company Haldia Petrochemicals. Now, my lord, why are so many parties, my lord, involved? My lord, the government of West Bengal holds shares, including, my lord, through the WBIDC. The industry was set up by the WBIDC. And, my lord, so far as the Chatterjee entities are concerned, they are diverse in number. My lord, what happened is the Chatterjees were, my lord, upon an initial agreement between the parties, trying to acquire the shares of my lord Haldia Petrochemical for a long time, and there was diverse litigations between the parties in this regard. Well, it started with the Company Law Board, came to the High Court, well, it went to the Supreme Court, went to the Division Bench, went to the Supreme Court, then well, it referred to arbitration and international arbitration. All these things were going on. What this will inexorably point at is that they wanted to buy the shares come what may. And that is very fundamental to the whole understanding of the whole award and how the award has proceeded. Now, this background your lordship will find from page 355 onwards. Well, the Chatterjees
So
were
who
not
were before the arbitrator? WBIDC, Government of West Bengal, and
Essex Development.
Essex. So what has happened with regard to the Chatterjee and Haldia?
Essex, Chatterjee, Mauritius, these are the Chatterjee entities.
Okay, okay.
Because they wanted to acquire it through several of the Chatterjee entities. Now, here, one thing, what your lordship will find, if your lordship sees the arbitration agreement, before your lordship comes to the other parts and portions of the document, the arbitration agreement is contained in this document is at page 390. Now, here your lordship will find that strangely, although the main agreement was including with the Haldia Petrochemical Company, Haldia Petrochemical was not a part to the arbitration agreement. Now your lordships have held without any demur that the arbitration agreement, even if contained in the main body of the main document, is a separate and independent agreement. Let us look at clause 19 once. If any dispute, controversy, or claim between the seller / the Government of West Bengal on the one hand and the purchaser on the other arises out of it in connection with the agreement, including with respect to interpretation of or breach, termination, or invalidity thereof, the disputing parties shall use all reasonable endeavors to negotiate with a view to resolving the dispute amicably. In the event the concerned disputing parties are unable to resolve the dispute amicably within 15 days or such other extended period as may be mutually agreed upon in writing, any disputing party may refer the dispute to arbitration. Now, so therefore, who can refer the disputes? Disputing parties. Who are the disputing parties? Seller or the Government of West Bengal on the one hand and the purchaser on the other hand. Now, if your lordship will now see the definition of the purchaser, please come back to the share purchase agreement. Once again, please see the parties first. Where's the definition of purchaser? 354. 354.
Yes.
If here your lordship will find the sellers is the Government of West Bengal and WBIDC, and the purchaser is clearly defined, Essex Development Investments Mauritius Limited. May I read it? Essex Development Investments Mauritius Limited, a company incorporated under the laws of Mauritius and having its principal place of business in Los Cascades Building, such and such, Port Louis, Mauritius, hereinafter referred to as the purchaser.
Yes.
Now, what is very significant is the arbitration clause does not contemplate referring of any disputes with regard to Haldia Petrochemical, although Haldia Petrochemical Limited is the fifth party or the party of the fifth party in the agreement.
Yes.
The reason why we talk about this is here the agreement is titled a share purchase agreement. So if your lordship looks at what is the intendment of the parties or what the agreement was supposed to govern, it is a sale and purchase of shares. It is not an allotment of shares by Haldia Petrochemical. It is shares which were already allotted to and were being held by the Government of West Bengal and WBIDC. that were to be sold to my lord Essex. And that is why, so far as the other parts and parcels of the agreement concerned, which we say, my lord, concerns, my lord, the offering of a tax incentive, my lord, that was never, my lord, the subject matter of arbitration at all. Now, my lord, one of the principal, my lord, reasons, my lord, is that, my lord, here, so far as this is concerned, that, my lord, here your lordships have held, my lord, without any contradiction, that, my lord, anything, my lord, that is beyond the scope of the arbitration agreement cannot be arbitrated. And the arbitration agreement, my lord, without again any contradiction, provides it is only disputes between the purchaser and the seller, not with regard to Haldia Petrochemical. Now, my lord, kindly keep it at the back of your lordship's mind that who was entitled to the tax benefit, if it at all? Haldia Petrochemicals. My lord, that is, my lord, how the agreement proceeds. So, my lord, if today there is ultimately an award with regard to the tax benefit, my lord, which tax benefit is, my lord, to go to Haldia Petrochemicals, and Haldia Petrochemicals is not a party to the arbitration agreement, then the question is whether this dispute was arbitrable at all. That is one of the issues.
So whether you raised this issue before?
Yes, yes, yes. Very squarely raised. Very, very squarely raised, and my lord argued, my lord, endlessly. My lord, I shall, my lord, come to that. My lord, now, my lord, why do I say that this agreement, my lord, is a share purchase agreement and must be confined to, my lord, the consideration that was payable for the shares? Now, my lord, here your lordship will, my lord, I will be showing it to your lordship, my lord, the law on the subject, which says that, my lord, in one document, you may have an agreement and you may have other incidental matters which are not a part of the agreement. It is not as if, my lord, everything that is contained in an agreement is the agreement between the parties. Now, my lord, here, now your lordship will see, your lordship has seen that, my lord, the document is titled Share Purchase Agreement. Now, my lord, what is the history of the background in which this agreement came to be executed? Which is very important to understand, my lord, the agreement and how to interpret it. My lord, may I now, my lord, show your lordship the page 355 onwards. Now, my lord, so far as the company is concerned, my lord, HPL Haldia Petrochemicals is defined as the company. That's in paragraph A. Then, my lord, paragraph talks about, my lord, how, my lord, this was conceived as a flagship company in the state. Then, my lord, please see C onwards.
Yes.
As on the execution date, the authorized capital of the company is rupees such and such 25,000 million, divided into 2,200 million equity shares of rupees 10 each, and, well, 300 million preference shares of 10 each. And the paid up share capital of the company is rupees 19,590 million, 200,500 only. Well, this is, my lord, made up of, my lord, 16 lakhs 87,000. I'm sorry, 1 crore 68 lakhs 79,000. Well, let's talk about it in million. I can't put the figure.
1,687 million.
Yes, that's right. Shares of 10 rupees each. Well, the shareholding pattern, my lord, is a part of Schedule 1, which your lordship will straight away please come to. Well, that Schedule 1 is at page 395.
Yes.
Well, please see the shareholding pattern here. Well, at the date of execution, WBIDC, well, 33 point, I think it's 35, 33 or 35.35%. Then, my lord, WBIDC, my lord, again, is 3.01. WBIDFC is 9.93. The Tata Group holds 2.30%. Indian Oil Corporation holds 2.66%. Well, now we come to the Chatterjee entities. CPMCP, well, which is 22.16. ITML, which is again a Chatterjee entity, 5.41. Winstar, a Chatterjee entity, 6.56. And then there are others, 1.16. And the lenders, well, of the company are 5.32. Well, this is how the shareholding pattern was.
Yes.
Existing shareholding pattern on the date of execution of the agreement.
Yes.
After the transfer of all shares, yes,
Now, my lord, please have a look at now page 377.
Yes.
My lord, this is, my lord, what would have been the position following the sale of additional shares.
Yes.
First tranche, second tranche, which was defined as additional share. Finally, this would have been the situation. We would have been
Well, this would have been the final situation. This was the contemplation of the parties. Well, purchaser or its nominees would have been, my lord, 30.80%. CPMC Chatterjee, my lord, entity would have been 25.65%, my lord, which is, my lord, more than 55% shareholding. My lord, WBIDC would have been left with only, my lord, 9%, 9.19. Again, my lord, India Trade Mauritius Limited Chatterjee entity, Winstar Chatterjee entity, my lord, they would have got another, my lord, about 14%. And then Tata Motors would be left with 1.33, Tata Power Company 1.32, well, about 2.66 for the Tata entities. IOL would be left with 8.89, lender 7.58, and others 1.33.
Yes.
Well, altogether, the idea was that Chatterjee Petrochemical or the Chatterjee entities will hold more than 70% shares in the company. And how? By transfer of the shares held by the state entities, that is WBIDC and the government of West Bengal. Now, please, allow me to come back to paragraph D at page 355.
Yes.
The purchaser is a company incorporated in Mauritius. Now, your lordship will see purchaser is defined and is an affiliate of CPMC. That is a part of the Chatterjee Group.
Yes.
The seller is a shareholder in the company and wholly owned and controlled by the government of West Bengal. That's WBIDC. So purchaser seller clearly defined. At the time of its incorporation in 1985, HPL was promoted by WBIDC and the RP Goenka Group, with each having an equal shareholding.
Yes.
By 1990, the RP Goenka Group exited the project and was replaced by Tata Motors Limited and Tata Power Company Limited. So, initially West Bengal government and Goenka, then West Bengal government and Tata. HPL was granted industrial license in November 1993. On or about the second quarter of 1994, Dr. Purnendu Chatterjee evinced interest in participating in HPL. Accordingly, WBIDC, CPMC and Tata entered into a joint venture agreement dated 20th August 1994 to implement the Haldia petrochemical project through the company. HPL plant was commissioned by August 2001. Soon thereafter, the company was in dire need of funds, leading to a liquidity crunch. HPL was in need of financial and managerial restructuring. Well, all this is a part of the narrative of this agreement, so these are admitted by the parties. For achieving the object, that is for financing of the company, for achieving the objective, Government of West Bengal agreed to put CPMC in management and control of the company. So Chatterjee is to be put in management of the company in August 2001.
Yes.
For achieving the above objective, the Government of West Bengal agreed to put CPMC in management and control of the company and agreed to transfer such number of shares to CPMC so as to ensure that CPMC has 51% shares in HPL. On that date, this we are talking about in 2001, on that date, transfer of 155 million shares would have made CPMC 51% shareholder in HPL. Accordingly, the Government of West Bengal entered into an agreement dated 12th January 2002 with CPMC. Further, WBIDC, CPMC and CPIPL, an affiliate of CPMC, entered into an agreement dated 8th March 2002. So, my lord, the agreement to transfer 155 million shares, which would have given 51% control to the Chatterjee Group, is entered into in 2002.
Yes.
Now, my lord, I'll take your lordship to some of these documents later, but my lord, for the time being, your lordship will kindly see this agreement. Thereafter, my lord, post 2002, with the joint efforts of Government of West Bengal, WBTC and Dr. Punendu Chatterjee or CPMC, a financial restructuring was successfully negotiated with the financial institution led by the IDBI as the lead financial institution. A corporate debt restructuring package was approved on January 2004, 22nd January 2004, and formally placed on record by the CDR cell by its letter of 21st February 12, 2004. Well, here, Ladia Trade ITML, India Trade Mauritius Limited subscribed to 107 million equity shares worth 107 crores. Now, pausing here for a moment. So, in 2004, Chatterjee Group acquires 107 crore, 107 million equity shares.
Million equity share 107 in HPL.
Yes. Now, their understanding was they will acquire 155 million shares.
Correct.
Out of that, they acquired 107 million shares in 2004. Now, they are already invested in the company. There is no contemplation of any exit from the company by the Chatterjee Group. Now, thereafter, you will see, on July 30, 2004, the company, that is Haldia Petrochemical, CPMC, the seller, and Winstar, which is another Chatterjee entity, Limited, such and such, sub-account Winstar, income cell, SEBI, such and such, a nominee of CPM, entered into a share subscription agreement, which is called the Winstar Agreement, pursuant to which Winstar agreed to subscribe to equity shares of the company at par. Some other associate TCG were also allotted certain equity shares. So, we move on from 2002 to 2004, where the Chatterjee Group comes in and decides to make further investment through Winstar and other of its entities. So, Chatterjee Group through Winstar and other Chatterjee entities also subscribe to equity shares in the company.
7 crore shares, ITM,
Now, so far as this is concerned, there is an agreement to subscribe to 155 million shares. That agreement was still there subsisting. That agreement had not been given effect to still, because ultimately this led to disputes, we went to arbitration and so on and so forth. This acquisition of 107 million shares was beyond the 155 million shares. Agreement to subscribe to 155 million shares. But before that agreement is given effect to, before the 155 million shares under the agreement are transferred, independently, they agreed to acquire 107 million shares and thereafter further shares through Winstar and other Chatterjee entities. Then, your Lordship will kindly see, paragraph L. This is what we are talking about again, 2004. Further, CPMC, WBIDC, Government of West Bengal, the company, entered into a supplemental agreement dated 30th July 2004, by which certain terms of the January 2002 agreement were amended. This is the agreement for transfer of 155 million shares. The board of directors of the company in the meeting held on 2nd November 2004 decided to induct Indian Oil Corporation Limited as a shareholder. This is very, very important. So, IOL is supposed to come in because the company is under financial stress. IOC agrees to come in as a white knight to ultimately infuse funds and save the company. On 14 January 2005, representatives of Government of West Bengal and CPMC signed a one-page document which recorded that the Government of West Bengal shall sell its entire shareholding in the company to CPMC. The price of shares to be sold was to be determined by an independent valuer selected by Government of West Bengal from amongst the panel suggested by CPMC. Well, kindly mark this paragraph. This is of utmost importance.
We had total 675, 155 was in the
yes.
Now, total 675 million shares. 155 million shares is 2002 agreement.
Correct.
107 million transfers. And this is the entire balance lot of 520 million shares. So a one-page document is signed in 2005 by which CPMC agrees to acquire the entire shares. And what is most important, this acquisition is to proceed on the basis of a valuation.
Correct.
And the valuation is to be made by an independent value.
Correct.
So, my lord, 2002, 2004, 2005, there's an agreement that they will take over the entire shares. And how will the price of 520 million shares be arrived at? That would be arrived at on the basis of an independent valuation. Now, my lord, this becomes a very important issue, because ultimately the question that falls for consideration or fell for consideration before the tribunal was what was the consideration at which these shares were to be acquired. Was the consideration a consideration that was decided or fixed by a valuer in terms of the understanding in 2005? Was there a subsequent understanding as to how the shares would be valued, or how the price of shares would be determined? There was no further agreement. So it was to be determined by an independent valuer, and then without going to question as to how this valuation was therefore arrived, the tribunal comes to a finding. Now, after that, your lordship will see, here.
So what this one-page document says?
This one-page document is really in the nature of a memorandum of understanding, which says we will sell our shares to you, but the price will be decided by an independent valuer.
Okay.
I shall show your lordship these documents. I'm just giving your lordship the history of the transaction. Now, after that, if your lordship please has a look at paragraph O. On the same day, we are talking about 14 January 2005.
5 years.
On the same day, an extraordinary general meeting of the company was held, where the shareholders by an unanimous vote approved the resolution to issue and allot 150 million shares of the company to IOC. Now, this again is a very important issue, because when to seek a way out of the financial distressed condition, there was a decision to allot 150 million shares to IOC. This was opposed by the Chatterjee Group with all its force. He said, you cannot issue any shares because you have agreed to sell the shares to us at a valuation to be decided by an independent value. Now, this is, a resolution that is passed on the same day on which this one-page document is signed. Because the idea was, the company is in need of funds. We will proceed with the sale of our lot of shares, which will still keep you in majority control. But the company immediately requires funds, so issue and allot shares to IOC, because IOC has agreed to come in and put in funds. Then P, in or around July 2005, certain disputes arose between CPMC on the one hand and the seller and the government of West Bengal in relation to the sale and transfer of the entire balance shareholding of the company, aggregating 519,900,002 equity shares and allotment of 150 million equity shares of the company to IOC. In the course of the proceedings, the seller and government of West Bengal also disputed the right of CPIPL's claim to ownership of 155 million shares. Now, 2005 disputes arise. What is the dispute? The government of West Bengal says that you have not come in with the funds that you had promised. So we don't want to transfer the shares to you anymore. Although, in January 2005, the agreement was, two agreements entered into the same date. Government will sell its entire shares to CPMC Group at a valuation to be decided by independent valuer, and 150 million shares will be allotted to IOC. That was an agreement to which everyone was adhering. They were all agreed on this.
So with regard to N and O, there is no dispute.
No. Because ultimately it is on the same day that this is decision taken. However, later on during the same year, there are disputes where the government says that no, you have not performed your obligations. I will not sell the 155 million shares to you. And also, they say that no, you can't allot shares to IOC. This is the dispute that your lordship finds in P. So, this resulted in a dispute where 155 million shares were not transferred to IOC, to the Chatterjee Group, and 520 million shares were not transferred to the Chatterjee Group. However, the Chatterjee Group had already, acquired 107 million shares and some shares through other entities.
Yes.
And what is very important is your lordship will find at no point of time did the Chatterjee Group say that we want out, we want an exit. Please buy back our shares and let us go. Now, after that, please see Q. CPMC and its associates had initiated proceedings against WBIDC and the government of West Bengal under Section 397 of the Companies Act 1956 on 2nd August 2005. So, January to August disputes surfaced, and company petitions were filed. The aforesaid proceedings under Section 397 of the Companies Act culminated in a Supreme Court judgment on 30th September 2011. The 2011 judgment upheld the decision of the Calcutta High Court. The Calcutta High Court had ultimately said that no, you can't, ultimately this is not a dispute between the company and its shareholders. Well, this is an inter-se dispute between a shareholder wants to transfer its shares privately to another entity. So this is not something that could have been decided on 397 at all. And when the Supreme Court upholds that, that is a judgment, which is very oft cited in these kind of cases. And we come back to paragraph Q, which says that ultimately the disputes went on between 2005 to 2011.
Correct.
When 2011, ultimately the court said that no, we will not entertain this in the jurisdiction of the in the company jurisdiction under the company law board. Then after that, what happens is after 2011, after 2011, paragraph R,
yes,
CPMC invoked arbitration. Why? Because the company law board had said that no, we will not entertain this. The matter reached Supreme Court. Supreme Court said this is not within the company court's jurisdiction. So then they invoke arbitration. Arbitration is confined to what? 155 million shares. So they are very keenly pursuing the acquisition of majority stake in Haldia Petrochemical, from 2005 to 2011, before the company court, and then 2011 onwards before the arbitrator. After 2011, the Supreme Court judgment, CPMC invoked arbitration under January 2002 agreement. The dispute relating to the 155 million shares was referred to arbitration before the International Court of Arbitration of International Chamber of Commerce, Paris on 21st March 2012. Proceedings were initiated by the company in Calcutta High Court to restrain the arbitration, and the arbitration proceedings were restrained by the Calcutta High Court from May 2012. The matter was carried to the Supreme Court by its judgment dated 10th January 2013. Supreme Court, the Honorable Supreme Court directed the parties to contest their claims before the arbitral tribunal.
HPL had filed suit against them to restrain the arbitration.
That's not important. Then, the government of India, at this point of time, when the matter was before the arbitral tribunal, the Supreme Court ultimately said that no, arbitration must go on. But in the meantime, at paragraph T, your Lordship will find, Government of West Bengal initiated an open and transparent competitive bidding process in 2012 to offload its entire stake in the company to an entity capable of reviving and restructuring HPL. Pertinently, the company was in a critical financial position and in dire need of financial restructuring in order to sustain the livelihood of hundreds of thousands of people directly and indirectly dependent on the company. Now, kindly pause here for a moment. There's an agreement to transfer 155 million shares. That matter is now before the arbitrator. There was a one-page memo of understanding that upon determination of the valuation of the shares through an independent valuer, the 520 million shares would be transfer. That is what the government does not want to do any longer. The government wants to invite an independent bidding process and invite persons who are prepared to turn around the company. Very important, because turning around the company would mean two things. Acquisition of the majority stake of the government, and two is infusing all required funds. So it is not only ultimately acquisition or paying the value of the shares to the government, but also to infuse funds required for turning the company around. Now, thereafter, please see, T, Government of India initiated an open transferring bidding process in 2012 to offload its entire stake in the company to an entity capable of reviving. That is what it did in 2012. Then, paragraph U. Indian Oil Corporation was declared the winning bidder, having quoted a price of rupees 25.10 per equity share for the stake held by Government of West Bengal. The bid process and the steps taken pursuant thereto were challenged by CPMC before the Calcutta High Court in various proceedings and appeals therefrom. A list of legal proceedings pending before the Calcutta High Court under Supreme Court are fully described in Part B. Now, so what do we have here? In 2012, there's a bidding process. IOC, again expresses an interest. It is prepared to pay 25 rupees 10 paise per share. Well, your lordship will remember originally, well, the 155 million shares was to be transferred at par. Thereafter, 107 million shares was acquired at par. Now, my lord, IOC says, I am going to come and pay the government of West Bengal 25.10 rupees per share for its 520 million shares. And I'm also going to come and restructure the financial debts of the company. Well, because that is what would entail, my lord, follow the acquisition of majority shares. And this is challenged by Chatterjee Petrochemical before courts, vehemently challenged. And my lord, this is, my lord, a challenge that is pursued right through till this agreement is entered upon. So, my lord, what we have here.
So, what has happened?
No, my lord, that is, my lord, what is settled. Ultimately, my lord, disputes raised. Chatterjee says, I will not allow you to sell this 520 million shares to IOC.
Correct.
You have to sell it to me.
Correct.
We say that we will not sell these shares to you. In the meantime, there is a valuation exercise that is carried on through a tender mechanism.
Correct.
The price, the right value of the shares is arrived at through a tender process, 25 rupees 10 paise per share. But, my lord, they say we will not allow you to sell it to. And, my lord, litigations go on. In the meantime, the company is starved of funds and finances, and the company faces, my lord, a precarious situation where, my lord, it will ultimately, my lord, face insolvency. At that point of time, because, my lord, the agreement entered into, my lord, or the bid that was received from IOC was not allowed to be put through. My lord, the company was brought down to its knees. My lord, kindly consider, my lord, the company, my lord, is in dire need of funds. Everyone recognizes that, acknowledges that. Funds are to be raised, my lord, through a process. Initially, it was decided that there would be an independent valuation of shares. Now, my lord, independent valuation shares, what for what? To transfer 520 million shares to the Chatterjee Group. What would that mean? Chatterjee would have to pay the value of 520 million shares as determined by Indian valuations and would have to put in whatever funds are required for the purpose. Now, my lord, this agreement is an agreement which was struck in 2005.
Yes.
2005, they agreed that they would, my lord, ultimately infuse all funds required to rejuvenate the company. And they would also, my lord, pay the value of the shares to Government of West Bengal. Now, my lord, let us now, my lord, keep this in mind. My lord, when this was not being worked out, we, my lord, tried to do a public auction of the shares. Price, my lord, decided. They did not let it happen. Now, had, my lord, IOC come in, what would have been the scenario? That is a very important consideration. Had, my lord, IOC come in, then IOC would have, my lord, paid 25 rupees 10 paise for the shares, nothing more. My lord, no other obligations, my lord, taken over. It would have simply paid 25.10 per share, taken over the company, infused all necessary funds, and turned the company around. But that Chatterjee's did not let happen. Now, my lord, what is Chatterjee's case now? Chatterjee's case now is you were supposed to sell 520 million shares to me. I am supposed to give you 25.10 per share because that is the discovered price now. But against, my lord, the value that I pay, you pay me back 4 times the value through incentives. Lord, this is, my lord, what is the subject matter of the whole dispute. The question is, my lord, then, if this is a share transfer agreement or a share purchase agreement, and, my lord, the value is to be decided through my lord, independent mechanism, and that value is decided, and there is a buyer who was waiting in the wings to take over the company at that value without any incentive, without any commitment, without any further, my lord, ado, and, my lord, that buyer is not allowed to come in. Well, the question is, my lord, when you now say, I will purchase the shares at that value, then, my lord, are you supposed to get the shares at that value? Or, my lord, are you supposed to get much, 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 much more? So you pay 10 rupees, but you get back 100 rupees. That is essentially what the agreement is. And that is, my lord, where we talk about a rational interpretation of a commercial transaction, which, my lord, is titled a share purchase agreement. Now, my lord, here on, if your lordship sees, my lord, yes. Now, my lord, here, please see, my lord, you once again. Indian Oil Corporation was declared the winning bidder, quoted price of 25.10. The bid process and the steps taken were challenged, and, my lord, the list of, my lord, litigation. Then, my lord, V. In the meantime, the financial position of the company had taken a further downturn, and the accounts of the company were turning into non-performing assets with the lenders of the company. An urgent and limited restructuring was carried out to avert reference to BIFR under Section 15 of the SICA. The company, however, continues to face imminent danger of closure in case of no further action, no further infusion of funds for recapitalizing and for working capital needs. So, my lord, company, my lord, needs infusion of funds. Who is to, my lord, infuse funds? The person who acquires the majority shares. Government of West Bengal does not have the requisite funds, and that's why it's looking for an outside investor. And whether it is in this background, this circumstances, that my lord, this agreement is entered. My lord, this, my lord, has to be the key to understanding the agreement. This has to be
why
the
the agreement entered.
Yes. Now, my lord, in such a scenario where, my lord, the company is brought down to its knees, where the company would not have been in such a position had, my lord, it been able to sell its shares, my lord, in 2012 to, my lord, IOC at 25.10, nothing more, my lord, required, then, my lord, this situation would not have happened in the first place. Because strategies did not allow that sale to go through, this, my lord, is the situation. In such a scenario, Government of West Bengal has informed the Chatterjee Group, TCG, that in order to protect the overriding public interest, considered TCG's proposal of 1st March 2014 for purchase of 520 million equity shares of the company out of the Government of West Bengal's stake of 675 million, and in a broad understanding was reached, TCG has informed that it has agreed to purchase 520 million shares. Now, my lord, 520 million shares, while, my lord, the arbitration regarding 155 million shares is pending. So, my lord, TCG agrees to, my lord, acquire the 520 million shares, and, my lord, that acquisition, you will find from the next paragraph, is, my lord, on as is where is basis at 25.10. Parties have agreed that the Government of West Bengal shall offload 520 million shares to Chatterjee Group or its affiliates on as is where is basis at rupees 25.10 per equity share, discovered through the transparent and competitive bidding process. The total consideration comes to 13,060 million. 1300. It's about 1300 crores. Parties have agreed to bring to an end all legal proceedings except the arbitration proceeding before ICC Paris, pending before various courts and fora. The parties have now agreed to the terms and conditions based on which they are entering into this agreement for reviving and restructuring HPL. Now, my lord, here, well, the object is to revive and restructure HPL. There's no doubt about that. But, my lord, ultimately, this object is to be achieved through what? Through the transfer of shares, so that ultimately the new entity that comes in is able to, my lord, restructure the funds of the company. Now, my lord, it would be absurd to imagine that, my lord, ultimately, my lord, I say that please take over my entire shares for 25 rupees, which you will pay to me, and then I shall pay you back 2,500 rupees per share, my lord, through, my lord, the process of tax incentives and nothing. The question is, my lord, whether this could be a part of the agreement for sale and purchase of shares, or, my lord, whether this therefore was a separate, my lord, part and parcel, which was never a part of the share purchase agreement, because, my lord, that part would necessarily include Haldia Petrochemicals Limited. And, my lord, Haldia Petrochemicals Limited is deliberately not made a part of the dispute resolution clause or the arbitration clause, which is, my lord, confined to, my lord, two other entities, because that was a matter of giving incentives. And, my lord, when your lordship knows, my lord, giving incentives, two, my lord, considerations call for, my lord, two considerations, my lord, come forth. One is, for example, I, my lord, want you to set up industry in a remote area.
Yes.
Give a fillip to that area. I say, I shall, my lord, not charge you, my lord, certain taxes or give you some exemptions from certain duties. My lord, that is, my lord, a promise on which you act and you go ahead and set up your industry. There, my lord, the courts have held that the doctrine of promissory estoppel will apply, and, my lord, because a legitimate expectation is created. And the second is, my lord, I merely make a promise without wanting you to do any corresponding act, without, my lord, altering your position to your detriment, consequence on such promise. My lord, that is a promise, my lord, which is never ultimately a binding promise, because, my lord, that is a, my lord, intention expressed, but not, my lord, binding in the form of a contract or in the form of a, my lord, my lord, what do I say, my lord, an obligation ex contractu, my lord, which is not a part of the contract, but a part of a promise, which acquires some solemn, my lord, character.
Yes.
Now, my lord, this is, my lord, the background, and now, my lord, this agreement is entered into when in 2014. 2012 agreement with IOC finalized. 2014, my lord, this agreement is entered into. And, my lord, this agreement says that, my lord, on as is where is basis, at 25.10 rupees per share. And my lord, it also goes ahead to say that, my lord, so far as this is concerned, my lord, the object is to restructure the company. Now, my lord, the company is set up by the government. The government had initially, my lord, made certain, my lord, incentives available. They carried on these incentives for a period of time. Then, my lord, they stopped, my lord, giving these incentives because of, my lord, the intervention of GST regime, which did not allow for, my lord, the giving of such incentives or, my lord, returning back tax collected. But whatever the reason, well, ultimately the question is, my lord, whether A, my lord, this formed a part of the contract. B, whether, my lord, ultimately the non-giving of these incentives could be, my lord, woven into the contract and made a binding obligation, which the government would have to, my lord, ultimately secure or pay. Now, my lord, here, if your lordship will now come to, my lord, the recitals in the agreement. My lord, please have a look at, my lord, the clauses which follow. But before that, my lord, one thing is very, very important. My lord, the entire tenor of the agreement, I shall be citing to your lord before your lordships. My lord, what is the importance of recitals to the agreement? Because the recitals, my lord, set the tone of the agreement. They, my lord, serve to, my lord, identify the purpose of the agreement. They ultimately, my lord, are, my lord, recourse that may be made to for the purpose of interpreting the agreement. And, my lord, when interpreting the agreement, my lord, the last clause of the recitals becomes, my lord, extremely, extremely important, because your lordship has seen in paragraph X. My lord, kindly allow me, my lord, the cost of repetition, to place paragraph X once more. My lord, this is the agreement, because, my lord, what does it say? Parties have agreed.
Correct.
Parties have agreed that the government of West Bengal shall offload 520 million shares to TCG or its affiliates on as is varies basis. Now, my lord, this expression will have to be given some meaning.
Yes.
At a price of 25.10 per equity share. This will also have to be given some meaning. As is varies basis and 25.10 per equity share. These are, my lord, two expressions will have to be given meaning. Discovered through the transparent and competitive bidding process. Because the background your lordship has seen, IOC had, my lord, agreed to pay this and take over the company. The total consideration of such and such, my lord, this does not include, my lord, the 155 million shares. Now, therefore, so, my lord, it is because of this background, it is because of this, and this is the agreement, my lord, captured entirely in clause X, that the agreement is confined to sale of shares on an as is varies basis at 25%.
This is the cause of entering
Yes.
into the agreement, as per your submission. Yes. Then.
Now, my lord, here, my lord, pausing here for a moment. This, my lord, 520 million shares transferred, 1,300 crores paid. Agreement is really concluded.
How?
My lord, by the sale and transfer of the shares
Where
at
it
the
is?
consideration.
That's an admitted fact.
No, that's an admitted fact. My lord, there's
Okay.
no dispute.
Okay.
No dispute about that. So, my lord, we have sold 520 million shares, received the consideration of 25 rupees, 25.10 per share. My lord, that part, my lord, there is no dispute.
No incentive.
I'm sorry, my lord?
No incentive.
Yes. Now, my lord, the question is whether, my lord, then, my lord, the question of this incentive or a tax incentive, my lord, more specifically,
Correct.
is something that can ultimately, my lord, be the subject matter of the reference or could be made a part of the contract for sale and purchase of shares. Because your lordship has seen that Haldia Petrochemicals is kept out, and this tax incentive in any case would have been paid to Haldia Petrochemicals and to no one else. My lord, that is a very important matter also. So, my lord, here, but ultimately the question is, my lord, when the dispute is only between the purchaser and seller, can, my lord, ultimately the tribunal direct payment of money, my lord, to Haldia Petrochemical? That is the other part. Now, Haldia Petrochemical was not a party to the arbitration agreement and hence was not a party to the arbitration, did not participate ever.
Where from the incentive comes?
Yes, my lord. Now, my lord, here, if your lordship now sees, my lord, may I show your lordship clause 11 straight away? Yes. Now, my lord, here your lordship will find, my lord, before that, my lord, may I just show your lordship, my lord, a few representations, my lord, that have been made by the parties. I need to show your lordship, my lord, one or two other clauses. My lord, after the definition clauses, your lordship will find, my lord, this sale was supposed to be completed in 2 tranches. Well, at first tranche, they will purchase, pay us the money. Second tranche, they will purchase and pay us the money. Well, here, that is what is called the first completion and then the second completion. Now, if your lordship sees, there are certain conditions precedent that are required to be satisfied.
Clause
That your
11.
lordship will find at clause 3, page 366. Or before that, please have a look at. I shall not trouble your lordship with the definition. Please see clause 2, sale and purchase of the first tranche of sale shares. That is at page 365.
Yes.
So, the first branch, based on the mutual representations made, assurances, warranties, covenants, and undertakings given by the parties, and subject to the fulfillment of the conditions precedent provided in clause 3, which I shall take your lordship to, the purchaser shall purchase from the seller, and the seller shall sell to the purchaser 260 million, which is the first tranche sale shares, upon payment of the first tranche purchase consideration by the purchaser to the seller in accordance with the agreement. Pause here for a moment. The first tranche is to be made against the receipt of the consideration without no other attending feature.
Correct.
Nothing else to be done.
At this stage, the lordship up to 363. Just for complete 363 for this transaction. This first share again 25.
If your lordship will kindly once come back to page 363 in this regard. Here your lordship will find
What is the transaction?
1.1.33 per share consideration is specifically mentioned. 25.10.
No element of any.
Yes.
Now, apart from that, your lordship will find that 1.1.36 sale shares shall mean the first tranche sale shares and the additional sale shares.
Yes.
So, this is the consideration, to be paid for these, value of shares. Then, the transaction is defined. Your lordship will find 1.1.39.
Transaction.
Transaction means only, the sale and purchase of shares as specified under this agreement. So, this is the confine of this agreement. This is the limit of the agreement.
Yes. Yes.
And then 1.1.40, transfer includes any direct or indirect transfer, assignment, such and such, etc. But what is important is, the sale price is decided, transaction is decided, and transaction is only the sale and purchase of shares. Now, if your lordship will find, so far as the interpretation clause is concerned, 1.2, I don't want to trouble your lordship with that now. And then kindly come to the conditions preceded. These are the conditions which have to be achieved before the first tranche of sale takes place. That's clause 3. The obligation of the purchaser to purchase the first tranche sale shares is subject to and conditional upon the fulfillment prior to or simultaneously at the first completion or at the time specified below of each of the following conditions. So, these are conditions to be fulfilled by the purchaser, that is, by the Chatterjee Group, before purchasing the first tranche of shares, 260 million. The warranties made shall have remained true and correct with the same force and effect on the first completion date. Then, there shall have been no breach of the covenants. Then the company shall have obtained all requisite approvals in relation to the transaction from the requisite statutory authorities. Then 3.1.4, the company, seller, Government of West Bengal and purchaser shall have performed and complied with all agreement obligations and conditions required to be purchased and are complied with. Company shall have attended to and carried out all corporate procedures. Purchaser shall have received a certificate of a director of the company. Then, purchaser shall receive certificate of a director of the seller. Seller and the Government of West Bengal are not a party to any agreement, arrangement, understanding with any other person. There is a warranty. Then the company shall have provided copies of documents. Seller shall have obtained approvals of the sale of shares. Company, West Bengal, etc. Ensure that the existing debt of the company shall be restructured, refinanced by the company's lenders in such manner to ensure additional working capital. Now, kindly, for a minute, please look at 3.1.11. The company, TCG, where TCG is the Chatterjee Group.
Yes.
The seller and Government of West Bengal shall ensure that the existing debt of the company shall be restructured or refinanced by the company's lenders in such a manner so as to ensure that additional working capital facilities as may be required by the company to operate the plant shall be made available by the lenders to the company and ensure that the company is able to implement its capital projects in accordance with the business plan. Provided that Government of West Bengal, WBIDC shall not be required to infuse any further funds in HBL for the purpose of restructuring or otherwise. Well, this is extremely important.
Provided that yes.
So, Malad, here an undertaking, Malad, is or representation joint agreement is entered into by the Chatterjee Group, Malad, which agrees to acquire 520 million is that, Malad, the financial lenders will restructure the corporate debt. But, Malad, the government will not be, Malad, required to infuse any further funds.
Correct.
And then your lot will find, Malad, purchaser shall have completed within 30 days of restructuring, 30 days of the said restructuring the technical, commercial, financial, tax, environmental, legal due diligence. It is for them to, Malad, to company shall have not made any reference under section 15 of SICA. Outstanding loans with accrued interest granted thereon, such and such shall be converted into unsecured superior loan and would have priority over other loans of the company, including without limitation loans debts due to lenders. Now, Malad, this is again very important. Please, Malad, allow me to show your lordship here. Malad, it says that the unsecured, Malad, the loan shall be converted into unsecured superior loans. Malad, no further infusion by the Government of West Bengal, no further money to be paid. Till the first completion date, there shall be no increase in the total paid up equity capital. So, Malad, we shall not allot further shares to anyone else. CPMC shall ensure that other constituents of the Chatterjee Group, namely Winstar, CPIPL and ITML, agree and undertake to adhere to all obligations. Purchaser shall have obtained necessary approval from Competition Commission. Now, Malad, pausing here for a moment. So, the first tranche, Malad, which is to ultimately take place, Malad, following, Malad, the compliance with these conditions precedent, does not require anything to be paid by way of tax incentive or, Malad, by way of any incentive whatsoever. And, Malad, keeping in mind clause X of the agreement, which is 25/10 on as-is various basis, and the specific representation that the government will not be required to infuse any further funds, the question is, Malad, how are the obligations to proceed? Now, Malad, thereafter, Malad, kindly see, Malad, 33, Malad, provides for satisfaction of the conditions precedent. Malad, the conditions precedent your lordship has seen. Malad, I don't want to trouble your lordships because, Malad, the whole idea is not, Malad, to ultimately tie down the government, Malad, to provide anything more than, Malad, the company itself and to, Malad, act along with, Malad, the Chatterjee Group to restructure the debts.
Yes.
And that is because the government still retains, Malad, these 155 million shares, which is the subject matter of arbitration. Now, Malad, actions pending first completion. Now, Malad, let us see whether this imposes any obligation. Malad, your lordship find 4.1, Malad, there is again, Malad, no mention of any, Malad, incentive, tax, etc. that is to be given pending the first completion. From the effective date to the first completion date, the company shall conduct its business only in the ordinary course. The company shall give the purchaser prompt notice of occurrence of any event, condition or circumstance set forth in 4.2 from the effective date to the completion date. The seller and the company shall become aware of any event. So, Malad, if there is any such event that intervenes, I will let you know. And, Malad, 4.2 is what are the events that can intervene? The company will carry on business in the ordinary course. Without prejudice to the generality of clause 4.2.1, the company shall not, and the seller and TCG shall ensure the company does not, with the prior written consent of the purchaser, transfer and encumber, Malad, any of the equity shares, transfer, encumber, or dispose of, Malad, any asset, Malad, alter the number of directors, change the auditors, amend the charter documents, amend the financial year, so on and so forth. So, Malad, these are what precedes the first completion, and the first completion is, Malad, clause 5.
Yes.
Subject to the acceptance or waiver by the purchaser of the conditions precedent to the first completion. First completion shall take place within 15 business days following the issuance of CP satisfaction certificate or any other date agreed in writing between the parties. And then 5.2, First completion will not occur unless all obligations in clause 5 are complied with, and agreement to be consummated at the first completion shall be deemed to occur simultaneously. And my lord, at the first completion, my lord, what will happen? Government of West Bengal shall deliver a certificate to the purchaser to the effect that as of the first completion date, warranties are true and correct. Then, my lord, 5.3.2, purchaser shall, in accordance with applicable law, pay the first tranche of purchase consideration to the seller directly into the bank account. So, my lord, they pay it without any other obligation to be fulfilled by the government. The seller shall, on receipt of the first tranche consideration, give unconditional, irrevocable instructions to its depository participant to transfer
these
the
are the
first tranche.
conditions.
Yes. Now, my lord, all the time trying to show to your lordship is the first tranche of shares, sale of shares goes through without any other action being required to be performed by the government. Well, that is, my lord, what I'm trying to show to your lordship. Okay. Well, should I come back, my lord, on another day?
Yes.
Taking aside application of foreign international commercial arbitration, some agreement is 2014. Because the contract was performed even by the government until the GST came into operation. The history lecture is all right, but lordship to examine what the scope of
the contract was performed is, my lord, an object I take serious.
No challenge was given.
That
Yes,
the contract was, it was not a part of the contract at all.
That's a different matter. Incentive
that is what we are arguing.
Incentive was given. No, you are giving a history of 2005. Indian Oil did not come. This could have. That's a matter of history. Do 2014, nothing is relevant. But it can take time, Lord, because kindly want to appreciate this. Lordship heard this matter once in detail. Now, Lordship have to examine whether that judgment should remain or should go at the final stage, 34.
I am not in appeal against your lordship, Judge 36.
No, I'm not saying that. I'm saying, my lord, only thing I'm pointing out is the 2014, my lord, agreement. We are relying on 2014 agreement. P2014 history is not relevant. As an international commercial arbitration award, my incentive was given, my lord, up to 2017 until GST came. Let him answer on the point. It's an award, my lord. No challenge was ever given to this.
Okay, Mr. Shah. Mr. Shah, on the next date, you come with what are the grounds?
Yes.
Come with
Kindly
Kindly see, my lord. Here, my lord, it is very important. My learned friend may say, my lord, whatever he wishes to argue in his turn. But, my lord, very important is, my lord, this, my lord, background, which my learned friend says is not relevant. My lord, the Supreme Court has said is relevant. Your lordship's court has said it's relevant. It's relevant to understand the contract between the parties.
That's correct.
Which Supreme Court? Where?
I shall be citing it, my lord.
No, then kindly show the award and tell us how it's wrong.
With regard to
that I will do.
Please come with your grounds and come with what is the purpose in the order.
Let us come to the point.
Today, my lord, my learned friend is trying to, my lord, now to shut.
No, I'm not this admin, but it can't go on forever.
They may, but the court has to go.
With the greatest respect, my lord, this is a serious matter involving thousands of crores. And, my lord, today, my lord, your lordship has, my lord, only formed a prima facie opinion at 36 days.
I'm not talking lordship opinion at all.
Today, I have to argue, my lord, in the manner that I wish to, my lord, argue. If your lordship feels that I'm repeating myself, your lordship will certainly stop me.
Well, I'm
that's
telling
why, that's why you come
Yes,
with
yes,
what is your grounds, what is the purpose, what the tribunal
we must know.
But, my lord, for that, my lord, I will not be able to allow to place the contract.
You can place the contract, but with regard to the what are the grounds main you want to argue.
My lord, unless I show your lordship the background, my lord, as to how the contract came to be entered into, what were the circumstances, my lord, will your lordship, my lord, be able to appreciate that the tribunal, my lord, was correct or not?
Kindly give a short date, my lord. Just finish this matter, all right? Can't go on forever. Whether it be 1,000 crores, 5 crores, makes no difference. The legal point would remain the same.
Shown by them at 36.
Learned counsel for the petitioner has argued, petition number 2 has argued the matter at length, but due to paucity of time, hearing could not be completed. Let the matter appear on 9 September at 3 p.m. 9 September 3 p.m. 9th September 3 p.m.
Kindly just give me a moment. 9th September
at 3 p.m.
My learned friend, my lord, is requesting if it could be, my lord, on the 16th September.
No, then it should be advanced. Well, we'll come in near the vacation. How can the matter be over?
Complete. You will not be there.
No, I will be there on the 9th, my lord. 10th and 11th, I am not there.
Okay, 9th September you complete. Then we'll see to the AG.
I may not be able to complete on the 9th.
Not complete,
yes. I shall proceed.
With that. You continue.
I shall proceed with my arguments.
Yes.
Lordship, kindly try, my lord, in earlier date. It's a long date, my lord. 9th from today, my lord, we are only on the 20th of August. More than 2 weeks. Kindly, my lord, look at the diary once. If I may request you, Lordship, my lord. No, they want to delay the matter anyway.
Kindly keep it on the 9th, my lord. Before that, my lord, my learned friend will be in difficulty.
No, maybe, may not be, my lord. Everyone can't be, my lord. My lord, I'm in difficulty, someone else will be here.
My lord, kindly keep it on the 9th, my lord. Kindly do not advance it before that.
No, उसके बाद उसे continuous. 9 के बाद continuous. 9, 10. 10 कितना बजे? 11:30 और 12.
Just 9th,
Okay, I am fixing 3 dates. 9 September is 3 p.m. and 10 and 11 September.
10 and 11, my lord, I'm in Delhi, my lord. I will not be able to be there. 10 and 11, my lord, I have PLS fixed in Delhi. My lord, cannot be here.
15 and 16 September.
15 and 16 is already.
At 11:30.
Yes, my lord. I'm grateful.
I'm grateful.
Third, 15 and 16.
I'm grateful.
15 and 16, 11. And third, 9th on 3 p.m.
Grateful.
I'm grateful.
Very great.
11th.
For the respondent, my lord,
yes.
We have already concluded our arguments, and my lord, the petitioners are in reply.
Fire and principal Rotnankor matter. Our matter is Shanti.
Yes.
Or main taking. আমি আমার ছোট্ট আমার প্রশ্নটা বলি তবে তো ওই যে add upon the facts বেরিয়ে যেতে পারবো তাহলে না কোন প্রশ্নটা বলতে চাইছো তারপর কথা জানাবি দুটো কথা কোন কথা বল ওই ইউনিভার্সিটি দেখি
Yes.
Lord, one aspect of the matter, Lord, kindly give leave to Mr. Gupta to address your lordship. I'll take in 5 minutes time, Lord. I'll take over.
But with my learned senior friends, leave, my lord. On fact, we are in reply, but 2 documents I shall compare on facts, because the submission of my learned senior friend was that they had demanded money, we have paid that. So that does not mean that the contract stood modified. That is the sum and substance of the submission. And linked with that, the submission was that the learned tribunal did not consider the documents because they didn't find it relevant. Our case is that there has been an ignorance of vital evidence, which brings the matter within the 4 corners of section 34. Now, to buttress this point, that why documents were there, which the tribunal completely ignored, just 2 pages I shall show. We'll kindly have a look at page 108 of the first volume. The 2 pages which I shall be comparing with are my lord pages 85 and 108.
Yes.
If my lord kindly takes a look at page 85 first.
Page 85.
85 first, my lord. This is the minutes of the meeting. To that, the submission was that nobody from the end of the respondent was there.
Yes.
And nothing was agreed upon in writing.
Yes.
So, my lord, we cannot run a case that this contract was not modified. This is the argument.
That is the main.
That is the main argument. To that, my submission is that
they have acted in terms of the modified agreement, which would show that by conduct, the agreement stood modified. Why I say so? Lord, kindly takes a look at page 85. This is the minutes of the meeting. Kindly sees there are certain charges which were deliberated upon and agreed. Kindly sees the first head. Your Lordship would find in the middle of the page, electrical charges at the rate of 180 per square foot.
Yes.
Serial 2, generator charges at the rate of 50 per square foot.
Yes.
Legal charges at the rate of 30 per square foot.
Yes.
Then sinking fund 20 rupees per square foot.
Yes.
Property tax 25 rupees per square foot. Maintenance charges for 6 months 36 rupees per square foot.
Yes.
This is the first side of the first aspect of this. Kindly turns over to page 86. Kindly sees page 86. There is a small table.
Yes.
We are concerned with serial number 5, the respondent.
Yes.
Kindly sees there are 2 columns. Revised rate per square foot of the respective unit. It has been reduced from 2325 to 1666. That is the first heading, first column. Second is reduction in the rate of the car parking from 26 lakhs to 13 lakhs.
No, revised rate per square feet for
Has been earlier rate is 2325 per square foot.
respective unit.
Yes.
Earlier rate
2325 reduced to 1666.
Revised to 1675.
No, my lord, 1666. Last
The last
heading,
one.
NROL, my lord, serial number 5 reduced to 1666. That is, my lord, so far as the rate per unit. The next column is the parking, reduced from 26 lakhs to 13 lakhs.
Okay.
Now kindly sees the paragraph after that table. Since the completion certificate has been obtained, possession of the units for fit out shall be given with immediate effect, and the parties have agreed to commence fit out. Thereafter, common area maintenance charges at the rate of rupees 6 per square foot would be effective from, kindly marks this, 1st October 2012. This will be binding on all the parties.
Yes.
This 1st October is the date of the invoice. And kindly sees the next paragraph. Based on the above calculation, demand invoice would be raised on 1st October. And all the above parties have been requested to clear their dues to enable Bengal Sachi to execute transfer documents after execution of the supplementary agreement. So 2 things emanate from this. A, the rates were revised. Particular rates were ascertained, the LNG charges, sinking fund, and so on and so forth. Considering the interest which had already accrued till that point of time. So,
based on the above calculation, demand invoices should be raised.
On 1st October.
And all the above parties have requested to clear up the dues.
Yes.
To enable the BSHDL.
Yes.
To execute transfer document after execution of supplementary affidavit.
Supplementary agreement.
Now,
why this was agreed? Kindly turns back to 85, the last paragraph.
Yes.
Last 2 paragraphs. It has been specifically agreed that the petitioner, Bengal Sachi, shall not be required to procure tenants and or lease for the entire booked area at a minimum return of 13 point such and such % on the aggregate of booking amount, car parking amount, and extra as stated in the main agreement, and the said provision shall be treated as deleted, and all the parties concerned shall have consented in that regard, and accordingly a supplementary agreement would be executed between the parties, of which was circular and forms part of the minutes. Then next paragraph. In order to accommodate the interest of the parties, each of the party would be offered a concessional rate, that is 23.25 to 16.1666. Accordingly, the rate per square foot stood reduced for the following SBB customers under special scheme. Now, your lordship would not find these charges, these heads, once again, page 85, electrical charges, generator charges, legal charges, sinking fund, property tax, maintenance charge.
Yes.
These are the 6 heads, apart from common area maintenance charges. Your lordship would not find any of these heads in the main agreement, which starts at page 19. I need not trouble your lordship with the agreement. What is not there, I can't show it, so I need not trouble your lordship with that. Your lordship would kindly note that your lordship would not find any of these heads in the agreement dated 31st December 2006. So, my lord,
Where is the
Kindly
agree-
see, none of these charges are there.
Where is the agreement?
Page 19 it starts from.
19, 19.
Yes, 19. Kindly sees your lordship would search in vain. None of these charges would be there. These 6 heads.
Hmm.
None of them there.
Okay.
So, my lord, why did they pay on the basis of this? They say, I have been demanded, I have paid. Simple. But it is not so simple. They are not so naive. Kindly seize page 108. Kindly seize page 108. Kindly see the heads of the charges on this invoice. Exact amounts paid. Kindly seize electricity generation collection charges 21260. But I will file a written notes of argument where I have given the exact calculation. Kindly seize page 85. Electricity charges is 180 rupees per square foot.
Yes.
Into 11787, your lordship would find the saleable area at the top of page 108. Your lordship would multiply 11787 with 180. Your lordship would find this figure 21,21,660. And for every such head, we will give the calculation to my lord in our notes. I'm not troubling your lordship with that right now.
So you mean to say, though they have stated that they are not the part of the minutes of the meeting, it is not an agreement between the parties, so it cannot be taken as per their consent. So your contention in that they have acted upon.
Acted upon, paid exactly. The rates.
That's why you acted upon.
Acted
by raising invoices in terms
now
of
the arbitrator ignores this document like it never exists. The award is silent on the merits of this document. I could have understood the arbitrator saying that I've looked into this document, this is rubbish, nothing is deciphered from that. I could have understood. But if there can be an example or statutory example of ignoring vital evidence, possibly this is one. And your lordship would find each of the heading, my lord. Each of the heading as per the exact rate per square foot. Each.
Yes, next.
And on facts, nothing else. If your lordship kindly permits, my lords. And they have made payment that we have also shown, my lord. Kindly see page 254, exact payment. 254, just that one document, and I shall. Volume 2, page 254. Page 108, amount is 8739,824. Your lordship has seen. Page 128, 108. Kindly see page 254, their document, their exhibit.
Yes.
254 is the payment charge. They have seen. Kindly see towards the middle of the page. Your lordship would find a figure 8739,824. Paid on 6th of January 2013.
8739?
Page 251 here.
251.
254.
Yes.
If your lordship kindly sees this here. Exact amount 8739,824. Add new capital 6/1/2013. This amount has been paid. Exact amount of the invoice. Kindly compare it with page 108. Your lordship would find the exact figure. So, this really takes care of the submission that whatever has been demanded has been paid. This would not show modification. This is possibly too naive an argument to believe, my lord.
Okay.
Those are my submissions.
Thank
you.
After my senior friend finishes, Manoj, since he has argued on fact, I'll give a one-sentence reply to that. Just one sentence reply. What more?
Lord, so far as the arbitral award is concerned, Lord, the ground of perversity, as Lord laid down, Lord, in Sangyong and thereafter in Delhi Metro Railway Corporation, is that considering irrelevant evidence, no evidence, and ignoring vital evidence. Lord, our case falls within the scope of ignoring vital evidence. Now, Lord, Lordship remembers, Lord, we had handed over a chart to your Lordship of the documents that were placed before the tribunal and arguments made, not considered.
Now, my lord, the response to that on the part of the respondent, the claimant before the arbitrator, is that is the arbitrator required to consider every document? If there are 5,000 documents produced before the arbitrator, is the arbitrator required to consider all 5,000? My response to that is, if there are 5,000 documents placed before the arbitrator and 20 are relevant, and these 20 have been argued before the arbitrator, and what has been argued is on record before your lordship because the minutes are there. Those 20 have to be considered. If we can demonstrate that those 20 are vital, because it's ignoring vital evidence. I'm not, in my respectful submission, we have demonstrated that these documents, which are in that chart which we have handed over, to which there is no dispute that they were not considered, they are vital evidence because they demonstrate that the parties have acted on the basis of a modified agreement and not the original agreement. Now, the question also arose is whether the document could have been modified otherwise than by a signed writing. Now, the document which my learned junior showed your lordship is the record of a minutes. The understanding between the parties is an oral understanding. The record is in a document. Now, we had shown your lordship will remember, Proviso 4 to the Section 92 of the Evidence Act. Your lordship kindly takes, Lord, Proviso 4 to Section 92 of Proviso 4 to Section 92 of the Evidence Act. This exact situation is contemplated by the statute.
Section 92.
Section 92, Lord, Proviso 4.
Yes. Existence of any, okay.
The existence of any distinct subsequent oral agreement to rescind or modify any such agreement, contract, or disposition of property may be proved, except in cases in which such contract or grant of disposition of property is by law required to be in writing or has been registered according to the law in force for the time being as to the registration of documents. This document is not by law required to be in writing, according to my learned friends. It is also not a registered document. Therefore, by an oral agreement, it can be modified. We have furnished evidence that the modified oral agreement has been acted upon. The documents that we have furnished are in demonstration of the fact that they have been acted upon. They evidence the fact that the modified agreement has been acted upon. Therefore, this is vital.
Yes.
Now, the arbitrators could have considered it and rejected it. Had they considered it and rejected on merits, then my door to Section 34 would have been closed. But the ignorance of vital evidence allows me, Lord, to canvass the point, and to that there is no answer from the side of the claimant.
Okay.
Now, this is one part of, Lord, our argument of ignoring vital evidence. And Lord, your lordship remembers we had relied upon Associated, Ssangyong, and Delhi Metro Railway Corporation.
Yes.
Now, Lord, one aspect of the matter is, which my learned junior argued, and may I just point out to your lordship, he told your lordship that the payment has been made in terms of the modified agreement and not the original agreement. I'll just give your lordship the two figures for your lordship's convenience. If payment had been made in terms of the original agreement, the amount would have been 3,43,58,233. Now, if your lordship just note this figure.
Connection, original.
Original, as per the original agreement, 31st December 2006.
Yes.
The figure would have been 3,43,58,233. 3,43,58,233.
Yes.
Payment actually made, Lord, as per the document which my learned junior showed your lordship, is 2,53,32,334.
253,
2,53,32,334.
334, yes.
Now, Lord, if my learned friend's case is that it is the original agreement of which they are seeking specific performance, then, my lord, they are in breach. Because admittedly, from the document my learned junior showed your lordship, they have not paid the balance amount.
In terms of the original.
In terms of the original agreement.
This is the statement of the case also. Article 33.
Accident. Now, Lord, if your lordship is pleased to take the CD 28 volume 1 and your lordship is pleased to take the document which my learned friend showed your lordship, CD 28. At page 285 of volume 2.
Yes.
Your lordship will find total amount payable as per the agreement.
343, 58,
343, 58, 223.
Yes.
Towards the middle.
Yes.
And the amount actually paid is the next portion below that. Payment details as under. And if your lordship adds up this, right till the payment which my junior showed your lordship of 87,39,824, the amount your lordship will get is 253,32,334. 253,32,334.
Then 56 year interest.
And your lordship will find that.
Now, where is the 253 paid?
Lord,
that is the total amount payable as per agreement 343.58. That is the 285.
Yes, Lord.
And paid amount, payment details under.
Payment details under, if your lordship adds these up.
Okay.
And I'll give your lordship, they have also given the figure 253,32,334. Lord, please turn the page over. And please come to the next page, which shows the payment.
Yes.
And right at the bottom, your lordship sees actual capital amount.
Yes.
That is the amount.
253.
Yes. Now, Lord, please also, Lord, have it confirmed from the statement of claim.
Page 16, para 33 of the statement.
Please see, Lord, paragraph 33, your lordship will find this amount also there. Page 16, paragraph 33.
Yes, 253.
Lord, page 16, paragraph 33. Now, Lord, on this, Lord, I have two submissions to make.
Yes.
That if, as per the modified agreement, it is 253, and they have paid 253 in terms of the modified agreement, then their entire case falls and the arbitral award has to be set aside. Now, if they succeed on the fact that they have to make payment in terms of the original agreement, and your lordship is not with us on the modified agreement, then they are in breach of payment
Not paid
of the
the
original
total
agreement.
amount. By
If-
not paying the total amount.
By not paying the total. If they are in breach, then they cannot seek specific performance. Party in breach cannot seek to enforce the first agreement by claiming payment in terms of that. So either way.
Yes.
Secondly, my lord, your lordship will find that insofar as the claimant is concerned, I've shown your lordship 253 is the amount that they have paid. Their pleading is and their evidence is that they have made full payment. Your lordship will find from the evidence of their witness that they have made full payment.
The full payment they are treating at 2 crore 53.
2 crore 53.
Page 286.
Now, Lord, if your lordship please comes to statement of claim, page 7, volume 1, page 7. Volume 1, page 7. And Lord, please come to paragraph 9.
Yes.
Lord, please see the pleading, Lord. Pursuant to the said agreement, claimant made full payment in respect of the said unit. So 253 is according to them the full payment. Therefore, I have admittedly acted in terms of the modified agreement and not the original agreement. Otherwise, it is not full payment.
Yes.
There's one other aspect, Lord, their evidence. There's one gentleman laid evidence, Sanjeev Dalmia. Your Lordship sees volume 2, paragraph 36 of his affidavit evidence at 276. Volume 2, page 276.
Yes.
This is paragraph 36.
Yes.
And Lord, please see in the middle of that paragraph, it says the portion is yet as a good gesture. Lordship sees that.
Yes.
Claimant has calculated the amount in this affidavit starting from the date 6 January 2013. That is the date when the claimant made the last and final payment. So admittedly pleading and the evidence adduced by them is that 253 is their final payment and last payment. It can only be in terms of the modified agreement. This has been ignored by the arbitral tribunal. This is where, Lord, our argument was that we come in because of ignorance of vital agreement, vital evidence.
Yes.
Now, Lord, the other argument made by the respondent before your Lordship is that one is, should everything be considered? Second is, we have paid whatever was asked of us. This runs contrary to their avowed case that they have made the last and final payment.
Good.
So once it is last and final payment, is not paid only what we have asked or just because we have randomly asked a figure, but because they also acknowledge this is the last and final payment. Now, this is one part of the argument with regard to evidence. Then, Lord, our second argument was with regard to section 28 registration. Now, Lord, on this section 28 of the Arbitration Conciliation Act with regard to evidence, ignoring substantive law. Now, Lord, here the argument was the document is a document of investment, not a document by which there has been any transfer of title in the property. Therefore, it does not require registration. Not in my respectful submission, this is not perhaps the right position of law, because section 17 of the Registration Act does not require a transfer. Any contingent or future transfer of interest is also sufficient. Interest is also sufficient. So, Lordship, for a moment only has a look at section 17 of the Registration Act. Just for a moment, Lord. Section 17(1)(b). Other testamentary instruments which purport or operate to create or declare, please ignore the rest, whether in present or in future. Section 17(1)(b).
Yes.
Whether in present or in future.
Yes.
Any right, title or interest.
Whether
Again, whether vested or contingent. So if the contract has any covenant which creates any interest in future or a contingent interest, that document also requires registration. I'm not saying that it requires to be stamped as that of a conveyance, but it requires registration. Lord, duty to pay stamp duty and a duty to register a document or an instrument are two different aspects, and under two different statutes, and both are not mutually one is not dependent upon the other. I'm not on the revenue in terms of the stamp duty. I'm on the fact that it requires registration, and if not, it cannot be used as evidence in terms of section 49. If it could not have been used as evidence, then Lord, the entire claim also falls flat.
But initially you're not objected for this.
Lord, this was the argument made. See, it has not been objected to. Now, the issue of raising an objection, and if I don't raise an objection, the objection being waived, is a position of law under the Stamp Act. Under the Stamp Act, if at the time that the document is being admitted into evidence, I do not raise the objection, I cannot raise it again. That is why I am not making any argument on Stamp Act. Although Lordship remembers we had made an application.
Correct.
The
You have
tribunal
made an
and it was argued.
application. You have made an application. Subsequently, you not raise objection, and it will continue.
And we had argued we had argued
No,
the
no,
application.
there is no argument. Kindly come to the. There is no argument on that. Can you see the award?
No, the award records that there is the minutes will record that argument has been made. Your Lordship is kind enough to take the minutes of the meetings, which are part of the records with your Lordship.
Page.
Lord, if your Lordship please takes volume 4, my Lord.
170 आगे application था और 7 देवे ना minutes 170 का application था
No, minutes to देखिए argument.
7
volume 5
volume 5
Yes.
volume 4 আছে রে volume 5 কেন লিখেছি প্রত্যেকখানে লেখা আছে volume 4 তা দেখি এটা কোনটা
minutes तो बात करी दीजिए
Lord, just a second. Lord, if your Lordship is pleased to take the submissions made at the 14 January 2021 hearing,
page,
which is at volume 4, page 635.
Yes.
And Lord, please come to Lord. Page 642. Your Lordship will find paragraph 18
Yes.
deals with this aspect of the matter. Paragraph 18 and next page, Lord, paragraph 19. 18 deals with the stamp issue and 19 deals with registration. না না এটা আর্গুমেন্টে কোথায় আছে দেখো না না আর্গুমেন্টে রেকর্ডেড কোথায় আছে Lordship has seen Lord paragraphs 18, 19, 20 and 21.
Correct. 21. Yes. Now 21, I filed an application taking the aforesaid points of demurrer.
Yes.
The respondent's argument on merit and accordingly without prejudice is right in contents.
Now, Lord, even Lord, the tribunal has rejected the point, but the point that your Lordship has raised is with regard to waiver or estoppel on the ground of stamp and registration. Now, insofar as stamped is concerned, if not the tribunal is of the view that you ought to have taken the point at the time of admission of the document, which was what was argued by Mr. Ghosh, then that affects only stamp duty, not registration. Registration is an absolute bar in terms of section 49.
Okay.
Lord, if your Lordship please takes the Stamp Act for a moment, and if your Lordship is pleased to take Lord, section 36 of the Stamp Act, it is by reason of section 36 that if my learned friend is right and the tribunal is right that I ought to have taken the point even earlier than my application,
yes,
then it is barred in terms of section 36 of the Stamp Act.
Correct.
But there is no equivalent provision under the Registration Act because it's an absolute bar under the Registration Act.
Yeah. Yes. Because 683,
Yes, my lord.
the finding of the arbitrator.
Yes, my lord.
The last argument argued the gravity relates to admissibility of the agreement dated 30th on the ground of seeking the transfer of the land. Neither the said contention is sustainable, first the document has been exhibited and relied by both the parties without any objection from the relied by both the parties without any objection either of the parties. Secondly, the agreement dated it itself provides a clause 11 that the parties should enter into a formal agreement for sale subsequently.
The tribunal, so far as stamp is concerned, as I said, no, I'm not
Correct.
troubling. So far as registration is concerned, the tribunal proceeded only on the basis that it contemplates a formal agreement for sale. That is for transfer of title in the property. But my argument is that even if there's any interest created of any nature whatsoever,
Okay.
whether contingent or in future, that itself is sufficient.
Okay.
And I've shown your lordship the provisions of the agreement, which creates interest in the property, because they say that they are booking a particular flat, they're booking car parking spaces. The fact that they're entitled to a conveyance in future creates an interest. The fact that they're entitled to lease rent from tenants of that portion of that area also creates an interest. And their claim in the arbitration is because you could not acquire tenants for me, and those tenants could not pay rent to me. Therefore, I'm claiming this from you. So that itself is an interest in the property, because the rent arises out of the utilization of the property, the immovable property, which is more than 100 rupees. So this was my second argument, which argument to this extent has been ignored.
Okay.
My argument is not that it transfers title in the property. Now, the third argument which we had made is with regard to limitation.
Yes.
Now, the third argument is with regard to limitation. Your lordship will find that the claimant says that he has made his claim from 6th of January 2013. Lord, 6th of January 2013, your lordship will find in the statement of claim itself, and from his evidence, the portion that I read out to your lordship. Now, that portion of the evidence of Sanjeev Dalmia, which I just placed just now, Lord.
76, page 276.
The lordship is pleased to come to Lord, page 276, where he says, paragraph 36, as a good gesture, claimant has calculated the amount in this affidavit starting from the date 6 January 2013.
Yes.
Now, Lord, the notice under section 21 was issued, Lord, on 6 June 2018. So, Lord, our argument is, even if you have a valid claim, even if the original agreement exists, substantial portion of your claim is barred by limitation.
13 to 18, 5 years.
And Lord, the tribunal holds that because it is compound interest, there is no limitation. That, Lord, cannot, in my respectful submission, be not appreciated, because then that means for 500 years also there will be no end of limitation, merely because it is compound and not simple. It's blatantly barred by limitation. Not the last point, Lord, which we had argued, to which perhaps there is no defense and no argument, is variation between pleadings and the proof. Lordship remembers in the SOC, this was amount that was claimed. In the evidence, this was amount that was claimed. In the award, this was amount was awarded. Completely different. And your Lordship remembers there's a chart which shows difference between what they have claimed in the SOC, what they have proved in the Evidence Act, and what was granted. Not very important. Lord, one last thing before your Lordship rises, please give me only 5 more seconds. Lord, please come to the award, the last portion of the award. I won't disturb your Lordship more than 5 more seconds.
1 second.
Lord, if your Lordship please comes to paragraph 30. Lord, if your Lordship please comes to page 684.
Yes.
Lord, kindly come to paragraph A.
Yes.
The money claim made by the claimant in terms of various clauses of the agreement dated 1st August 2007 is valid, though not the quantification of claim as pleaded in the statement of claim. Therefore, the tribunal itself holds that you have not proved your
Quantification is
claim
not
case, then kindly see. The correct computation of such claim has been set out under the heading award herein below. The particulars of the claim by the claimant in its computation sheets handed over the hearing and a copy whereof is appended with the award. With the award, there was no computation sheet. There is no evidence on the sheets handed over, or no attempt to prove that. They brought in a witness. But when the witness came and the witness's case was completely disbelieved, at the time of arguments, they produced a chart. Nobody has produced the chart and the chart is not part of the award. So on what basis will a lordship hold that these amounts are proved?
Yes.
The award does not contain this appendage, if I may use the word appendage. It's not part of the award which was served upon us. It's not part of the award. We've taken the point. In their opposition, they have not annexed this chart saying that this was part of the award. You have not disclosed it. So whatever be the other grounds, the award has to go because of lack of evidence on the amount awarded. Tribunal itself says your claim is something else, you have proved something else. At the time of argument, you produce a chart. We are annexing that chart, we are awarding in terms of that.
Yes.
No discussion on how or why the chart is correct. And their SOC is to be rejected, their evidence is to be rejected, our arguments are to be rejected, and the chart is to be taken as gospel truth. Which chart, nobody knows.
Yes.
Number two judgments have been cited by Mr. Ghosh. Both the judgments are only on the point that your lordship will not sit in appeal, but the grounds of section 34, if they are satisfied, then your lordship will interfere on the grounds of public policy.
That is settled.
I have argued only on points of public policy, Lord. These are my.
Thank you.
Your
We
lordship
filed a note by Monday, Lord.
by Monday.
You don't want to file it by Monday.
Yes.
And then give us
Whichever
another
day-
week.
whichever
Malad.
day-
No problem. No problem.
Only one thing, I came late, Malad, but my learned friend said this. No, there's no discussion in the award that.
Reply to reply.
No, that full payment, etc. Paragraph 26 it's recorded that learned counsel for the respondent, as Mr. Sen, argued with much ingenuity that that whole thing is
ingenuity
no,
was shown 51 times already.
no, but it's just now it was submitted. It's not considered. Paragraph 26 to 28. That point is considered. Registration point is also considered in paragraph
No, I'm not saying,
34,
no, that might
where
not
it
got
is
it
said it is argued with the least amount of importance. And now my learned friend says, see. In minute number 320, I have argued.
Greatest amount of attention and
No, only with regard to the law point, which my Mr. Sen has argued, the agreement, the minutes of the meeting,
yes,
which is stated that you have not signed. So it has
Yes.
not been taken into
He's
consideration. But
saying
you
that-
but he has made a submission that he has acted. You have acted
Yeah,
upon.
it's a self-serving argument. He has said that we have taken this much money, therefore it shows that this agreement was modified. I'll come myself and pay him more money if he wants. This thing. That is also dealt with in paragraph 34. But I don't think mentioning is
Counsel for the getting concluded.
You can extend.
Getting concluded. Counsel for the parties are directed to file their written notes of argument. की तारीख 20 1st of September 2025. This is the matter on 1st September 2025 under the heading to be mentioned for filing written.
7th, my lord.
1st September.
When I'm back on the 1st.
When you back?
Tomorrow I'm going. I'm back on the 1st.
Your first
So 1
then
week, your lordship. Give us on the 8th of
8th
September.
of September.
Great.
To be mentioned for filing.
They are not so busy on this side.
Yes.
Sorry, Malad. After 2, Malad is not going to take up Malad the commercial matters. So that the Admiralty matter, Malad, where the decree was passed and Malad was pleased to pass an order of injunction. Malad, the interim order, Malad, is still today.
But now that is changed. Administrative matter is changed now. Not of this court.
Not with this. Malad, this is the execution. Malad, not the administrative.
Maybe. Because that time the commercial court was there, the administrative
Malad,
has
the
not
matter is
been
appearing in the list today, Malad. Item 47.
But I think just 10 days before the determination is changed.
Oh, Malad, definitely.
Specifically, administrative has been given to some other court, Justice Kapoor.
Oh.
No, Justice Mukherjee. Sorry.
Sorry, Malad.
Justice Mukherjee.
Oh, Malad, we were not. It's Malad appearing, Malad, as item.
Milord, I was opposing that prayer.
You don't know who you are. You don't know. You're a
I am
You didn't do us
I am the person against whom he executes the decree, which
No,
I've
we
not
are
even
on
signed.
the defendants, my lord, no one has come back to us, my lord, saying that anyone's appearing. It's item number 47, my lord, today. And the order, my lord, was still today.
47 क्यों यहाँ रखा उन्होंने से मेरा ऑर्डर नहीं है ना जी का order है। जो भी है so I am releasing then you mentioned before Justice Mukherjee I think so I have not
My lord, I'm Admiralty execution, I don't know, my lord, whether that will be a separate, perhaps, my lord, it will be the same.
you give the that determination
কিন্তু নাও তোমরা ডিটারমিনেশন জানো না কি হচ্ছে আমাদের এখন ডিটারমিনেশন দেখতে হবে clueless.
just 2 weeks before that has been changed.
I'm so sorry, my lord, my junior should have really, my lord,
all the admin
because it was appearing in the list, my lord, I was under the impression, my lord, that
fine just a minute action नहीं है नहीं admiralty का है और वो लेटर है कहाँ है हमारा
তাহলে দুটোর সময় ওখানে মেনশন করো
डिटर्मिनेशन आया था ना क्या करते because I am releasing what can be done
my lord, if the determination is not there, my lord, I can't, my lord, but I wasn't.
okay I will see in the lunch then some of the junior come I will pass.
Very well. My beer anyway here, my lord, I have that first
Yes,
matter.
we'll also be there at 2 p.m.
I will see
Very
item 12 let me in my office my
Very well,
determination
very well. My lord, we'll come back at 2 p.m.
Item 12, the interim order is still today.
12
Yes.
Item 12 is that famous Dwarfim matter, my lord. Yes, my lord, kindly have a look at your lordship's order of 8th August. But kindly consider this. Well, I will not say anything beyond this.
Let it remain in the list, my lord. We are ready to argue, my lord.
you are appearing for whom
I appear for the plaintiff.
Well, I am only
No,
restricting my submissions to 6 and 7. And in your lordship recalls, my lord, the notes of argument was filed on 2nd
you
of
filed
May.
you have filed
We have
with regard
filed notes. We have completed.
We have filed.
filed so I will dispose of with regard to the 6 and 7
No, well, this is where I join issues.
because otherwise nothing will be done now
But it's there in the list. my lord. Today, tomorrow, whenever it's
I will
taken.
dispose of the 6 and 7
Let
because
the
appellate court order is there this court has to comply with
But there's no fault on her part. my lord.
what can be done not your part but one or the see when the matter was taken only 2 respondents come forward for argue one
Your
is the
lordship will close their arguments.
one
my lord.
with, one with regard to 6 and 7 and one is with regard to the 10
Yes.
then I pass
So
them
your
on.
lordship will
now,
my lord, what I was humbly beseeching, your lordship will kindly give.
they've argued. I
My
have
learned
argued,
senior
they
friend
have
says
filed-
after this order he will not make any submissions. My lord, my only contention is that
rebutting to
my
what
lord,
you're saying.
my only contention is that
Isko
it's not
kal-
that we have not done the matter. If the
Let
other
it be fixed
defendants do not,
tomorrow has to be mentioned
if the other defendants do not agree,
come tomorrow has to be
but
mentioned
it's still today. The interim order is still today.
No, I have no objection in extension of the interim order. We'll let
interim
the
order
judgment.
interim order is extended till 2nd of September 2025 or until further order. Let the matter appear tomorrow as to be mentioned only with regard to us to be mentioned. Let it be seen.
If the other defendants do not agree, then close. Will
That's
close.
why
We'll
let
file
it
the
come
notes.
tomorrow as to be mentioned.
Yes.
Yes. Anything?
Could-
Okay, that's why I'm keeping tomorrow. If anybody is telling we will not argue the matter, then I will fix.
Well, only thing.
If anybody is telling that they will argue, then I will fix the matter for order with regard to the other
Yes.
some of the respondents who completed. Then with regard to the other respondents who are not argued, then it will go.
Only one prayer due to medical emergency of Mr. Upadhyay tomorrow. Could it be on Friday? my lord? There's
Friday gather to be mentioned.
there's a medical urgency.
To be mentioned. Okay, Monday rakh do, to be mentioned. Monday, please, Mr. Bosu, you also ascertain who are there.
Yes.
If they do not argue, your lordship will close it.
Grateful.
Deeply.
My lord,
Which matter?
Lord, item
let me, Mr. Mitra, my lord.
Lord, item 1 is appearing at my instance.
Yes.
My lord, kindly have the last day's order once. There is one typographical error, my lord. In paragraph 1, it has been recorded that we are appearing for official liquidator. It will be, my lord, applicant appellate, not official liquidator, in the last day's order, my lord.
Okay. That's all.
And my lord, the main 10F appeal, which is APO, my lord, that has to be, my lord, fixed on a particular day. But my lord, there is a difficulty at our end. My lord, this was initially filed by, my lord, a firm of advocates. After that, my lord, there has been a change. My lord, we have not yet been able to obtain a no objection from the erstwhile firm whose Vakalatnama is on record. And these are very old records. So, my lord, all that we were submitting is, my lord, a direction be given on the registry if possible to accept the Vakalatnama, and we shall also, my lord, do a inspection as to what level.
First you have to tell whether you are appearing in the matter. Once you are telling that you are not having the record, second you are telling that you have, want to inspect the record. You are having the Vakalatnama.
My lord, with the leave of Mr. Mitra, my lord, may I address, my lord? My lord, we have a Vakalatnama, my lord. The only difficulty, my lord, is that the erstwhile advocate, my lord, who had filed the main 10F appeal, my lord, that firm, my lord, the advocate's firm, my lord, is possibly not existing, my lord. We have taken some due diligence on our end, my lord, that's not existing. So difficulty is that,
So
my
why
lord,
you mention?
my lord, the only reason, my lord, it's only to save this court's time, my lord. It's not ready for hearing, my lord, and we have also inspected, my lord, our own records. This main 10F appeal, my lord, is connected with several other applications, my lord. Some of the applications, my lord, we don't have records, my lord. The court may have so, my lord. I'm only seeking, my lord, kindly gives us, my lord, 3 weeks time. We'll do the necessary on our end, my lord. We'll do our best, my lord, to obtain the NOC, my lord, if it is possible, my lord, for us to obtain it, and my lord, we'll inspect the court records and fill up, my lord, whatever deficiencies there are on our end.
I am for my lord, some of the respondents. I'm not standing in the way, but technically my learned friend cannot appear today also.
And that's
Yes, that's exactly what your lordship was pleased to. Now, my lord, our difficulty is also, my lord, that we don't have any paper, my lord. We have written to them for copies of the papers.
That's why when the paper publication has come, the Calcutta High Court is having the much higher pendency. Then I find that 130 of the company matters of 1968, 1978, all the things are of the company matters. Then I inquired from the official liquidator, it is pending for the liquidation since 1968, 71, whatever it is. Okay. The matter is listed as to be mentioned on as per the prayer made by the counsel for the applicant. Counsel for the applicant submitted in the order dated 30th July 2025. The learned advocate is appearing for the applicant and not for the official liquidator. But inadvertently in paragraph 1, it has been recorded that Mr. Shaunak Mitra is appearing for the official liquidator. In view of the above, in the order dated 30th July 2025, in paragraph 1, it should be recorded that Mr. Shaunak Mitra, an advocate, is appearing for the applicant instead of official liquidator. It is submitted by the learned Mr. Mitra that some other firm was appearing on behalf of the applicant, but it is not possible for him to take no objection from the earlier firm, and as such he prays for leave to file fresh Vakalatnama and also to inspect the record of the instant case. In view of the above, the applicant is the advocate on record of Mr. Mitra is given liberty to file a fresh Vakalatnama and to inspect the case record within 2 weeks from date. Let the matter appear after 2 weeks. You will also inspect. You will also inspect
My lord, yes, my lord.
you are appearing for?
for valid respondents.
The counsel for the respondent also prays for inspect the document. According, both the parties are given liberty to inspect the document within 2 weeks.
Because Bernard, it's extremely voluminous. It's a 2015 matter. That's why we should have to check. If we need to reconstruct, we'll reconstruct.
Okay, 2 weeks within check.
Yes, yes.
Submit.
We have pointed it out to them also by letter that, my lord, there is a change of name of the company, my lord, the respondent number 1. That they have to take steps.
Okay, let us check the record, then come.
Yes, and I'll take steps, my lord, if necessary. Grateful.
Yes, call the matter. After 2 weeks, ना तो आज क्या तारीख है? 22 है, 20 है, 10 तारीख को रखो. 10 September.
10 September.
Yes, that matter.
My lord,
Determination is not with me, so I am releasing that. Commercial, the admiralty suit.
No, the execution, my lord, I thought my lord was with my lord. Oh, I've
Except admiralty, so that's why.
very well, my lord will mention it.
Relating to मैं तो white कर दे रहा हूँ.
Except
Relating to admiralty, relating to.
But execution of decree.
That's why.
My lord, execution of decree, my lord, perhaps my lord is
Commercial Courts Act देखो.
commercial division, right?
That's why when this
What
determination has come, then when the determination has come, I clarified from the office. They are telling them that we cannot say
Because,
anything.
my lord, this was filed, my lord, in the commercial division. Original side, my lord, as my lord, execution application.
Execution तो covered.
Clarify.
Commercial Courts Act.
Commercial court का एक दो उनका.
Commercial Courts Act.
Take this.
So this is now the from 7th August. This is the.
हाँ सेटा ठीक আছে, but where will execution go? Is it covered or not under?
It's. My lord, I thought execution, my lord, will be my lord with my lord.
That's why on that day I have taken the matter
Yes.
because it is a commercial and
Correct.
and I have seen the cost title of the earlier proceedings.
Yes,
So that's
yes.
why this court has taken on that.
But this is my lord, of course, my lord, an execution commercial number. That's why my lord has. July te ki chilo dekho.
आगे ताई छिलो. देखो.
This was the same thing. Motions and hearings of matters written to.
My lord, that day also, my lord, we find. My lord, this matter was taken up only, my lord, because it's a execution, my lord, commercial.
Because at that time admiralty was not specified. That time the admiralty was not specified. So this court has taken as a commercial. No, admiralty has been specified now after the 7th August determination. Because what has happened, someone, I think Mr. Mukherjee has appeared in a recent admiralty matter. No, some urgent matter was moved.
Yes.
So this confusion was arose. So
Yes, correct. But my lord, I am only on, my lord. We'd like your lordship to hear it also, my lord. I'm just seeing if we can get a execution out of it. My lord, kindly give me, my lord, 2
The
minutes.
only difficulty, my lord, is that the interim order.
today is the interim order.
Today, my lord, it.
Execution का देखो ना. क्या देखो? Does execution fall under?
This is Raj Judge. एक होता है jurisdiction होता है. July मास jurisdiction होता है.
July मास.
होता है. My lord has all matters relating to commercial division.
That's why I've taken that. But now this has come, I don't know. But and in that the admiralty has been given, but commercial has not been given. In that the determination is given to other court, but the commercial is not given.
Correct.
So admiralty with regard to the commercial.
That day, my lord, we were. My lord, correct.
That day I was.
That's right.
That day on this court was having
all commercial matters were before my lord.
Today also all commercial matter, even the determination, but only with regard to admiralty that we don't know.
My lord, I don't know, my lord, if we are quite happy, my lord. I'm sure, my lord, Mr. Mukherjee, my lord, also will have, my lord, takes up the matter, but my lord,
Happy will not do.
no, my lord, if there's no jurisdiction, there's no.
Correct, that is the problem.
The 7th August is. There seems to be, my lord, a 7th August, there's
7th August. So release. What can be done? 47.
Anything you do, I have no problem.
I'm quite, my lord,
I am
the
believing
matter
it
is
mentioned before the court. If Dutch court will say, then
very.
47.
47.
The Leonard Senior Mr. Ratnanko Banerjee mentioned the matter and submit that the interim order is only till today and plead for extension of interim order. This court find that this court and this execution case is connected with the admiralty suit, and as such, this court is not having the determination. Thus, the matter is released from the list of this court with the liberty to the parties to mention before the court having determination.
Look, since my lord has passed the order, but we can, my lord, now, my lord, go and mention, my lord, the. Great.
इसको अभी करके दे दो, करके वो अपलोड कर देगा, उसको अभी कर दो.
One hopes, my lord, perhaps, my lord, will again, my lord, be here so that, my lord, because we have substantially argued the matter.
তারপরে execution
Execution কিছু বলা নেই. But my lord, execution matters also coming before my lord.
Execution commercial is coming here. All
commercial matters are before my lord.
suits, execution.
Except now it seems with the 7th August, the admiralty commercial has, and very well.
That is
তোমায় দেখাচ্ছে আগে
Now 7th August to change.
7th August. That is the only difficulty.
Admiralty with commercial বেরিয়ে গেছে কিন্তু কমার্শিয়ালটা বেরিয়ে গেছে ওটা তো কমার্শিয়াল হিসেবে এসেছিল এখানে.
But that is not mentioned regarding to the commercial.
7th August there's a departure with regard to that.
Yes.
That's
Yes. ওটা 3টের সময় রেকর্ড
কখন করব 3টে
হ্যাঁ
একবার বলে দাও.
My lord, I am just saying, my lord, that so that I don't miss out on my fees to mention that matter at 3 p.m. My lord, I'll be before your lordship.
Okay.
আচ্ছা আগের দিনের অর্ডারটা কি 3 pm বলা আছে না 2 pm বলা আছে?
2 p.m. Order 2 p.m. Check 3. We realized there was a 3 p.m.
Yes.
Now, my lord, I was, my lord, on my lord, the family company aspect, my lord, I have, my lord, made my submission, cited the cases.
Yes.
Kindly come to paragraph 7. My lord, there were 3 sets of allotments. My lord, your lordship recalls, my lord, 1995, 2009 and 2011. My lord, which were, my lord, challenged. Kindly come to, my lord, the 1995 allotment, my lord.
Page.
Paragraph 7 of, my lord, the impugned order. Your lordship will find that, my lord, in the memorandum of appeal. Kindly take the memorandum of appeal.
Yes. Paragraph 7.
Yes, my lord. My lord, the petitioners have challenged the impugned allotment of shares in 1995 on the ground that the sole purpose of such allotment was to take away the negative control of the petitioners group.
Yes.
Lordship sees, my lord, it's already set out, my lord, in the judgment, my lord, about, my lord, the shareholding of petitioners group,
Yes.
which was 30.80%. That's at paragraph 5. Now, my lord, however, the petitioners could not defend their case of rejection of application for allotment of shares, which was defective on the ground of such application being made on joint shareholding without mentioning PAN number of the applicant, which was a mandatory requirement for filing such application. So, my lord, here, my lord, it is said that, my lord, if there was, my lord, a second applicant, my lord, for, my lord, the shares, then PAN number had to be given,
Yes.
and PAN had not been given, and that was a mandatory requirement. As regards the loss of negative control of the petitioners group, reliance has been placed in the case of Clemens and Clemens. However, in 1995, petitioner number 1 and 2 held 10.14% and 6.96% of the then issued, subscribed, and paid up capital of the company. Therefore, there is no loss of negative control of the petitioners group as a result of the impugned allotment. Now, my lord, petitioners group, my lord, is, my lord, kindly come, my lord, to paragraph 5 at page, my lord, 18. My lord, page numbers are at the bottom of the order.
Yes.
My lord, kindly take the last 5 lines. However, it has been observed that petitioner number 1 held so-and-so shares comprising 10.14%. Father of petitioner number 1, namely Padmanand Garg, held 30,242, that's 13, prior to his death in 1999.
Yes.
And petitioner number 2, mother held, my lord, of petitioner
6.96.
number 1 had held 6.96 prior to, which aggregate to 30.80. And in para 7, kindly now have a look, my lord, what is being said. My lord, that, however, in 1995, petitioners numbers 1 and 2 held so-and-so of then issued capital and paid up. Therefore, there is no loss of negative control of whom? Petitioners group as a result of. My lord, ignores that 30.
Yes.
30 point, my lord. This is clearly, my lord, over 25% petitioners group had.
Yes.
The case of Clemens is distinguishable because in that case, there were only 2 shareholders and a closely held family company between an aunt 55% and a niece 45%, unlike the present case where there are numbers of shareholders and directors, some of whom are outsiders. It is also pertinent to mention that articles of association in Clemens' case contained a negative covenant that provided non-transfer of shares unless a family member declines to accept the same, which is not the case. Thus, relevant cases of no assistance. My lord, I pause here. Clemens and Clemens was a case where, my lord, and I'll cite it, my lord, the aunt, my lord, had, my lord, majority. My lord, the niece, my lord, had just above 25%.
Correct.
My lord, a restructuring of the company was taking place by which, my lord, employee shareholders would be, my lord, inducted. So, my lord, that was challenged by the niece, saying you can't do that because by doing that, you will dilute my 25% shareholding. And the court said, yes, that is oppressive. My lord, if, my lord, my negative control is being taken away, it's a valuable right, my lord, of my group which is being taken away. My lord, there can be additional grounds, but this by itself, my lord, was a ground in Clemens and Clemens.
Okay.
Now, my lord, so, my lord, first 2 things. My lord, 1, my lord, is on a question of fact, my lord, this order is contradictory. My lord, paragraph 5 says over 30% shareholding. Para 7, my lord, says not even 25%. Clearly contradictory. And, my lord, it talks about petitioners group. Petitioners group in 1995 had over 30%.
Yes.
And, my lord, here, my lord, only 2 shareholders are being considered. Third, my lord, even in law, my lord, it's a wrong application, my lord, of Clemens and Clemens, which I shall, my lord, show. And the third, my lord, thing, my lord, which is being decided here, and this is important, is that, my lord, PAN number was mandatory, and because it was not there, it got rejected. My lord, the conduct has to be judged, my lord, on the basis of equitable consideration if it's a family company.
Correct.
If I'm right in that, then even if it's contrary to law, you should give me an opportunity to cure. Because company is supposed to be in need of funds.
Correct.
It will help the company if more funds come in.
So
Now, my lord,
technicality cannot be taken.
correct. Then, my lord, kindly come to, my lord, para 8. In order to establish that there is no application of law of limitation in the case of the petitioners, the following cases have been cited. Then, my lord, the petitioners did not challenge. Now, my lord, we have 3 cases cited here. Did not challenge the impugned allotment within limitation period as prescribed in law, which is 3 years. Now, my lord, first point, my lord, which has to be decided,
Limitation.
did the Limitation Act apply? to, my lord, proceedings. Yes, to the Company Law Tribunal, Company Law Board. My lord, the present act, my lord, makes it, my lord, applicable. Kindly see, my lord, Companies Act 2013, my lord, section 430. Sorry, 424. 433, my lord. Kindly see 433. Without the old act. Now kindly see, my lord. 433.
Yes.
The provisions of the Limitation Act shall, as far as may be, apply to proceedings or appeals before the tribunal or the appellate tribunal, as the case may be. Now, my lord, in the Companies Act, my lord, after its amendment, my lord, and my lord, giving the jurisdiction which had been vested in the High Court to the Company Law Board, my lord, there is no provision, my lord, in the Act which said limitation will apply to proceedings before Company Law.
Okay.
Now, my lord, they go on to hold, my lord, that mention the petitioners did not challenge the impugned allotment within as prescribed in law, which is 3 years. So, my lord, according to, my lord, our case, my lord, Limitation Act did not even apply.
Yes.
In the case of ABP, my lord, which was cited, my lord, 142 company cases, it has been held that wrongful allotment of shares can have a continuous effect so as to support a case of this nature. However, it is an admitted position in the instant case that post, so my lord, here, my lord, first is, my lord,
Post 95.
yes, my lord, first is whether Limitation Act applies at all. My lord, therefore, my lord, this, my lord, finding that, my lord, was not challenged within limitation period, my lord, is, my lord, wholly, my lord, without, my lord, basis in law, because there is no limitation period.
Yes.
Second, my lord, is, and this is important, in the case of ABP, it has been held that wrongful allotment of shares can have continuous effect so as to support a case of this nature. However, it is an admitted position in the instant case that post 1995 allotment, petitioner number 1 and 2 have continuously accepted dividend based on their changed shareholding without any opposition, and thus have acquiesced to the same, and accordingly are now is stopped from raising any. So, my lord, it's a case of, my lord, you have acquiesced, you cannot challenge. Now, my lord, I am entitled to 10,000 rupees dividend, my lord, on the basis of my old shareholding. My lord, my shareholding remains the same. My percentage reduces. My lord, is it to be suggested I should never receive dividend? My lord, if my shareholding had gone up, I would have received more. If I receive less, am I acquiesced from saying, am I stopped from saying that I'm entitled to more? I could have understood, my lord, that, my lord, an allotment has been made. And, my lord, on that basis, my lord, I get more than what I'm entitled to.
Whether you claim further more?
My lord, I have said 25%, you restore it to 25%,
When?
30%.
When?
My lord, that has happened, my lord, in these proceedings, as well as, my lord, talks of settlement, my lord, paragraphs which have been ignored, my lord, in the petition.
Okay.
I have shown that, my lord, it was a family company.
Okay.
My lord, the grandfathers were talking. My lord, one generation above, father of petitioner number 1, father of respondent number 2.
Correct.
They were the people, my lord, who were, my lord, talking.
Yes.
Then, my lord, what happens? My lord, my shareholding, my lord, they say it's going to go up, it will be taken care of, it's not taken care of. So, my lord, when that generation, my lord, passes, the settlement doesn't happen, which I have, my lord, given that document. My lord, I showed it to your lordship, my lord, on the last occasion, that Kothari document for bringing about a settlement.
Okay.
Then, my lord, once that fails, my lord, so, my lord, acquiescence has to be, my lord, something more. My lord, I am owed, my lord, 20,000 rupees. I'm paid 10. If I accept 10 and don't say it's in full and final settlement, my lord, can it be, my lord, acquiescence?
Okay.
I'm getting less than what I, my lord, deserve. Then, my lord, similarly, in the case of AG Kolho, the issue is on similar line but the factum of acquiescence by the aggrieved party was absent in that case, and therefore the said case is also not applicable to the facts. Insofar as the case of NR Shah is concerned, the delay of 5 years was discounted. Now kindly see, as it pertained to a family-owned company and the parties were trying to settle issues, unlike in the instant case where there has been a delay, and on top of that, petitioners have acquiesced to the shareholding by accepting dividends and therefore no reliance. So, my lord, if I'm right in my submission that it was a family company, one of the grounds goes out for distinguishing my lord NR Shah. And my lord, here in view of the above, the petitioners have failed to make out any case against the rights issue of shares made in 1995, and therefore no interference is called for in this regard. So, my lord, let us see, my lord, the 6 points, my lord, which have been made, my lord, to reject, my lord, my case of 1995. Now, kindly come to, my lord, paragraph 12 of, my lord, the petition. This is, my lord, page 92, my lord, volume 1, my lord, before your lordship.
Yes.
My lord, in or about October 4, 1995, the company came out with a preferential issue in the ratio of 1:1. The application form had spaces for 2 names. One was marked for first holder and the other was marked for second holder. The petitioners and many other shareholders filled the names of first holder and second holder in the respective blanks. Out of a total of 1.9 lakh shares subscribed by shareholders, 98,564 shares applied by petitioners and other shareholders were rejected on the ground that the second shareholder's name should not have been mentioned in the application form, since only the first holder is entitled to the new shares on offer. This was number 1. Number 2, another alleged reason for rejection of the application of petitioner number 1, who was a co-promoter and executive director, was that PAN number was not stated in the share application form. A copy of the application form and letter of rejection are annexed here too and marked so and so. The application of the, now my lord, kindly have a look at, my lord, page 227 of volume 1. My lord.
Yes.
My lord, kindly see, my lord, the application form 227. My lord, it's to the board, number of equity shares applied for, and now, my lord, kindly see, my lord, at the right hand side, my lord, bottom, PAN stroke GR number, if any, with circle ward district in the application is for face value of shares of rupees 50,000 more.
Yes.
My lord, that is in the form.
Yes.
This is the form of application. My lord, both shareholders have filled in their names and both have signed.
Correct.
My lord, Ritu, my lord, is, my lord, the wife, my lord, of petitioner number 1. Now, my lord, the application, now kindly come back, my lord, to, my lord, the pleading. The application of petitioners and other shareholders were rejected with ulterior motive and malafide intention. Lordship has that, my lord?
Yes, yes.
Yes. My lord, and the shareholding of petitioners were reduced from 33 to 22, and the shareholding of 2 and his group was increased from 33 to 49. Share application money of the petitioners was also refunded. Money had been given. At that point of time, the father of the petitioner number 1 was critically ill. The petitioner number 1 had questioned the father of respondent number 2 as to the wrongful rejection of the share application. The father of respondent number 2 assured the petitioner number 1 that share application for tax had been rejected for tax purposes and that 50-50 partnership basis would continue between two branches of the family. No, father of respondent number 2 also assured petitioner number 1 that shareholding petition would be treated as 50-50. Now, my lord, kindly come to, my lord, I showed your lordship, my lord, 226 and my lord,
227.
227, my lord, kindly come to 226. My lord, after it's rejected, my lord, we, my lord, had, my lord, asked for, my lord, reasons. And this is being written to petitioner number 1.
Yes.
This has reference, I'm sorry, my lord, rejection of your share application. 226.
Yes.
This has reference to your letter dated 30th November 1995, asking for specific grounds on which your share application has been rejected by the board. As you are aware, at the board meeting held on 30th, on the basis of resolutions passed at the annual general meeting, it was decided to reject all applications which were incomplete, invalid, defective. The specific grounds inter alia on which a share application has been rejected are as follows. In the register of members, in folio 58, you are the sole holder of 22,376 equity shares of the company. However, in the share application form, Ritu Garg has signed as joint holder. This is at variance with what is stated in folio 50 of register of members and contrary to resolution. Income tax permanent account number is not stated in the application, though application has been made for allotment of so and so. So, two grounds for rejection. There's one folio, my lord, one shareholder under that folio, and my lord, so there couldn't have been a joint, and my lord, PAN number, my lord, has not been given. Now, my lord, kindly, my lord, have a look at, my lord, the resolution. Where is the resolution? Yes, my lord, kindly take, my lord, 539, volume 3. My lord, this is, my lord, the board of directors. My lord, meeting of 14 July 1995.
Yes.
Lordship has that?
Yes.
My lord, the typed copies at, my lord, 539A might be easier to read.
Yes.
Now, my lord, the secretary informed the board that the company's bankers, United Bank of India, has suggested to increase the paid-up capital of the company to enable them to consider further enhancement of working capital facilities. Company also needs additional funds to meet its operational expenses. The board, after discussing the matter in depth, decided to issue equity shares to all existing shareholders in the ratio of so and so. And kindly note this, also allot the unsubscribed portion of equity shares in such manner as it may determine. Therefore, it was resolved. Now, my lord, kindly see on the following terms, etc. And my lord, to whom? To my lord, all those whose names are on the register of members on 29. My lord, the third condition also have a look. In the case of any undersubscription or unsubscription, the undersubscribed or unsubscribed portion of any would be aggregated and allotted to those who have applied for additional shares in such manner as the board may determine. So, my lord, discretion, my lord, was with the board. There is, my lord, no mention. Then, my lord, kindly come to page 540, my lord, if you, which is 540A.
Yes.
My lord, the board is authorized to dispose of the shares which remain undersubscribed or unsubscribed even after allotment against applications for additional shares in such manner as the board may determine. Now, my lord, this is very important. My lord, if the intention was not to reduce me, my lord, I had made an application which was being rejected on, let us say, PAN not there, some, my lord, additional shareholders' name being mentioned, they still could have allotted to me when I have, my lord, expressed, my lord, an intention, my lord, to subscribe because I put in the entire money and company was in need of funds.
Yes.
My lord, this is also. Yeah. My lord, then the new equity shares allotted shall rank pari passu in respect of existing, except that new will be entitled to pro rata. Then, my lord, kindly next see the next one. Resolved further that for the purpose of giving effect to the above resolution, the board is authorized to settle any question of difficulty, or it should be or difficulty that may arise in regard to the issue and allotment of new equity shares, and to do all such acts, deeds, things as may be required. So, my lord, the resolution which is passed, my lord, does not mention anything about PAN number, my lord, in, my lord, the resolution itself. Let us say they give us a form which requires PAN number to be mentioned, and, my lord, I have, my lord, let us say applied jointly with my wife, my lord, for, my lord, the shares to which I am entitled to. They say, sorry, in the register of members only your name is there, therefore only you can would have made the application, not with your wife. Now, my lord, board, my lord, has, my lord, the authority, my lord, to, my lord, ensure that, my lord, this is given effect to and settle any question or difficulty. What do? They, my lord, say, sorry, these are mandatory requirements. There is no law that this is a mandatory requirement. But, my lord, they say it's a mandatory requirement and we are not permitting this. But, my lord, large portion remains unsubscribed. So, my lord, company was in need of funds. On that basis, my lord, they had done a rights issue. Rights issue would have brought in over 1 crore. Now, my lord, what do? They could have then said, look, we reject it, but we have under
Complete
3.
this,
Yes, I could have gone under 3. So, if you are willing to, we are now willing to give you this.
Correct.
No application in these rights issue forms were required. My lord, they don't even do that. So, my lord, this, my lord, point of, my lord, rejection, my lord, is bogus.
So
then
this,
what happens?
This minutes of the meeting of the which date?
My lord, this is
90
July. My lord, on the basis of which the rights issue, my lord, is made.
July 95. And
July 95.
And rejection was?
Now, my lord, kindly come to, my lord, 15th of September 1995.
Yes, up to that.
Yes. Now, my lord, kindly come to, my lord, 30th November 1995. Now, my lord, as desired by you, vide your letter dated 30th November, I am enclosing certified copy of resolutions passed at a meeting of the board held on 30th relating to issue of shares. Now, my lord, kindly come to 542. This is very important, my lord. Kindly seek, my lord, 542, my lord, clause, my lord, 1, agenda item 1.
Yes.
The secretary tabled the file containing the individual share application and also the statement showing inter alia the names, address, number of shares applied for on 1:1 basis or lesser number of shares against the letter of offer made to the existing shareholders of the company, duly initialed by the chairman for the purpose of identification for consideration of the board. The chairman tabled the legal opinions obtained from reputed solicitors, advocates, wherein it was inter alia stated that applications which are not in accordance with the special resolution passed at the 44th annual general meeting, the letter of offer, and are contrary to record and or register of members of the company cannot be considered complete and hence liable to rejection. So, my lord, some opinion is, nothing is there, my lord, otherwise. An opinion is obtained to, my lord, reject. The board perused all the papers, documents tabled, and the secretary was required to note whether each application was valid or invalid in the remarks column. Thereafter, the board passed the following resolution. So and so is approved and each applicant is, etc. Then, my lord, resolved further that allotment advice, refund order at allotment money due notice be issued to respective applicants and that allotment money at the rate of so and so be payable on 30th being last date fixed for payment of or within such time as may be extended. Resolved further that where application money exceeds the amount payable on the shares allotted, that may be adjusted against allotment money. Resolved further that share certificates be issued to shareholders who have paid in full the money due on allotment. Now, my lord, kindly note, my lord, something, my lord, very important is happening. My lord, entire price of the shares is not being taken on the first day. It is, my lord, whatever, my lord, once the shares are allotted, first, my lord, is, my lord, what is due on allotment. So, my lord, this is now, my lord, what is happening. Now, kindly note, after that, my lord, after that resolution, resolved further be issued to so-and-so. After that, next line, my lord. My lord, after the
Rajiv Garg, yes.
Mr. Rajiv Garg, director, opposed the resolution in writing and a note of his dissent was made. So it wasn't accepted at the meeting. Petitioner number 1 said that this is my dissent.
Yes.
Now, my lord, kindly see consideration of additional shares. The secretary tabled the statement showing inter alia name so-and-so applied for on additional basis against letter of offer made to existing shareholders duly initial. The board perused the same and after discussing following resolution, resolved that matter in a subsequent, it will be taken up. Now, my lord, the third issue, my lord, which was, my lord, otherwise, my lord, if anything is unsubscribed,
Yes.
then, my lord, whether it would be given or not. My lord, they had an opportunity to, my lord, I've been knocked out because of a technical default. They could have, my lord. There's nothing on that.
So third issue was not decided.
Not, my lord, not even pursued. Because, my lord, our case is, it transpired that, my lord, they, my lord,
Yes.
that, my lord, actually, my lord, what transpires is, my lord, once that new majority, my lord, is being created,
yes,
and, my lord, we, my lord, lose our negative control. Because, my lord, their shareholding, my lord, really went up to, my lord, 49%, I believe.
yes,
My lord, by reason of this allotment. So, not an absolute majority. So, my lord, really, my lord, no creation of a new majority as such. But, my lord, they themselves, my lord, their shareholding went up, my lord, significantly. And, my lord, our negative control was lost.
yes.
My lord, that was, my lord, the purpose. My lord, at page 520 of volume 2, my lord, I have given, my lord, the position. So, my lord, we went down to 22 from 32.04, and, my lord, they went up, my lord, from 33.65 to 49%. My lord, the second, my lord, second line, my lord, in the table.
Yes. 36, 49.
My lord, kindly see, my lord, last two columns. My lord, the first, my lord,
Shareholding.
32.04 went down to 22. That was our shareholding, Rajiv Petitioner Group.
Correct.
And, my lord, then, my lord, Praveer Group, my lord, they were 33.65. They went up to 49.
49.
My lord, once that is achieved, my negative control is gone. My lord, then, my lord, quiet us. Now, my lord, so in my respectful submission, my lord, this, my lord, exercise of discretion,
yes,
or, my lord, the decision taken, my lord, was, my lord, unfair. My lord, I don't have to say it's in violation of law. My lord, it was unfair.
Okay. Yes.
My lord, if it is unfair and it's a family company, my lord, it cannot, my lord, remain. Now, my lord, what happens? My lord, the next thing. Then they say, my lord, I come to Clemens and Clemens. Now, kindly have a look at, my lord, Clemens and Clemens. My lord, 1976. To All England Report, 298. Sapna aur clock on me.
Yes.
268. I'm sorry, my lord, 268. My lord, kindly come to 280, my lord.
Yes.
My lord, your lordship sees the heading, the law. Now, my lord, I'm just placing, my lord, two paragraphs under this section. The first, my lord, is for the plaintiff, that's my lord, the niece, it was submitted that the proposed resolutions were oppressive since they resulted in her losing her right to veto a special or extraordinary resolution, and it greatly watered down her existing right to purchase Clement shares under Article 6. So two grounds of oppression were urged. One is, my lord, my negative control is going because special resolution I cannot veto. And second, my lord, is I have a right of preemption, my lord, which will also be, my lord, diluted. Now, my lord, kindly come to my lord, paragraph my lord, page 282. My lord, heading is conclusion.
Yes.
Kindly see, my lord, that portion. I do not doubt that Miss Clemens is in favor of the resolutions and knows and understands their purport and effect. Nor do I doubt that she would genuinely like to see the other directors have shares in the company and to see a trust set up for long service employees. But I cannot escape the conclusion that the resolutions have been framed so as to put into the hands of Clemens and her fellow directors complete control of the company and to deprive, now my lord, kindly see, the plaintiff of her existing rights as a shareholder with more than 25% of the votes and greatly reduce her rights under Article 6. So, my lord, one right, my lord, 25%, another is diluting the right of preemption.
Correct.
They are specifically and carefully designed to ensure not only that the plaintiff can never get control of the company, but to deprive her of what has been called her negative control. This is, my lord, whether I say that these proposals are oppressive to the plaintiff or that no one could honestly believe that they are for her benefit matters not. A court of equity will, in my judgment, regard this consideration as sufficient to prevent the consequences arising from Miss Clemens using her legal right to vote in that way that she has. And it would be a right for a court of equity to prevent such consequences taking.
Yes.
So, my lord, though there was no legal embargo, my lord, negative control would be lost, amongst other things. My lord, fact that negative control, my lord, was being lost, my lord, should have been, my lord, prevented. So this, my lord, was an act of, my lord, oppression, my lord, and this was also a family company where, my lord, the balance of, my lord, more or less equal shareholding was also, my lord, being disturbed. Now, my lord, what is important is, now I come to limitation. Now, my lord, after 16 years, my lord, could I have challenged this?
Just a minute.
Release করে দিবো। চারটে চারটে হ্যাঁ সাড়ে তিনটা আমাদের ইয়ে আছে
Upload. Yes.
Now, my lord, one very important aspect. Now, when deciding, my lord, on limitation, the next thing is, my lord, three cases, my lord, was cited.
Yes.
My lord, to say, my lord, that number one, the Limitation Act does not apply. And number two, to say, my lord, that an allotment of shares, my lord, if, my lord, the effect, my lord, continues. So even if Limitation Act applied, my lord, the, my lord, petition could have been filed beyond, my lord, 3 years. Now, my lord, kindly see, my lord, I've shown your lordship how, my lord, that is dealt with in paragraph 8. Now, kindly have a look at, my lord, the judgments, my lord, which we, my lord, relied on. My lord, first is ABP my lord, this is, my lord, reported in 142 company cases, 688. My lord, kindly come to para 25. I have considered the pleadings and arguments of counsel. Media West and the petitioners have filed their written submissions also. Before dealing with the allegations relating to allotment of shares to media and appointment of its 4 nominees as directors, I shall deal with certain issues relating to maintainability of the petition. And my lord, Shri Dave relying on the decision in so and so, that there should be continuous acts, etc. Now, my lord, kindly take 5 lines after that. Even though this contention as a general proposition is valid and correct, Lordship has that, my lord?
Yes, yes.
Yet this board has consistently taken the view that in case of allotment of shares, even if it is a single act, since it has continuous effect, allegation relating to the same can be entertained in a petition under section 397. In the present case, both the allotment of shares as well as change in composition of the board will have lasting effect and as such can be agitated in a petition so and so. In this connection, judgment of the Calcutta High Court in T brokers may be referred to, wherein also such a decision has been given. Therefore, the ratio of Shanti Prasad cannot be applied in the present case. Then, my lord, so my lord, this was, my lord, the position, because my lord, it's a continuous act. It has a continuous effect. So, my lord, there's no question of limitation.
Yes.
Now, my lord, I rely on, my lord, Kohlerov's case. My lord, this is reported in 45, volume 45, Corporate Law Advisor, page 17. At, my lord, para 7. Page 28. My lord.
Paragraph
7.
Yes.
First, we shall consider the question of limitation on which Sri Raghavan cited a number of cases. In a section 397 petition, if the alleged act of oppression has a continuous effect, then the issue of limitation is of no consequence. So, my lord, all these are assuming limitation act applies. My lord, if there is, my lord, a continuous effect.
No, it is continuing.
Correct. My lord, it continues, my lord. Therefore, petition cannot be dismissed. And, my lord, the other case, my lord, was Naveen Ramji Shah. My lord, that is reported in 136 company cases, page 770.
Yes.
Paragraph 8. I have considered the pleadings, arguments, and the written submissions. Insofar as limitation is concerned, I'm sorry,
Yes, yes.
insofar as limitation is concerned, as submitted by learned counsel for the respondent, the provisions of the Limitation Act are not applicable to a proceeding before this board in terms of section. And I showed your lordship, section 433 in the new act, no corresponding provision there. My lord, Supreme Court judgment said Limitation Act will apply, my lord, to proceedings in court.
Yes.
And the court, my lord, has to be, my lord, a court, my lord, which is, my lord, in the hierarchy of courts, my lord. It, my lord, cannot apply to tribunals unless, my lord, it is specifically made, my lord, applicable. Then, my lord, further, when this board exercises equitable jurisdiction, technicalities like delay, etc., are not given much weightage, especially, kindly note this, in cases of family companies wherein the family members always attempt an amicable settlement before bringing the matter to court. Then, my lord, in the present case, the petitioners appear to have attempted at an amicable solution, but seems to have failed. Therefore, I do not consider this petition should be dismissed on account of delay or laches.
Yes.
These were, my lord, the three cases, and your lordship seen that the only ground, my lord, on which the first two cases, my lord, have been, my lord, distinguished is, my lord, that there has been acquiescence. Now, my lord, how? My lord, by, my lord, us accepting, my lord, dividend. My lord, we should have got more. We've accepted less. And therefore, my lord, it is, my lord, acquiescence. My lord, with the greatest of respect, my lord, this is and cannot be, my lord, acquiescence, because I'm getting less than, my lord, what, my lord, I am entitled to get. Because, my lord, to say, my lord, that I should not have accepted dividend, my lord, means, and my lord, this is, I'll have nothing.
Correct.
I'll have nothing. My lord, by simply, my lord, reducing me to 22%, they say that, oh, well, you should not have accepted dividend. So you should have had nothing.
Okay.
When, my lord, this is part of a family business, my lord, it can be, my lord, nothing worse, my lord, in terms of ouster from, my lord, a family. This very stance itself, my lord, that dividend should not have been accepted at all, in my respectful submission, my lord, shows, my lord, the, my lord, motive. And that Kothari document I had shown your lordship earlier, my lord, your lordship's made a note at page 569, volume 2, my lord. Just lordship's taken it down earlier. Just kindly make a note, even apropos this, which shows, my lord, that settlement was on, my lord. It's in volume 3. And the date, my lord, is 13 January 1998. 569, volume 3.
569. Yes.
Now, my lord, so, my lord, the most important aspect is, my lord, even on facts, my lord, they have not, my lord, considered, my lord, paragraphs 12 to 14 of the petition which I placed. My lord, I placed 12 only. Kindly make a note in same lines, my lord, 12 to 14. As also, my lord, the settlement proposal, my lord, of, my lord, 1998, my lord. And the fact, my lord, that I had objected, my lord, after objection, my lord, till I withdraw, my lord, the objection, my lord, there is no question of acquiescence. So after objecting, if I have accepted dividend, that does not mean, my lord, that I have acquiesced.
Yes.
Because, my lord, my learned friend says that's a tall argument. I say that by getting me out for, my lord, 22%, you are now saying you should not have accepted dividend. So you have the shares, you stay invested with us and get nothing in a family business. My lord, that is the stance, my lord, which is being taken.
This is the only little interruption, my lord, I can give.
No, because the energy is the benefited for this.
Yes.
My lord,
my lord, I don't know if he went
no,
to
my client told, my lord, personally, we are all beneficiaries, my lord. I don't know about my client, my lord, but personally, yes, my lord, we are all beneficiaries.
Now, my lord, we come to the next, my lord, allotment, my lord, which is, my lord, I think your lordships have. So, my lord, we'll stop here and, my lord, do the next two on the next date.
Yes.
Next, ওটা হবে না আমার arbitration আছে before ভাস্কর ভট্টাচার্য arbitration আছে কটায় ও ঠিক আছে তাহলে my lord 27th, my lord
27 कुछ फिक्स है नहीं है Yes, 27 at 2 p.m.
2 or 3, my lord, whatever, 3:30, whatever suits your lordship.
3 p.m. कर दी
3 p.m.
Learned counsel for the applicant has appellant has argued the matter at length, but due to paucity of time, hearing could not be completed. Let the matter appear on 27th August at 2 p.m. No, 3 p.m. That Mr.
Whatever.
Mukherjee, 27 might be not, this court might be third 3rd September.
3rd September, ठीक है? Yes, ma'am. That's
3rd September at 3 p.m.
Right. 3 p.m. my lord.
3 p.m.
lovely.
Your Lordship, appear for the applicant in item number 4.
Yes.
Mr. Bose is leading us in this matter, Your Lordship. He's in legs of court number 2.
No,
If
madam,
Your Lordship kindly keeps as a short pass over. Not today, it's just a short pass.
We wait for a 1 week, entire week.
Where is Mr. Bose?
Court number 2, Your
unfair.
Lordship. Court number 2, Your Lordship.
He knows that matter is
2.
fixed at 3 p.m.
It's all, the matter is almost over, Your Lordship. He's on.
Let me start, Miller. Then Miller, let me start, Miller, because Miller on his part it's complete, more or less.
What is your instruction?
Miller,
Like will continue this matter. Any
He-
instruction?
He will address to Your Lord. He will address Your Lordship
Huh?
on this, on the issue that
This is
was raised
unfair on
last
the
time,
other
Lordship.
party, Miller.
Okay, let it pass over, Mr. Bose come.
Great.
Pass over. Tell them I will take this matter. I will not adjourn.
No,
I will take
a
it
short
back.
pass.
But I'm for the official.
Milord, this is my application, Milord.
Yes.
Your Lordship, Milord, sees, Milord, the order dated, Milord, 6th of August. The different matter. 6th of August, Milord, we have come up before Your Lordship, Milord, the item number 41. Item number 41, Milord, is an application by the official liquidator for, Milord, confirmation of sale, Milord. We, Milord, on the last date appeared and saying we have an offer, Milord, which is, Milord, higher than, Milord, what is the actual offer today has been placed, Milord. My Lord has been pleased to, Milord, grant us liberty to file an application, Milord. This is the application, Milord. If Your Lordship sees, Milord, there are 2 conditions, Milord, which I would like to, Milord, incorporate. One is, Milord, that page, Milord, the sale notice is at page 21.
Yes.
And, Milord, the relevant portion is the clause 5, which is, Milord, at page 24. That is, Honorable Court may accept or reject any offer without assigning any reasons thereof, and decision of the Honorable High Court of Calcutta shall be final, Milord.
Correct.
Milord, this application I have filed, Milord, prior to Your Lordships confirming the sale at their instance, Milord. Milord, what was their offer, Milord? Their offer was, Milord, 8,74,31,247, Milord. That, Milord, will appear from the report, Milord, which the Milord, the official liquidator had filed on the last day.
8 crore.
8 crore, Milord. I have pleaded at paragraph 6.
But if your lordships kindly
7.
see the report of the official liquidator, paragraph 8.
Item
Page
41. My Lord, item 41 is, Milord.
Item 41 if I'll need.
PLG.
Yes, then?
Yes, Milord. My offer is, Milord, 10 crores. Which is, Milord, in excess of, Milord, more than a crore of, Milord, what has been offered by, Milord, the present, Milord, highest bidder. Milord, why I could not, Milord, appear, Milord, I was not aware of, Milord, this. Milord, there is an association in Maharashtra, Milord, which is known in the name of Sinnar Ayudik Shankari Bhashat Mandit, which, Milord, is kind of, Milord, a authority which, Milord, gives land on lease to, Milord, various business entity. We had, Milord, business entity, Milord, we approached them for a land. When we came to know, Milord, that one of the land, which is, Milord, otherwise owned by them, has been, Milord, put on auction by Your Lordship for this Honorable Court. But by the time, Milord, we have got to know, Milord, the auction was over. Therefore, Milord, he appeared before Your Lordships, Milord. And today, Milord, I have an offer of, Milord, 10 crores, Milord. I am carrying a, Milord, demand draft of 2.50 crores, Milord, to give it to the official liquidator. And, Milord, so, Milord, that is, Milord, my application in nutshell, Milord. In any event, Milord, if Your Lordship accepts my prayer, Milord, that will endeavor to, Milord, the money being coming into the, Milord, the official liquidator, which will affect. That was my, Milord, submission. So, Milord, I am, Milord, if Your Lordship, Milord, so direct, Milord, I can rely on, Milord, the...
Yes, who is for the bidder? Yes.
My humble submission is in regard to this auction sale notice.
Correct.
The auction sale notice was published widely. It
Correct.
was published on 9th of July 2025.
Correct.
It was published in the local newspaper and the two newspapers and
Yes.
the official website of the where the auction was held. Your Lordship. But any auction which has been closed can only be reopened. There are some grounds on which the auction can be reopened. The auction can be reopened only. My learned friend can show that there has been fraud in the auction, or the value on which the price auction has been closed is the undervalue of the property. To protect the sanctity of the auction, if everyone comes and prays that we want to participate, they have ample time to come and participate in the auction procedure. They paid to come and participate in that. They nowhere in their application has pleaded that there has been a fraud has been played in the auction or the property has been sold undervalued. There is no such prayer. There is no such pleading in regard to this. So my humble prayer is this, that this auction to be finalized in favor of the equal bidder.
So you will not use the affidavit.
Lordship,
You will not use the affidavit, then I will decide here.
I am led by Mr. Manag Bose, Lordship.
I don't know if you have used the affidavit, then otherwise I will decide here.
No, then my submissions be recorded.
Yes.
That's finalized.
Yes. What is your submission?
Lord, my respectful
Lordship
submission.
wants, my lord, I can assist your lordship by certain judgments also, my lord, that before the actual confirmation, if the court finds, my lord, there is a higher offer, my lord, and it is for the interest for the creditors, then, my lord, the court there is not powerless to act.
Which judgment you are relying
Yes,
upon?
my lord. First is, my lord, citation to the
ACC page 79.
2000 volume 6 SCC page 79. Kindly see here also, if your lordship sees paragraph 2, open auction, the last line of the first page. Then, my lord, kindly see on 14th August 92, appellant offered a sum of rupees 38 lakhs. That is after the highest bidder's offer of 37 lakhs. Then, the company judge, after consideration, allowed the petition of the appellant and directed to deposit 10% of the bid and balance 15% to make up 25%, such and such. Division bench had set aside this order. Now, my lord, kindly comes to paragraph 4. In Navalkha versus Ramayana Das, this court held that court is the custodian of the interests of the company and its creditors, and the sanction of the court required under the Companies Act has to be exercised with judicial discretion, regard being had to the interests of the company and its creditors. Where acceptance of the offer by the commissioner is subject to confirmation by the court, the offerer does not by mere acceptance get any vested right in the property, so that he may take automatic confirmation of this offer. Condition of confirmation by the court operates as a safeguard against the property being sold at inadequate price, whether or not it is a consequence of any irregularity or fraud in the conduct of the sale. In every case, it is the duty of the court to satisfy itself that having regard to the market value of the property, the price offered is reasonable. Unless the court is satisfied about the adequacy of the price, the act of confirmation of the sale would not be a proper exercise of judicial discretion. Then, my lord, your lordship will kindly see para 5. The purpose of an open auction is to get the most remunerative price, and it is the duty of the court to keep openness of the auction so that intending bidders would be free to participate and offer higher value. If that path is cut down or closed, the possibility of fraud or to secure inadequate price or underbidding would loom large. The court would therefore have to exercise its discretion wisely and with circumspection, and keeping it with the facts and circumstances. One of the terms of offer in this case is that even confirmation of the sale is liable to be set aside by the High Court as per clause 11 of the conditions of offer. In our case also, my lord, there is a similar clause. The sale conducted was subject to confirmation. Therefore, mere acceptance of the offer of Shantilal Malik does not constitute any finality of the auction, nor can it be automatically confirmed. The appellant offered higher price even now at 45 lakhs. keeping in view the interests of the company and the creditors and the workmen to whom the sale proceeds would be applied, the learned company judge was right in exercising her discretion to reopen the auction, directing Shantilal Malik as well to make higher offer than what was offered by the appellant. In every case, it is not necessary that there should be fraud in conducting the sale, though on its proof the sale gets vitiated and it is one of the grounds to set aside the auction sale. Therefore, the discretion exercised by the learned single judge cannot be said to be unwarranted. The we are satisfied division bench committed manifest interfering the order of the learned single judge. Now, this is one judgment. Then, my lord, the other one is Divya Manufacturing.
Yes.
Just 1 second, my lord. What's the number?
6 for 16.
Yes. My lord, Divya Manufacturing, your lordship will see 2006 SCC, page 79. 69. Kindly come to paragraph 2, placetum F. Then this is also sale by the company court. Straight away, your lordship will kindly come to paragraph 12. The law on the subject is well settled. Paragraph 12, my lord, refers to the Navalka case, which I have just also referred to in the other matter.
Yes.
So I am not placing that. Your lordship will straight away come. Paragraph 13. From the aforesaid observation, it is abundantly clear that the court is a custodian of the interest of the company and its creditors. Hence, it is a duty of the court to see price fetched at the auction is an adequate price, even though there is no suggestion of irregularity or fraud. As stated above, in the present case, sale proceedings have a checkered history. Appellant started its offer after having an agreement with the Shomiti for 37 lakhs. This was on the face of it underbidding for taking undue advantage of court sale. At the intervention of the learned single judge, bid was increased to 85 lakhs. Subsequently, before the division bench, appellant increased to 1.30 crores. At that stage, respondent 7, Sharma, was not permitted to bid because it had not complied with the requirements of advertisement. Stated that on 26 June 98, division bench had ordered that offer of Eastern Silk and Jai Press products would only be considered on 2nd July and confirmation of sale would be made on the basis of the offers made by the two parties. Further, despite the fact that appellant Divya had withdrawn its earlier offer, court permitted it to take part in making further offer as noted in the order of 2nd July. In this set of circumstances, there was no need to confine the bid between 3 offerers only. Then in Lika versus official liquidator, which I have submitted, 14 and 15 is quoted from Lika. Then, my lord, 16, page 79, kindly come to para 16. There, further, there is a specific condition 11 in the terms and conditions of sale as quoted above, which empowers the court to set aside the sale even though it is confirmed for the interest of creditors, contributories and all concerned and or public interest. In this view of the matter, it cannot be said that the court became functus officio after the sale was confirmed. Here, my lord, that stage has not come. It has not confirmed. As stated above, neither possession of property nor sale deed was executed in favor of appellant. Offer of 1.30 crores is totally inadequate in comparison to the offer of 2 crores. And in case where such higher price is offered, it would be in the interest of the company and its creditors to set aside the sale. This may cause some inconvenience or loss to the highest bidder, but that cannot be helped in view of the fact that such sale are conducted in court precincts and not by a business house well versed in market forces and prices. Confirmation of sale by court at a grossly inadequate price, whether or not it is a consequence of any irregularity or fraud in conduct of sale, could be set aside on the ground that it was not just and proper exercise of judicial discretion. In such cases, a meaningful intervention by the court may prevent to some extent underbidding at the time of auction through court. In the present case, court has reviewed its exercise of judicial discretion within the shortest possible time.
Yeah.
The other judgment is only one paragraph. I'm trying to show that he has not acquired any vested right. His offer has neared the highest bid has been accepted, but he does not get a vested right unless confirmed. And this confirmation takes place when the court actually applies its mind.
Yes.
So that is my submission, my lord. There is no predicament, my lord, in, my lord, at this stage, the court accepting the offer.
Yes.
My lord, I being the official liquidator, my only respectful submission that a sale is being conducted by the official liquidator for the benefit of the creditors in general. No other interest is vested with the official liquidator. Only in respect of the, my lord, the benefit for the creditors in general.
Yes.
So if the offer is being more, not that 10 lakhs or 11 lakhs, it is more than 2 crores. So, my lord, the court can accept, though I appreciate with regard to the, my lord, the judgments of the latest judgment of the, my lord, the BAFNA, Cellular versus BAFNA, where it has been held that sale cannot be set aside merely on the ground, on any ground, save and except if there is a material irregularity and, my lord, the fraud and others else. And that was also judgment also supported by another judgment, subsequent judgment, that is Sanjay Verma versus Sanjay Sharma. So, my lord, both the judgments are, my lord, they said that the sale cannot be set aside by any means. But here in the question of the creditors, my lord, the creditors benefit. My lord, if I get the more money, my lord, I can, my lord, they pay more money to the creditors. My lord, that is the only duty of the official liquidator. So, my lord, I leave it to your lordships. My lord, the sale actually, in fact, if your lordships kindly see the report filed by the official liquidator, paragraph 8. Well, I have stated so that who is the highest bidder and how much amount he has paid. Paragraph 8, my lord, if you will just kindly see. So my report was for confirmation of the sale, but on that day, my learned friend, my lord, invited your lordship's attention that his client is interested to make a more bid. So accordingly, he has filed this application. So I have nothing to say, my lord. I leave it to your lordships.
And I have got, my lord, the demand draft for 25% of my bid amount.
But if the auction sale is being held, my lord, it should be held before this court, my lord.
Yes.
And let them pay, my lord, the amount, my lord, the 10% at least.
Yes, I have
So
got
they are
it,
bona
I
fide.
can pay it to the official liquidator. Thereafter, your lordship will conduct the auction any given day. my lord.
But I am the unfortunate H1 bidder, my lord, the high
Yes.
auction purchaser. But I would have just referred to one paragraph from Balji Kimji to say, my lord, today Mr. Sen's client has come with a higher bid. But tomorrow somebody else will come. But our auction cannot be reopened, so the entire auction process will stand frustrated. So it is not his case that there was inadequate publication. He was otherwise prevented with some other unavoidable circumstances.
Yes.
So how will the auction process ever come to an end?
Yes.
Well, just because you want to pay some more, that by itself cannot be a ground to reopen a sale. That to an auction sale, which has been held after adequate publication in newspapers, national daily newspapers.
Yes.
So everybody participated in the auction.
Yes.
But higher amount, tomorrow, my lord, Mr. Sen is giving higher amount. Somebody else will get amount to pay even higher. So no auction will ever reach a finality.
Okay, then in that case, the court will conduct the auction in open court here.
No, my lord, then there has to be adequate publication. So, my lord, everybody must know.
No, not
so. My lord,
Okay,
I have
okay, you are not
respectfully
there. You are
submitted.
not there.
My lord.
Mr. Sen has relied upon 2 judgments.
My lord.
You considered it. Come on the next day.
Very well. Very well.
Yes.
These 2 judgments you consider?
Very well.
Because I asked your junior, but he's telling that you are making a submission.
Divya.
So yes. There are 2 judgments Mr. Sen has relied upon. You considered it.
Yes.
Come on the next day.
Very well.
এটাই তো দিব্যা, there is one more. এটাও দেখিয়েছি লিকা।
Laika 1, Laika 2. This is yes.
Yes, Laika 1, Laika 2.
Yeah, this is 19. এখানে কেন?
2006.
2000 volume 6. Possibly this is Leica 2. There are two, Leica 1, Leica 2. Divya.
CA14 by filed by you.
CA.
CA14.
CA14 is by the official liquidator.
CA15.
CA15.
Applicant, namely Yash Vijay Vedamutha, VED Ved Mutha, VED MUTHA, Mutha.
এখন তো দেব।
Who is he? Is the proprietor or what?
Applicant is one of the MNE Components India Private Limited.
MNE, okay, take care then. MNE
Yes.
Components India Private Limited has filed an application being CA15 of 2025, praying for
Judges summons, one of the prayer is there.
15 का judges summon का है बाबू? Praying for an order for accepting the bid of the applicant of rupees 10 crore as the highest bid in respect of the sale of the assets and properties of the company in liquidation. As per the order passed by this court, the official liquidator has published a notice of sale of the property and assets of the company in liquidation, and in terms of this tender, in terms of the said notice, one form, namely, what is the name of your firm?
Then I'll just give your lordship. If your lordship will see the second respondent, the name is a little complicated. Your lordship will see second respondent. Trambekeshwar Food Private Limited.
TRAY, yeah, Trambekeshwar Food Private Limited had participated in the said tender process and has quoted, and is the highest bidder, quoted the rupees 8,74, 31, 247. The applicant, namely MNE, क्या वो नाम है ना, company, has not participated in the tender process, but now he has come with the proposal of rupees 10 crores. Full stop. Learned counsel for the applicant has argued the matter and relied upon true judgment reported in 2000 within bracket 6 SCC 69. And what is the another?
Well, that is 79. The rest are said. 2000 volume 6 SCC page 79. One is 69, one is 79.
69 and 2000 volume 6 SCC 79. Full stop. Learned counsel for the Trambekeshwar जो भी है ना, press for time to go through this judgment and to make appropriate submission on the next date fix. In view of the above, case is adjourned. Let the matter appear on 3rd September.
Very well.
Punjab National Bank is the secured credit. When the official liquidator invite them to appear before your lordships, because they are the secured creditor ultimately.
Issue the official liquidator is also directed to issue notice upon the secured creditor, that is the Punjab National Bank of
Punjab National Bank.
which branch?
Mumbai branch.
Issue notice to the Punjab National Bank. Give the address. What is the address?
We can deposit the demand draft with the official.
Kindly don't allow them to do that. Your lordship will hear it.
It is already with
notice if they intend to appear in the proceeding, shall appear before this court either in person through the advocate or through the virtual mode on 3rd of September 22.
Review of this order passed by item number so and so, item number 41.
Yes, 41 be taken together. 3rd September.
Grateful.
Well, will it appear at 2 p.m.?
3rd September 2
Company
p.m.
matters are taken up at 2 p.m.
Then my lord, let it
No, not 2 p.m. On 3rd September.
Yeah, company matters
appear slightly at the top, my lord.
company matters हो जाए.
एक काम करो 3rd September वाला कब दिया 2 p.m. भी है ना उसको इसको टॉप में कर दीजिए.
Grateful.
Pass one matter with
Yes,
Mr.
yes.
Bositi.
Call the pass over matter.
Other matter may be released.
Let me see what Mr. Bose will argue.
My lord has got a matter fixed at 3:30, I understand.
Call.
6. From our court.
Yes.
By instructing counsels and none of them are here.
He will. No, he has left.
We all here, possibly he thought that fixed matter was going on.
No. He consciously told me that Mr. Bose will continue. I am leaving.
How would he know I will continue? I wasn't even here. My lord, in fact, my lord, if your lordship recollects, on the last occasion I was making, then your lordship said that your lordship is with me, but how would the company court have the jurisdiction to entertain? Because the probate that they got, what the probate which was granted after the order of the Supreme Court, well, that needs to be revoked
or whatever,
or something has to be done that would be within the jurisdiction of the testamentary court and not within the jurisdiction of the company court. So, my lord, on this, my lord, I had told them to take instructions because I was respectfully submitting that, my lord, in that event, your lordship will record that there's a lack of jurisdiction to decide this issue, and then we can take appropriate step to file an application for revocation of probate under 263. So then my lord, we'll get benefit of section 14 of the Limitation Act, nothing else. So, but this instruction I had told
the
them.
appropriate court, not before this court.
Of course, whichever is the court, whichever is the court. So, my lord, that instruction I told them to take. My lord, this decision I cannot take.
Yes, you have taken. That's why I asked your colleague.
Lordship kindly takes up the other matters. I'll just pass it over for the call. Well, I'll ask them right away.
Yes, call the next matter.
Instruction may be given today only, Millet.
Pass over. Call the next matter. Item number 6.
My lord, in this matter, my lord had been pleased. But I filed an application giving details of certain properties which were lying with me, which I found from the title deeds that the properties were actually that of the company. I brought them on record. My lord had asked the official equator to file a report by today. We have not yet been furnished with a copy as yet.
I filed the report.
कभी चाहिए
की वो तो नहीं खाली यही दिया वो उन लोग ले गए
Man, the report does not speak of this property at all. He just says, I've got no knowledge.
I have got no knowledge.
That is why I filed the application annexing certified copies of title deeds, chain deeds, everything. How can he say he's got no knowledge?
Kindly see the prayers.
Yeah, see the press.
The winding up order was passed, my lord.
In 1975.
Now 2025, he
Yes.
has come with the documents. Immediately, it cannot be traced out. And the documents is not also visible.
There was nothing for him to trace out.
Yes, that is the reason why I have read it
Yeah.
here. Paragraph 11.
My prayer is I will hand over all the originals to him if he's interested. It doesn't seem he's interested.
Yes, yes, definitely interested. You were not interested for last month.
I was not interested.
25 years.
Yes. Where is the document?
I've annexed the copies, and my prayer A is that direct him to take copies from me and do something. He's not, in spite of annexing it, and my lord asking for a report, he's disclosed nothing about this property, what steps he's taking on the basis of my. I'm doing a favor to the company. 1975, the winding up order has been passed. 50 years ago. Still proceedings have not been concluded.
Have you considered this document which he annexed with the document?
All annexed to my application.
Where is your comments on this document?
Kindly see. The applicant may be kindly be directed to provide a legible copy of the indenture to the official liquidator High Court Calcutta within 7 days from the date of the order. Direction may please be given to the Commissioner Mysore Urban Development Authority and Deputy Commissioner.
Legible copy. This is not a legible copy.
While will come to page 45.
Please, sir, I am asking.
Very well.
This is not the legible copy. What further legible is required? What further legible is required? Who has given you instruction? This is not legible. Which show me, pointed out which document is not legible, then I will direct him.
Yes,
show me.
Yes, Malord, if your lordship feel I also, Malord, my copy is correct.
Then
Malord, kindly pass an order in terms of prayer B, C, and D. So B and C for the purpose of Malord taking.
Legible copy down.
No, first we have to ascertain with regard to the the status of the property at present.
That is the reason, Malord, I have to take inspection of that property. So, Malord, that is the reason, Malord, I have.
That's why you're given to.
Prayer B and C. The lordship kindly see.
It is where it is Karnataka, Mysore.
My pray B have got no objection. Pray B can be granted. Pray A is already got.
And Malord, prayer C also. The local police may be assisted
My
by
lord.
the official if required.
Yes, do it. See, both the type, meaning. That's exactly my prayer, my application also.
Mysore property, what is the survey number? What is
Even the title deed is annexed at page 45.
Where is the? That's why you kindly come to your prayer, judges, judges summon from Mysore property.
Yes,
the total Mysore is to be taken into consideration.
I've said the Mysore property.
Mysore
I've annexed the deed did that because of that.
Deeds up. You
because the Mysore property has been defined, my lord, paragraph 16. I've said
paragraph 16 of
page 8 of my application of CA4. The Mysore property has been defined. 3 acres, 23 guntas under survey number 58. For the 3 acres, 20 gunta under survey number 6.
No, at this time, the applicant able to ascertain the scrutiny of the document and the title is handed over to applicant in original among the various properties bequeathed by late Gayatri, included properties in Mysore, Karnataka. Guntas, measuring 3 acres, 23 guntas, survey number itna, further 3 acres. This is the only property.
Yes. This is 8 acres of land.
This is the only property.
Yes. This was left to me by will. However, I later discovered that the deed stands in the name of the company.
Who are you?
I'm the sole heir of the only share. I'm 100% contributory. Anything which remains will be coming to me.
You are claiming that you are the 100% contributory.
Yes. There's no dispute on this.
How you got it?
This was a family company.
By way of inheritance.
Family company, husband and wife. They died, leaving their property to their son. Then from the state to the son's wife, and from there to me. 100%. There's no dispute on that. But in the will, it was left to me, treating it as his property. I find out that it is not that. And if these properties are sold, all creditors can be paid off. And there'll be enough money left over.
The applicant, what is the name of the applicant?
What's the name?
The applicant Amalendu Karmakar, son of late Vijay Krishna Karmakar, resident of 4/6 Ashwini Datta Road, Police Station Damdam, District North 24 Pargana, Kolkata 700028, has filed the present application being CF4 of 2025, claiming that he is the sole heir of the shareholders of the PC Rai Company, PC Ray and Company India Private Limited, within bracket in liquidation. He submits that on scrutiny of the documents and title deeds, he came to know that late Gayatri Ray has bequeathed her landed property to whom?
To me.
To the applicant in connection with the land bearing survey number 58,
amongst other properties.
58, measuring 3 acres and 23 guntas, and survey number 62/2, measuring 3 acres, 21 guntas, and survey number 60/1, measuring an area of 2 acres, situated at in the district of Karnataka. Where is
my mind will kindly take page 50. All the details are there.
50?
50.
Situated at
village Nachinahalli,
situated at
Mysore Taluk, Mysore district.
NACHANAHALLI, Nachinachalli village, Mysore Taluk, Mysore district,
then it was state of Mysore, now it becomes state of Karnataka.
Mysore district. Full stop. The said document was handed over to the official liquidator, and on receipt of the said documents, the official liquidator has filed the report.
No, my lord, the document was not handed over. Copy was handed over.
A copy of the document. Copy of the documents were handed over to the official liquidator, and the official liquidator has submitted the report, praying for a direction upon the commissioner, Mysore Urban Development Authority, within bracket MUDA, MUDA, capital, and the deputy commissioner collector, Mysore, and commissioner of Mysore, municipal corporation, to depute officials for demarcation of the aforesaid landed property, and to provide the documents and the sketch map of the property in question. The official liquidator also prayed for a direction upon the commissioner of police or the competent police authorities of the said area wherein the landed property is situated, to provide adequate police adequate police protection for conducting demarcation and for conducting demarcation for the purpose of identification of the property in question.
And for taking physical possession. He's asked for that.
As well as for taking possession of the property, as well as taking possession of the said property. Good. I'll heard the learned counsel for the respective parties. This could find that the applicant is claiming the said landed property and being the property of the company which is in liquidation, and the official liquidator is in charge of the property. Thus, for the identification of the said landed property and for taking possession of the said landed property, comma, the competent authority of which district?
Well, at that point of time, it was Mysore district.
So now it is, you are not ascertain before filing this application.
But it was not my property. I've
You
just
could
come
have been ascertain. Now all the things are on online.
It says
in the south is the only area you will get from day one till today the total details of the property. Only you have to pay the 35 rupees. In all south.
It appears to be my Mysore district.
In all south states, only 25 or 35 rupees you have to deposit. You will get from 0 to till today. Full stop. The deputy commissioner or the district collector of the concerned district and the concerned revenue authorities are directed to conduct the demarcation of the aforesaid landed property in presence of the official liquidator of this court,
As well as the representative of the applicants.
in presence of the official liquidator or the representative of the official liquidator of this court, and in presence of the applicant.
My lord, the applicant really has no. I've never seen the
presence of
property.
the applicant, or in presence of the applicant. Able to demarcate, no? For the purpose of identification, and if the authorities found that the land in question is free from all encumbrances, comma, after the demarcation in presence of the official liquidator or the representative of the official liquidator and the applicant,
I say all the applicant. I really have never seen the property.
the said property be handed over to the official liquidator. And if the landed property is handed over to the official liquidator, comma, the official liquidator shall take possession and take possession of the said property and to submit the full list of property. The police authority of the concerned district are also directed that if any request is made by the concerned district collector or the official liquidator for providing adequate police protection at the time of demarcation of the said landed property, comma, the concerned police officers shall provide adequate police protection to the district collector as well as to the official liquidator for at the time of demarcation and identification of the landed property, as well as for giving at the time of giving possession of the said landed property to the official liquidator. The
A copy of the cost and expenses to be borne by
applicant. All the expenditure shall be borne by the applicant. And the official liquidator shall submit the report within 6 weeks from date. Let the matter appear on.
My lord will not put the costs on me.
On 5th November on 12th of November 2020.
A copy may be circulated, my lord. Copy of the report filed by the official.
Let come, then we'll see to that. Let the come, we'll see.
My lord, the official liquidator is having
Already filed, my lord. Already filed.
The official liquidator has substantial funds. But why, my lord, putting the cost on me?
What cost? The department will conduct. There will know if any cost you have to be.
He will say the cost of the official liquidator going there. Everything will have to. But
That is the official.
My lord, a
They will-
copy be served, my lord.
What?
Report has been filed today, my lord. That copy has to be served, my lord. I am applicant number 1 and 2, my lord. Application number 1 and 2. CA
The report, the report submitted by the official deputy director to serve the report submitted by this, submitted today before this court to all the appearing parties.
My lord has kept it on.
Huh? Huh? 12th November.
12th November.
Great. Yes, copy, my lord, I have already served.
Served, no?
Yes.
No,
Give me.
they have not got it.
It
He's
is-
only
it
given
is-
me.
Yes, next. 6 to 9. 6 to 9. Yeah, combined order.
If your lordship takes up I have taken instruction, and I had sought for a passover in that.
Yes.
Company.
Pass over. 4 number.
Unnecessarily, I don't want to keep Mr. Dasgupta waiting. So, my lord, I have taken instructions, my lord. Your lordship can record that no jurisdiction, and will challenge the probate, which has been passed after the order of the Supreme Court before the appropriate forum, whichever is the appropriate forum in accordance with law.
So whose application is this?
Well, this is my application.
CF 157?
Yes, 157.
New CA 22. New number 22.
I don't know. इनका वो तो जज समन्स तो
তোমরা আগে বলতে তো তোমাদের সব কষ্ট হয় না। এটা তো আমার এখানে আছে।
Inconvenience compilation টা है।
Yes. Any submission? The applicant. So you are appearing for one, na?
Yes, madam. I am appearing for one.
The applicants have filed the present application being CA 157 of 2017 within इसको नहीं CA 22 of 2017 within bracket old CA 157 2017 praying for following relief. Prayer A2
বলে দিচ্ছি।
H judges summon, full stop. This court finds that Supreme Court order रखा होगा उसमें तो?
Yes, madam. The Supreme Court order
This court find that
is at volume 8, page 1197.
अरे नहीं है 17 February 25.
February is 1195.
No, my lord. It is
1195.
so the final order টা কোথায় বলো?
109.
My lord, 1195.
My lord is asking for the 2025 order.
That is the
No, yes, 17th of February 2025.
That is
Correct,
at
correct.
1195.
1195.
Volume 8.
क्या बोला? This court finds that by an order dated
No.
17.
My lord, this is the application
Acha,
where I
recalling.
got for recalling. Correct. So, my lord, the
Initially,
my lord,
the respondent number 2, who has filed the initially probate application, you?
Yes, my lord, Athanu Dutt.
Athanu. Respondent number 2 has filed an application for grant of probate or letters of administration. What?
Probate.
Grant of
Probate.
This court, not this court, the testamentary court has granted probate.
Division bench order টা দাও।
Probate. Challenging the said probate granted by the testamentary court, comma, the
Division
who has
bench.
challenged that?
My lord, that was challenged by two caveators, Onima
অনিমাস not challenge. One অনিমাস
It was not
perform.
Being agreed with this
কে
order
challenge
of
করেছিল?
chairman?
মানে রবীন্দ্রনাথ দত্ত
রবীন্দ্রনাথ দত্ত। আচ্ছা।
that your lordship will find in the judgment of the appeal court, the division bench judgment which I had handed over to your lordship. Judgment দাও. But I had handed over to your lordship the
Page number?
Page number, the judgment. Judgment বলছি ডিভিশন বেঞ্চে অজনাথায় জাজমেন্টটা যেটা দেখি
क्या बोला? Who has prepared the appeal, Mr. Dasgupta?
I'll tell you.
রমা দত্ত, সুরজিৎ দত্ত and সর্বজিৎ দত্ত.
The respondent and the respondent number three herein, namely Ramo Datta, Surajit Datta, and Sarabjit Datta, have preferred an appeal. Full stop. By an order dated thus, the appellate court has set aside the order passed by the testament report granting
6th August 1998.
6th August 1998. ऊपर हाँ? Set aside the probate granted by the
which
testament
became
report.
a reported judgment.
Full stop.
Reported
Being
judgment.
agreed with the said order of the appellate court, comma, the same persons have preferred.
Yes, I mean I had preferred.
They had but it was set aside. The
preferred.
probate was set aside.
Datta, comma, the respondent number 2 in the present application, in the present case, has filed an SLP before the Honorable Supreme Court, being
Milad, civil appeal number 6239 of 1998.
Being civil appeal number 6239
Correct.
of
1998.
1998. And the Honorable Apex Court, and during the pendency of the SLP before the Honorable Supreme Court, comma, the Atanu Datta, Rama Datta, and Surajit Datta and Sarabjit Datta have entered into a settlement, and on the basis of the said settlement, comma, the Honorable Supreme Court has disposed of the SLP by an order dated
16th March 2000.
16 March 2020. And 2000. Full stop. The applicants herein. No, who has prepared the review application? Applicants?
Yes, my lord.
The applicant herein have preferred a review application before the Honorable Supreme Court for recalling of the order, for review of the order dated 16 March 2000.
My lord, may I just? My lord, our application was for permission to file recalling and modification application. That is, my lord, it is there at page 1195.
The applicants herein have filed an application before the Honorable Supreme Court for
seeking permission to file a
miscellaneous application number, being miscellaneous application diary number,
yes, my lord,
30985/2023.
Correct.
Praying for recalling. It is recalling. It is
yes, my lord.
Recalling of the order dated 16 March 2000. 16 March 2000. By an order dated 17 February 2025, the Honorable Supreme Court has disposed of the said application by passing the following order. It quote करी दिन यहाँ से लेकर के ठीक है. This application being CA number 157, CA number 22 of 2017, within bracket old CA number 157 2017, is filed in the year 2017. That is prior to the order dated 17 February 2025. After going through the application filed by the applicant being CA number 22 of 2017, this court find that this court cannot decide with regard to the recalling of the probate granted by this court.
Lord, just if you would be a lordship pleasure to record that after the Supreme Court order in 2025, they came back here and got the probate granted. So I am aggrieved by the grant of probate which happened after the Supreme Court order. So that is what needs to be revoked now.
After नहीं वो कर दो हाँ सी है, नहीं उसको काट दो, उसको काट दो, ना ये पूरा काट दो,
After 2000,
काट दो।
Milord, I have one
order of
submission.
17 February
Milord,
2025.
whatever Milord, Milord thinks, Milord, when Milord had dictated that Milord, Shurojit, Roma and Shorbojit they entered, Milord one submission, Milord, three notices were sent from Milord Supreme Court registry to Anima. She had not come and appeared.
That I not recorded.
Milord, it's my submission, Milord.
Okay.
Kindly Milord.
Okay. क्या बोला? लास्ट में क्या वर्ड है? ना वर्ड नहीं, उससे पहले ये फर्स्ट पैराग्राफ क्या बोला? सेट आउट किया ना, फुल स्टॉप. After the order passed by the Honorable Supreme Court dated 16 March 2000, Atanu Datta has obtained probate from this court. Obtained probate from this court.
20th April 2001.
Dated 20th April 2001.
2001.
2001. Probate.
Page 392.
Yes, 2000, 2001. Yes,
2001.
yes.
Full stop.
Correct.
Full stop. Now the petitioner, now the applicants herein, intending to recalling of the probate granted by this court in favor of Atanu Datta. This court find that this court, being the company court, cannot decide the title of the property in question, which the Atanu Datta is claiming through the probate granted by the testamentary court. In view of the above, this court is not intending to go into the merit of the present application. Accordingly, go into the present application. So you are withdrawing?
No, yes, well, since it lacks jurisdiction, so your lordship says that since there is an inherent lack of jurisdiction of the company court, my lord, the application,
then it has to be dismissed.
Present application, as this court is not having the jurisdiction to entertain the application.
and kindly give me liberty to challenge the
No liberty may be granted
to, before an appropriate forum
liberty
in
may be
accordance
granted.
with law.
Whatever he has before that court, my lord, whatever court.
22
Otherwise, I will not get the benefit of
No,
section 14.
CA number 157 of 2017 is dismissed only on the ground of jurisdiction, as this court has not gone into merit.
Correct. And then my liberty, otherwise I'll not be able to change it. Now, my lord, kindly see.
However, the dismissal of the present application will not debar the applicants to take appropriate step before the appropriate court.
Milord, only Milord one submission that may be recorded. When Milord had recorded that Milord, we had entered into Milord an agreement Milord amongst ourselves. Prior to that, kindly Milord record that 3 notices were served Milord from Supreme Court registry where Anima has not come. Prior to that, I can also give the dates: 13 November 1998, 17 November 1998, 14 December 1998.
एक जगह सेटलमेंट का बोला है ना, एंटर इनटू सेटलमेंट, उसमें बोलो सेटलमेंट बोला है, उसके बाद देखो एक पैराग्राफ ऐड करो. लैंड काउंसिल फॉर the respondent Atanu Datta submits that prior to entering into the settlement between the parties, notices have been issued to Animo Datta
from the Supreme Court.
Supreme Court, but Anima Datta has not appeared in the proceeding before the Honorable Supreme Court,
which is denied by us. Which contention is denied by
the
us.
counsel appearing for the
whether
applicants,
a
but
record,
denied
it
the
has to be
submission made
shown.
by the counsel for the applicant. Deny made by the learned advocate appearing for the Atanu Datta. वो बीच में आ जाए. So what remains in the company petition?
The other 2 applications.
No, that is on a completely different. That's on a debenture. That can be taken up any other day conveniently.
So what are the other 2 applications?
CA 27.
It's fixed on 27. CA 27 is fixed on 27th of this month.
27th, so already it will come. Let it come, then we'll see. Come on that day, we'll see to that. If it not, then mention.
Very
well. Yes, my lord, my application is also on 27, 26.
The interim orders are need to be vacated, Milord.
Interim order, if any,
No,
vacated.
interim order in this CA.
No. There and Milad a clock.
Then
Milad
how
given
can
by-
it be
given-
vacated?
Ek minute, sir. Given by Justice Milad Kapoor, Milad restraining the Milad OL from disbursing the money on Milad on these applications. Milad this
Which
application, Milad this application.
By which order? Give the order. By which order?
But that is not on this application.
No.
That
Milad,
is on
this
CA
client-
25.
This client,
CA 25.
My client has got another
CA
application.
25, not CA 26.
Yes, it's on CA 25.
Milad, this is on contention that she
Not
is
CA 25.
very well. Milad Milad takes Milad the order, 3rd May order.
All the more reason that the interim order should be extended, because if he takes away the money
No.
and I get the revocation of the grant, what will I get?
Kindly see 3rd May order. Kindly
Continue this interim order. No further disbursement should be made.
No.
But if I
This is Milad.
if I file revocation,
Order
that's the whole
dated
point.
3rd May.
Yes, 3rd May 2023. Is his client?
No order on 3rd May 20.
Yes, Milad, can you see?
Give.
All applications are there.
Well, kindly seek on the top of the order,
Maybe.
is where it starts the next
It's
page,
on
second
his
page.
locus,
It's on
Milad,
CA
we have
25.
challenged his locus. If the proceeding is not there, interim order will continue.
Oh my,
That's
my lord, I have this interim order has to be restraining the liquidator from disbursing.
Yes, I'm seeking
Cannot
a,
disburse.
seeking a recall of
So
that.
then my application, subsequent application, everything will become
So
infructuous.
that he will pay before that court. This
How can
court
I pay
will
before that
continue with
court?
interim order.
How can I pay
A
before
court
that
saying
court?
I have no jurisdiction will continue with the interim order.
No, but so far as the other application is concerned, your lordship has
Application,
jurisdiction.
Application.
No, well, the debenture application is there.
That is something else.
There is a separate interim order in that
Milad,
as well.
This order has to go. This order has to go. This is on his prayer, same.
But how I can't understand, how is it the same? My lord, kindly have a look at this.
My lord, there is no stay for in the debenture application, my lord.
There is no stay in the debenture application.
Yeah, but
Why,
No,
Milad,
my lord,
this
CS
will be
27
unnecessarily, may I
there was
put
no
this
stay,
into
my lord.
myself. There is no proceeding on his part. And that has been filed by Roma. He is selling in 2 boats now.
Where is the stay order? There is no order of stay.
Yes, Milad, there is a stay order, Milad, where Milad money disbursal has been.
Yes, it is already there.
Yes.
And the official
Kindly see-
disbursal of the fund to be made by the officer within 72 hours.
Yes.
Then
Now, Milad, since no party has filed.
where is that?
Yes, in this application, that 72 hours.
Show me where is the order.
Milad, kindly see 122 on Milad that order. The aforesaid disbursal is to made by the official legal within 72 hours from the.
Correct. From the date of this order. CA 25
Yes.
disposed of.
In view of the subsequent fact that monies have been returned to the official liquidator.
Where
and
from
lying
you are
to-
reading?
Milad, page 3.
Yes. So subsequently, in view of the
Yes, Milad, there was an order passed on 6th April 2017 passed by Justice I.P. Mukherjee. In this application, that Milad is now this Milad.
where is that? That's interesting. Show
Milad,
me.
that 6/2017 order that's been recorded in Justice Kapoor's order. Kindly see.
Justice Kapoor.
My lord, page last para.
Yes, kindly recorded, Milad, 16th April 2017 order. Kindly see page 3, last paragraph.
16th April.
6th April 2017 order has been recorded by Justice Kapoor at page 3 of that order. My lord is now looking at. Kindly see page 3 of that order.
Yes.
In view of the subsequent facts, monies have been returned to the official liquidator and lying the OL, and in view of the order 6th April. So
Directing.
this was the interim order.
Read directing
Directing
before any further amount is
disbursed to Otonu. Appropriate notices 72 hours to be given.
Correct.
So this interim order was passed in this.
No, come, read. Complete. Kindly come to the page 4.
Yes.
Page 4, last 2 paragraph. The aforesaid
Insofar, yes, page 4.
Read.
If the official liquidator directed to give full particulars applying to the appropriate disbursement in respect of pension of such and such and such within 2 weeks. The aforesaid disbursement fund need to be made by the official liquidator within 72 hours from the date of this order.
Then
now, Milad, this 72 hours Milad clock was passed in this CA. This
court has stated disbursal of fund is to be made by the officer in 72 hours. So where is the stay?
This interim order has passed in this CA.
That's why this CA, that CA.
Yes.
As per this order, the official liquidator is liable to
Can you let
release the fund
any internal pass be vacated? As the dismissal of this.
Without understanding whether
Yes.
there is an existing interim order or not, court will pass an
This
order.
application, if any interim order passed, stands to be vacated because the
controversy you are making, sir.
Because it's being dismissed.
Let them come up with an application saying that this was
Show me the order, I will naturally I will pass.
allow me to say this, my lord.
This
If
order-
today an application is dismissed, suppose, my lord, an application is dismissed, does any interim order continue?
Nothing.
No.
Do we need to
The OL
specifically mention that?
OL has to disburse
By
the
operation
fund.
of law, it
Application.
stands dismissed. If there is any.
OL is not disbursing fund to me.
So have you filed a contempt application against this order, third May order?
We have CA 157 due to pendency of this order. Pendency of this application.
Pendency. That's why show in the subsequent to the 3rd May 2023, there is an order of status quo and stay. Show me.
My lord, gives me a moment. My lord, pass the order. I'll just come back. I'll come back, man. Yes. তুমি তিনবার come back করছো, আমি একটু come back করি।
I came back for the so that the.
I'll just show. My lord, it was done suddenly. He has withdrawn. He could have intimated us that he will withdraw.
Hello.
If I argue, he has a problem. If I withdraw, he still has a problem.
Call the next.
I'll show.
Yes.
My lord, I appear for the petitioner, my lord. I'm just paying for a small passover, my lord.
What passover? When the passover?
My lord, actually, I'm being led by learned senior counsel, Mr. Rotnanko
Let
Banerjee.
them go out of the list.
My lord, I'll start, my lord. My lord, this is my application, my lord. Under section 463, subclause.
Only once in a week the matter has been taken. Passover, senior.
My lord, I will start. My lord, this is my application under section 463, subclause 2 of the Companies Act, my lord.
Which was the other side?
My lord, yes, my lord. My lord, we'll just show 2-3.
Register of companies. Yes.
My lord, the first document, my lord, the
What is
background.
the prayer?
My prayer is, my lord, the alleged offences, my lord, they be condemned.
Yes.
Sorry, my lord. My lord, this is, my lord, under that section. My lord, originally, my lord, will recall, my lord, 633 of, my lord, the Companies Act was there. Now, my lord, it's 463.
463.
Yes, where my lord, if, my lord, it's certain, my lord, violations of the Companies Act which have not been done, my lord, intentionally, or, my lord, they are really not so serious, my lord, the court has the power, High Court has the power, as an original court, to, my lord, excuse, my lord, the breach, my lord, or, my lord, the violation which has happened.
What breach you have committed?
My lord, I'll just show my lord.
Not given the accounts.
No. My lord, here, my lord, in the accounts, my lord, the clubbing was long-term. The first account item? CP1. My lord, like the first one was, if my lord kindly come to, my lord, page 148. Clubbing. Yes, this is the one. My lord, like for instance, my lord, the first complaint they make was long-term borrowings. I've already shown. As my lord, 11 crore 69 lakh 3607. They say you have not shown whether directors have guaranteed it or not. The directors have not guaranteed it. So, my lord, why will I show that say you have not given particulars of to? Kindly just see, my lord, at page 148. It is observed from the financial statement of the company as on 31st March 2020 that the company has shown long-term borrowings amounting to rupees 11. So we have shown 11 crore 69 under the heading non-current liabilities. Company has neither classified and subclassified the borrowing nor specified whether such borrowings have been guaranteed by the directors or others. Aggregate amount of such for each head and the period amount of default as on balance sheet in repayment of borrowings, interest in notes to the accounts as required by para Sansad, which are true and state of affairs being affected, leading to violation of section 3 under the provisions of.
Yes.
And then, my lord, the answer, my lord, will find, my lord, at page 143.
Starting 144 is
143.
Yes, my lord.
Before
Because we gave an earlier reply, my lord.
Before answer.
My lord, there are several notices which were sent by them. We have taken a point of limitation as well. 143 at 144, my lord. Reply of query number A1. The same.
Yes.
It is submitted the company as shown in the financial statements of the company as of 31st March amounting to rupees 11 crore 39 as long-term borrowings under the non-current liability note number 6. Now, so far as the contention regarding disclosure required under Schedule 3, Division 26EI is concerned, following disclosure has been provided for. 2019-22, note number 6, long-term borrowings, unsecured considered good, intercorporate borrowings, 11 crore 69 3607. Further, it submitted that no amount of the borrowings has been guaranteed by any of the directors or other persons. Furthermore, company has not made any default in the repayment of borrowings and interest payable therein. Further, the company did not have intent to hide anything, misrepresent state of affairs.
Yes, who is appearing for the ROC? What is your contention? What is your contention? They have given the reply. So what is your contention? You file reply or what? Report.
Affidavits have been filed.
Filed. So what is your contention in the affidavit? What they have taken the?
Same explain.
What is the ground? Give the
Yes.
affidavit.
Malad kindly looks at Malad the affidavit. There's nothing really, and Malad no shareholder has complained because balance sheet is Malad meant for the shareholders so that they can
That's
get.
why I want to see what is the complaint.
Yes.
The reports are 37.
It's except for Malad narration of facts, Malad, I did not really Malad find.
Reports are it's
Same thing you repeated.
Yes. Malad, if Malad it helps, Malad in page 37, they have given a chart.
It's a report.
Or a report. And it's the same thing, Malad, which is repeated, Malad, in the column, Malad, on
Yes,
the.
madam. Who is your senior? Where is he? He or she? What is the name? Shreya Chaudhary. Where is he? कोई है क्या ऑनलाइन में? नहीं है. So what is your? This is the only thing. You are not narrated anything in the violation in your reply.
Oh, judgment of the.
I think.
Okay, come on then. When will be available? Next week.
Bhagavati.
Bhagavati, no. Division. There are judgments, Malad, which says I'll bring it the next day.
On the next.
Saying, Malad, that if shareholders, because your accounts are meant for really, Malad, if the shareholder complained, then Malad, it would have been an issue. No one is misled by that.
Let me hear that.
Very
And counsel for the applicant has argued the matter. Counsel for the respondent prays for time. According case is adjourned. Let the matter appear on 10th September. 10th September.
Okay. Malad, can it be 3rd, Malad? After that.
Okay,
Malad.
3rd.
And Malad, the interim order, Malad, can be Malad extended? It's been continuing from.
Yes, it's there.
Yes, Malad, interim order. Malad was pleased to extend it till 20th August.
Interim order is extended till 10th of September 2025 or until further order.
Great. Both Malad, 10 and 11 on.
And come ready on that day. 10th September. Returnable 3. Yes, next.
11, Malad, also similar Malad issue with regard to Malad 11. There also Malad, we have an interim order which can be Malad
same
extended and Malad can be kept on the same day.
3rd and
3rd and
10 and 10.
I'm grateful.
Inform your senior. Yes, next.
12 and 13 Milord are similar matters your lordship would recall.
Similar matters?
No. Lord, the official liquidator was to file report with respect to.
Place the report, your lordship. Here, your lordship, the settlement could not be made of the claims because of the disputes. We want some documents about the legal heirs. So, lordship, in the report we have stated the succession certificate is required since it's a monetary claim. So that is the.
Lord, the only thing I prayed with your lordship on the last occasion that everything in addition, Lord, 7 except Lord that succession certificate, all other documents we have produced.
How many years? How many persons are here?
2,
Claiming?
Lord, subject to correction, Lord, 3 years.
Who are you?
Lord, I am Lord Sanjay Sureka, Your Lordship would kindly take not my application.
Give the
Your Lordship
application.
ke 13 number
You
file
see
sa
it?
deben, please. The reply application H.
Sanjay
But the
Sureka.
original member of the company was Ratanlal Sureka.
Correct.
He had a son, Rajkumar Sureka.
Correct.
Rajkumar Sureka died, Milord, leaving behind 3 heirs, Sanjay, Madhusudan, and Namrata.
Where is the
Milord, Sanjay is the applicant, and Milord, Madhusudan is also there with me. And Milord, there is no dispute coming forward from Namrata also. I have disclosed that in my affidavit, Milord, which I have affirmed before the magistrate also. I have disclosed, Milord, these are the heirs.
do one thing here, only the one petitioner is here.
Yes.
Correct. Other two are not here.
My lord.
Other two are not here. Let they also file the affidavit before this court. You are only the 3 years.
Very well. Very well.
Come with an affidavit before the oath commissioner.
My lord.
And that can be done, and it will be served.
This is the direction with that respect, Milord, we shall do that.
So you
Milord,
you
this
only
defect
3,
will be
and you are telling that a succession certificate is required.
That's a monetary claim, your lordship.
Monetary claim.
Lord,
Let
I
them file,
understand the difficulty, Milord,
let
that-
they file the affidavit before this court.
That will take care of everything.
That will take care. The applicant Sanjay Kumar Sureka has filed the present application being CA7 of 2024. Praying for. Where is the judge's summons?
আমরা শুধু দুজনের হয়ে রিপ্রেজেন্ট করেছি সঞ্জয় একা ফার্ম করেছে
Praying for a direction upon the official liquidator to distribute the surplus funds of the company lying idle in favor of all the contributories of the shareholders and allied players. The official liquidator has submitted the report after serving the copy to the learned counsel for the applicant and submits that, and wherein it reveals that it is the specific ground, it's a case made out by the special liquidator, official liquidator, that the identification and the entitlement of the applicant is to be decided only after production of the succession certificate from the competent court of law. Full stop. This court finds that the applicant is claiming that initially, who is the main?
Ratanlal Sureka.
Initially, the Ratanlal Sureka was the proprietor.
Lord, was the shareholder.
Was the shareholder. And after his death, Rajkumar Sureka,
my lord,
has inherit. Shareholder is transferred. Share is transferred. After his death, the share is transferred in the name of Rajkumar Sureka.
Share both transfer hai.
Rajkumar Sureka.
Share holding a name transfer hai.
It is there is a document.
Lord, one thing I must indicate, Lord, he had inherited, but the name in the shareholding did not change.
Transfer
That
is not
Not
being
been
Yes.
The Ratan Sureka died only leaving behind.
Ratanlal Sureka died on 6th of November 1982, leaving behind only one son, Rajkumar Sureka.
Only one son. Wife?
Only one son. Lord, wife was a predeceased. I'm told it's predeceased.
Where is the document?
These documents should come up by way of an affidavit.
No, that has
because
been
there are no-
annexed.
Where is that?
I'll just indicate. I'll indicate.
Where is that? Rajkumar is there.
Sureka is there.
Rajkumar is there. Where is the Ratan Sureka death certificate and his
Ratanlal
wife
Sureka
and
death
legal?
certificate ache? Lord, Ratanlal Sureka's death certificate I had communicated. Ratanlal Sureka?
Ratan.
Lord, that also I have. That has been also supplied. Krishna Devi Sureka, she died, my lord, on 5th of May 1988.
Shareholder.
Here is the document.
Shareholder. After and Ratanlal Sureka died, leaving behind his son Rajkumar Sureka, and the wife of Ratanlal Sureka was predeceased to the Ratanlal Sureka. Full stop. It is further case of the applicant that the Rajkumar Sureka died, leaving behind 3 sons, namely
Two sons, one daughter.
namely Sanjay Kumar Sureka and
Sanjay Kumar Sureka, Madhusudan Sureka, and Namrata Sureka.
And one daughter, Namrata Sureka.
Bina Rani Surekha also predeceased him.
Namrata Sureka and
The names which are coming up on the earlier occasion, my lord, I find in the report in the order dated 6th August 2025, the observation of my lord was that the applicant is a legal and the contributor named Rajkumar Sureka and Bina Rani Sureka. These two names transpire.
Huh.
And today some more names are
What is
These
the
are
name?
the part of the application.
What is the name of the Rajkumar Sureka wife?
Bina Rani
Bina Rani
Surekha, the death
Sureka.
certificate is here.
Okay. And the wife and one daughter Namrata Sureka.
Bina Rani Surekha.
One daughter Namrata Sureka. Namrata Sureka. The wife of Rajkumar Sureka, namely Bina Rani Sureka, was predeceased to Rajkumar Sureka. Full stop. This court find that though the applicant has filed the present application for the direction upon the officer liquidator for distribution of the shares in favor of all the legal heirs of Virat Kumar Sureka, but all the documents and all the legal heirs have not come forward before this court except Sanjay Kumar Sureka. In view of the above, the applicant Sanjay Kumar Sureka is directed to file a supplementary affidavit disclosing the death of Ratanlal Sureka, his wife, and his legal heirs, the death of Rajkumar Sureka, his wife, and all the other legal heirs of Rajkumar Sureka. That is the beta log hai na. That is, what are the names other than Sanjay Kumar Sureka?
Madhusudan and Namrata.
And the daughter Namrata Sureka shall also file an affidavit stating the details of the legal heirs of Ratanlal Sureka, including the documents on affidavit by the next date fixed.
file an acceptance.
I will give. Let they file first, then I will give. Let the said affidavit be filed within 2 weeks. List the matter on 10th of September 2020.
Oh.
Yes, next.
Okay, Lord, I appear on behalf of the applicant.
Answer.
Lord, my application, Lord, seeking Lord implementation.
Your Lordship, I am appearing for the state of Bihar. My learned senior, Mr. Umesh Prasad Singh.
Item number?
Item 14.
14.
Yes.
Your Lordship will pardon me, Lord. I am from Patna. This is, Lord, they say we filed a rejoinder because about 177 pages documents first time disclosed with the reply to my affidavit in the position. And new facts have been brought. When we challenge the authority of the applicant to file an application instead of official liquidator, then he had brought that he had been given power of attorney in 2015. Although the main proceeding, my lord, the company petition, but he struck off in 2014 itself. So I permit your lordship to seek leave to file this rejoinder.
Your Lordship, this is a rejoinder that is to file.
Lord, it's a
No,
third
you filed an application.
Lord, I filed the application. My learned senior friends filed an affidavit in opposition. Thereafter, my lord, in order to controvert the statements made therein, my lord, in inter alia, my lord, one of the allegations was that the liquidator who had appointed the power of attorney holder, my lord, liquidator has passed away. So I brought those documents on record, my lord, medical records, and my lord, in order to other, my lord, disputes which my learned friend has raised, my lord, in order to controvert that, my lord, sir rejoinder being filed, and my lord, right now, my lord, Lord, it's a very simple application, Lord. I started, Lord, on the last
Have you
occasion.
received the copy?
Lord, I've just received it right now.
Are you fixing next date?
My Lord, as your Lordship pleases, Lord.
Your Lordship, I was praying second week of September because the learned senior will be appearing and he wants to.
The respondent slash state of Bihar has filed sir rejoinder.
My lord.
Sir rejoinder, as you are, sir rejoinder. After serving the copy to the learned counsel for the applicant, let the same be kept with the record. List the matter on 10th of September for hearing of CA 13.
Lord, 10th September, only one prayer before my Lord. My Lord, we will see. My Lord, I am only seeking. My Lord, Lordship may not enter into the merits at all. I am only seeking, my Lord, implementation of an order passed by this honorable court, wherein, my Lord, directions were given to the state of Bihar to, my Lord, allow mutation of certain plots of land which are admittedly, my lord, in my name. My lord, that is the only, my lord, inquiry which is required. My lord. Possibly the merits will not have to be gone. Grateful.
Thank you. Next. Whatever.
This is at page 617 of the compilation, volume 5. এই ট্যাবটা দেখি না ভলিউম 5 টা দিন Millet can have a look, Millet. 617.
Yes.
Kindly see the last paragraph. Last penultimate line. 72 hours.
This appeal for hearing on 2017, the official requested proposal to disburse any further sum of will give 22 hours notice to the applicant. Yeah, that
is the interim order.
Correct.
Now, Millet, the well had disbursed money without giving 72 hours notice. Millet, on 24th April 2023, this order was passed when direction was passed to refund the entire money in this application. That has been made bold at the top.
Correct.
Kindly see, Millet, I don't have a... This is Kaput's order.
Yes.
We had returned the entire money of 1 crore and odd by virtue of this order, of this interim order of 72 hours. So that has to be vacated, that clock of 72 hours passed in this application.
No, subsequently, the 3rd May, there is an order.
Yes, then we returned the money. Kindly see 3rd May order. Everybody was disbursed with the money 7 except Otonu. Kindly see the list.
Correct. Then
so the money has now to come has to come to me. That's why the interim order pending in this application.
Subsequently, kindly come to the order dated 3rd May.
Yes. Kindly see the list.
3rd May.
Yes.
3rd May.
Yes.
The officer will director give the full particulars of the applicant for the proportional disbursement of made.
Yes. Kindly see the list. See the names. Otonu's name is not there.
Correct.
So Millet, the money now Millet, I refunded the money on Millet 25th April 2023. By draft 1 crore 33 lakhs. By in view of this interim order of that was not followed, court punished me. That 6th April order you have not followed. 72 hours notice was not given. Similar, now this interim order has to go in view of dismissal of this CA 157.
Let me see.
Yes, kindly see.
This appeal that we send it to hours notice to the applicant
Yes.
to enable him to take appropriate.
Now redo it, Millet 24th April order. Passed in this application.
Whether the amount has been disbursed or not.
No, disbursed to all of them.
Amount is lying with the official liquidator in view of the order of the Honorable Court.
No, but
order?
Yes, I'm asking which order. By which order?
Other amounts was disbursed to
7 except me.
7 except Otonu.
By which order?
This order. This order, because list has been given to whom it has to be disbursed. My name was not there as a punishment. That I have not followed 6th April order. I mean, this application has gone. This clock has to go.
2 matters is directed to appear on 27th August. I shall not brought those 2 briefs, because this is only one matter. So, if it is taken up, 27th, I shall submit the.
No, this is the apparent from the order. Yes. It's 27th.
Where is Mr. Bose?
Because as a punishment, Justice Kapoor had restrained me from receiving the money. Everybody has received.
Correct.
I had returned the money that later is there at my lord's hand. 1 crore 33 lakhs.
That is the only money lying with the official
yes. Now that has to be released.
Now, what are the other 2? What are the other 2 applications?
They're disposed of CA 25.
What are the 27, CA 27 and
that is debenture.
That is debenture.
And Mitolal Bose Street.
That application is
to do with this.
Which on 27th, was pleased to direct those 2 matters to appear.
Okay,
so
let the matter come on 20,
yes, let it appear on that day also.
तो जितना उसको दिया है ना, उनको बोलो ऑर्डर बना दो, रखो, ममता, हाँ, 27 में हम करें, हाँ, let the matter, because Mr. Bose is not there, then he will say something. let the matter appear on 27.
No, he will have the advantage then, milord.
27th of August 2025, only to ascertain whether there is any interim order passed in the matter.
Is there was an interim on 6th April?
That's why he is not here to ascertain whether.
I told him to wait, milord. He has left, milord. What can be done, milord? These things are being done regularly nowadays.
Yes. Yes, next.
But 15th, my lord, time is losses kind of cheap.
Well, before your lordship rises, my lord, may I have my lords kindly leave to mention item number 67. This is that content matter regarding the Thiruvalur and that man. My lord, the concerned person has come to Calcutta with a demand draft. My lord, could it appear as to be mentioned tomorrow?
With the demand draft, you take the demand draft.
Yes, but demand draft of somebody else. So if I take it, then they may lodge a claim that money lent and advanced. Give me back. So with court's order to be mentioned tomorrow, my lord, I shall not trouble more than 2-3 minutes of it. Item 67, my lord.
Lordship, may I make a mention for item 24, OCD list commercial. Lordship, we were informed through mail that at 4:15 it will be mentioned. I think.
What is your mentioning? Tell me. You don't think. You only say.
Lordship, we received the email that 4:15 the plaintiff will mention this matter.
Which matter?
Item 24, OCD list.
24. Nobody has mentioned. Skipper India.
Skipper.
Nobody's mentioned. Yes.
Your Lordship, item number 29, Your Lordship, is execution matter, Your Lordship. Last time the direction was there to file the affidavit of asset, Your Lordship. We are just 1 day's delay. We have affirmed this affidavit of asset today, Your Lordship.
Okay, come tomorrow.
Your Lordship, only one thing. The client is coming from Dhanbad, Your Lordship. It's a out station client, Your
If
Lordship.
your client is come, you mention the matter, I will take the matter first.
Your Lordship, he's present here, Your Lordship.
Because today my call court officer is my company.
If it can be fixed tomorrow at particular
That's why
time, Your Lordship.
Come tomorrow, you mention the first hour.
Your Lordship.
At the time mentioning, I will take the matter.
Yes.
No
My
problem.
lord, praying
I'm
for
obliged.
extension of interim order, my lord. The interim order is going to expire.
Which matter?
My lord, this is item number 64 appearing in your lordship's days list.
ए मनोतोष उनका ना नंबर लेके टू बी मेंशन में तो पर्सनल अपीयरेंस या तो ऊपर करो पर्सनल अपीयरेंस करके ऊपर करो.
My lord, this is a commercial matter, my lord.
Which matter? Which serial number?
My lord, item number 64, my lord, of your lordship's days list. The appearing as new motion commercial matter.
64.
Lordship, your lordship was pleased to pass an order of injunction.
Extended till 21st of yesterday. Till tomorrow.
It is still tomorrow, my lord. I am asking for extension.
Tomorrow, where is the other side?
My lord, I do not find that.
Come tomorrow. It is still tomorrow. Tomorrow. Today I will extend. The other side will object for that. Come tomorrow. I will extend. No problem. Yes.
To mention item number 69. Lordship, I'm praying for accreditation because I am for one of the secured creditors. Now the liquidator is distributing funds to the other creditors. He has the minutes as approved by the secured creditors.
Item number
69 of today's list. Lordship, it was appearing in the top 10 matters for the last 2 weeks. It could not be taken up. Today, my lord, it's item number 69. I had mentioned this previously. After that, it was updated. Thereafter, my lord, last week also it was appearing as item number 11 or 12.
ठीक है इसको ऊपर कर दो ऊपर 10 में कर देना टॉप 10 में कर देना.
May I prefer one indulgence? Meet it's almost done. Meet appear to be mentioned. Should we wait for one more week? Like 27 mileage.
Mention, but they will not be available.
No, Mr. Bose is coming and told me like he's left the library. He is on his way. So me like because unnecessarily we have to wait. Me like
under which heading? My tomorrow is the to be mentioned of which?
This is almost done. The clients are also anxious. They have also seen virtually that order has been passed.
Okay. You do one thing. You should notice fix on Fridays to be mentioned.
Friday to me.
और वाला है ना वो जो जिसमें ऑर्डर है ना ये वाला यही रखना वो उस दिन ऑर्डर करते हैं वो जो ऑर्डर किया उसको रहने दीजिए.
Friday to be mentioned.
Friday to be.
I'll inform them.